Chapter 1 Introduction. Whether the Bill of Rights applies to the states by virtue of the 14th Amendment presents a momentous question. For if it does not, many modern decisions of the Supreme Court example respecting First Amendment freedom of speech. Fourth Amendment search and seizure. Fifth Amendment criminal procedure, issues the founders left to the states are without constitutional warrant. Point 1 It is difficult to imagine a more consequential subject than this one, said William Van Alstyne, and it is astonishing that the answer should be thought doubtful at this late date. More than a century after the ratification of the 14th Amendment. 2. That the Bill of Rights has no application to the states appears on the face of the First Amendment. Congress shall make no law and is confirmed by the legislative history. Point 3 In proposing the First Amendment, James Madison, Gerald Lynch, Book Review, 63 Cornell L. Rev. 1091, 1094, 1978, Michael Curtis, The Bill of Rights as a Limitation on State Authority, a reply to Professor Berger, 16, Wake Forest L. Rev. 45, 46, 1980. 2. William Van Alstyne, Forward in Michael Curtis, No State Shall Abridge the 14th Amendment and the Bill of Rights 9, 1986. 3. The primary purpose of the First Amendment was to reserve to the states an exclusive authority, as far as legislation was concerned, in the field of speech and press. Leonard Levy, Judgments, Essays on American Constitutional History 136, 1972. Urged its extension to the states because the state governments are as liable to attack these invaluable privileges as the general government is, and therefore ought to be cautiously guarded against. 4. But the view that finally prevailed was that of Thomas Tucker, it will be much better, IAP. Prehend, to leave the state governments to themselves. 5. Egbert Benson explained that the Committee of 11, to whom the amendments had been referred, meant to provide against their being infringed by the federal government. 6. Such was Thomas Jefferson's understanding. With respect to freedom of the press, he wrote to Abigail Adams on September N. 1804, that the power is fully possessed by the several state legislatures. It was reserved to them, and was denied to the general government. While we deny that Congress have a right to control the freedom of the press, we have ever asserted the right of the states, and their exclusive right to do so. Point 7 In short, the prohibition on Congress was motivated by a solicitude for states' rights and the federal principle. 8. Hence, Chief Justice John Marshall held in Barron v. Baltimore, 1833, that the Bill of Rights had no application to the states, saying, had Congress engaged in the extraordinary occupation of improving the constitutions of the several states by affording the 4-1 Annals of Congress 441, Gales and Seaton, 1834, print bearing running head History of Congress. 5 ID. 7555 ID. 732 7 Felix Frankfurter, John Marshall and the Judicial Function, 69 Harv. L. Rev. 217, 226, 1955. 8 Levy, Super Note 3 at 136. Referring to the declarations of rights proposed by the state ratification conventions, Madison wrote, all of them indicated a jealousy of federal powers, and an anxiety to multiply securities against a constructive enlargement of them. 4 Letters and Other Writings of James Madison, 121, 129, 1865. People additional protection for the exercise of power by their own governments in matters which concern themselves alone, they would have declared this purpose in plain and intelligible language. Point 9 Thereby he recognized the jealous regard of the states for their sovereignty in local affairs. Point 10 For 135 years, Justices Harlan and Stewart reminded the court, every member had agreed that the founders exempted the states from the Bill of Rights. Point 11 This, Lewis Hankin observed, was the consistent, often reaffirmed, and almost unanimous jurisprudence of the court. 12 It fell to Justice Black, dissenting in Adamson v. California, 1947, to discover in the legislative history of the 14th Amendment an intention to incorporate the Bill of Rights therein. Point 13 40 years have passed since Adamson, and the court's response is worth recounting. Addressing the Privileges or Immunities Clause, it approved of the slaughterhouse cases which, according to Justice Field, had reduced the clause to a vain and idle enactment. 14 And stated, it accords with the constitutional doctrine of federalism by leaving to the states the responsibility of dealing with the privileges. 932 U.S. 7 Pet. 243, 250, 1833. Curtis recognizes that the decision in Barron was a vindication of states' rights. Curtis, Book 23. Duncan v. Louisiana, 391 U.S. 145, 173, 1968. 12 Lewis Hankin, Selective Incorporation in the 14th Amendment, 73 Yale L.J. 74, 76, 1963. 332 U.S. 46, 80 to 90, 1947. The argument had been pressed upon the court in Maxwell v. Dow, 176 U.S. 581, 587, 1899. It is now urged in substance that all the provisions contained in the first 10 amendments, so far as they secure and recognize the fundamental rights of the individual as against the exercise of federal power, are by virtue of this amendment to be regarded as privileges or immunities of a citizen of the United States. The argument failed. 14 Slaughterhouse Cases, 83 U.S. 16 Wall. 36, 96, 1872, dissenting. And immunities of their citizens except those inherent in national citizenship. Point 15. Charles Fairman, a most fastidious and careful scholar, sifted the legislative history of the 14th Amendment in 1949 and published a 139-page refutation of Black's history. 16. Alexander Bickel, the outstanding constitutional scholar of his generation, subsequently studied the legislative history and considered that Fairman's article was conclusive. 17. And in 1959, Justice Frankfurter stated on behalf of the court, "We have held from the beginning and uniformly that the Due Process Clause of the 14th Amendment does not apply to the states any of the provisions of the first 10 amendments as such. The relevant historical materials demonstrate conclusively that Congress and the members of the legislatures of the ratifying states did not contemplate that the 14th Amendment was a shorthand incorporation of the first 8 amended." 53. Charles Fairman, does the 14th Amendment incorporate the Bill of Rights? 2 Stan. L. Rev. 5, 1949. Leonard Levy, who lauds Curtis, in for Chapter 5 text accompanying Note 4, wrote, "Black did not merely misread history, nor wishfully attribute to it a factual content it did not possess, he mangled and manipulated it by artfully selecting facts from one side only, by generalizing from grossly inadequate proof, by ignoring confusion and even contradictions in the minds of his key protagonists, and by assuming that silence on the part of their opponents signified acquiescence." Levy, Super Note 3 at 68. My own study of the records in 1977 convinced me that the historical evidence confirmed Fairman. Berger, Government by Judiciary, The Transformation of the 14th Amendment 134-156, 1977. The most recent critic of those views acknowledges that Berger's work is representative of a broadly held scholarly view. Curtis, Book 113. 17. Alexander Bickel, The Least Dangerous Branch 102, 1962. Ments making them applicable as explicit restrictions upon the states. 18. Selective incorporation. Although the court rejected Justice Black's wholesale incorporation, it achieved the result through the doctrine of selective incorporation. It did not root it in the original intention of the framers, however, but conjured it out of the principal carrot of justice. 19. Because selective incorporation purportedly derives from the Due Process Clause, it bears emphasis that, on the eve of the convention, Alexander Hamilton stated that those words have a precise technical import, and are only applicable to the process and proceedings of courts of justice, they can never be referred to an act of the legislature. 20. My own study of 400 years of history epitomized by Hamilton confirmed his summary. 21. But for a few aberrant cases, among them Dred Scott, the meaning of the Fifth Amendment's Due Process Clause, wrote Charles Curtis, 18. Bartkus v. Illinois, 359 U.S. M. 124, 1959. 19. Palco v. Connecticut, 302 U.S. 319, 325, 1925. Gressman points out that the framers intended to incorporate those basic rights not into the Due Process Clause but into the Privileges and Immunities Clause. By castrating the Privileges and Immunities Clause, the Supreme Court has forcibly shifted the debate into the unintended forum of the Due Process Clause, searching for something that the framers never really intended. Gressman, Book Review, 1 New Law Books Reviewer 57, 5960, 1986. Thus, like Curtis, Gressman would resuscitate the Privileges or Immunities Clause from the paralyzing blow delivered by the slaughterhouse cases. 24. The Papers of Alexander Hamilton. 35, H. Syrett and J. Cook, eds. 1962, 21. Raoul Berger, Law of the Land Reconsidered, 74 NW. UL. Revelation I 979. An admirer of the court's transformation of the words, was as fixed and definite as the common law could make a phrase. It meant a procedural process. 22. In the 14th Amendment, the court stated, the words were used in the same sense and with no greater extent. 23. As the legislative history confirms. When asked what the words due process meant, John Bingham, draftsman of the 14th Amendment, shortly replied, the courts have settled that long ago, and the gentlemen can go and read their decisions. 24. Indicating that he thought the question frivolous. Speaking to the Bingham Amendment, James Wilson, chairman of the House Judiciary Committee, indicate that the Due Process Clause furnished a remedy to secure the fundamental rights enumerated in the Civil Rights Act. 25. Judge William Lawrence, a member of the 39th Congress, quoted the Hamilton procedural definition in 1871, 26. And in the same year another framer, James Garfield, said that due process of law meant an I'm. 22c. Curtis, Review and Majority Rule in Supreme Court and Supreme Law 170, 177, Edmund Cann, ed. 1954, in a classic study, Charles G. Haynes wrote that due process of law referred in England to a method of procedure in criminal trials. C. Haynes, The American Doctrine of Judicial Supremacy 410, 1959. 23. Hurtado v. California, no U.S. 516, 535, 1894. 24. Avens 157. Dean James Bond found that during the ratification campaign Republicans represented that the Due Process Clause guaranteed only procedural fairness. J. Bond, The original understanding of the 14th Amendment in Illinois, Ohio, and Pennsylvania, 18 Akron L. Rev. 435, 443, 1985. 25 Avens 189. 26 ID. 479 of such data Curtis takes little account, but cites instead Sumner's view that the Due Process Clause, brief as it is in itself alone a whole Bill of Rights. Curtis, Book 130. It is such unorthodox views that deprived Sumner of credibility in the Senate. See Raoul Berger, The 14th Amendment, Life from the 15th, 74 NW. UL. Revelation 3N, 327, 328-29, 1979. Partial trial according to the law of the land. 2017 John Hart Ely found no references in the legislative history that gave the Due Process Clause of the 14th Amendment more than a procedural connotation. 28 As I likewise found. In a searching study of selective incorporation, Lewis Hankin concluded that it finds no support in the language of the amendment, or in the history of its adoption, and that it is truly more difficult to justify than Justice Black's position that the Bill of Rights was wholly incorporated. 29 Thereafter, Judge Henry Friendly regarded it as impute that selective incorporation has no historical support, observing that the present justices feel that if their predecessors could arrange for the absorption of some such provision in the Due Process Clause, they ought to possess similar absorptive capacity toward other provisions equally important in their eyes. 30 The way we arrived at incorporation, Paul Bader wrote, was intellectually shoddy. It was just announced as though it was a coup d'etat. Suddenly we had incorporation. 31 It will profit us to examine the derivation of the doctrine more closely. Before liberty of contract derived from the liberty of the Due Process Clause was abandoned, the 27 Cong. Globe, 42c. Cong, First Sess. 153, 1871, Avens 529. Lysander Spooner and Joel Tiffany, two leading abolitionist theorists, refused to rely on due process or thought of it almost entirely as a formal requirement. Jacobus 10 Broke, Equal Under Law 121, 1965. 28 J. H. Ely, Constitutional Interpretivism, Its Allure and Impossibility, 53 IND. LJ. 399, 416, 1978. 29 Lewis Hankin, Selective Incorporation in the 14th Amendment, 73 Yale LJ. 74, 77, 1963. There is no evidence, and it is difficult to conceive, that anyone thought or intended that the amendment would impose on the states a selective incorporation. ID. 77-78 30H. Friendly, The Bill of Rights as a Code of Criminal Procedure, 53 California. L. Rev. 929, 935, 1965. 31 Paul Bader, Some Thoughts on Applied Federalism, 6 Harv. J. of Law and Pub. Policy 51, 58, 1982. C. Levy, Infratext accompanying Note 34. Justices timidly extended the concept to freedom of speech. As late as 1922, the court had held that the Constitution imposes upon the states no obligation to confer upon those within their jurisdiction the right of free speech. 32 3 years later, in Gitlow v. New York, the court has assumed that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the states. 33 Commenting on the shift, Leonard Levy observed, judicial behavior is sometimes inexplicable. Thus casually and without reasoned judgment, and despite precedents to the contrary, the court began a process of incorporating selected provisions of the Bill of Rights into the Due Process Clause. 34 Justice Holmes furnished the clue in his dissenting Gitlow opinion, free speech must be taken to be included in the 14th Amendments in view of the scope that has been given to the word liberty as their use. 35 But this was precarious footing. Charles Warren tellingly pointed out that the free speech of the First Amendment could not have been comprehended in the due process of the Fifth, because having already provided in the First Amendment an absolute prohibition on Congress to take away certain rights, it is hardly conceivable that the framers would, in 32 Prudential Ins. Co. V. Cheek, 259 U.S. 530, 538, 1922. 33 268 U.S. 652, 666, 1925, emphasis added. 34 Levy, Super Note 3 at 73. C. Bader, Super Text accompanying Note 31. 35 268 U.S. at 672, emphasis added. Holmes was against extending the 14th Amendment, Brandeis reported. But that meant, Brandeis said, that you are going to cut down freedom through striking down regulation of property, but not give protection to freedom in other contexts. Alexander Bickel, The Supreme Court and the Idea of Progress 27, 1978, brackets in the original. The fifth, provide that Congress might take away the same rights by due process of law. 36 When the First Amendment was proposed, Madison urged that it was equally necessary that free speech be secured against the state governments, but his plea was fruitless. 3 Jefferson, the great champion of free speech and free press, wrote in 1804 to Abigail Adams, "While we deny that Congress have a right to control the freedom of the press, we have ever asserted the right of the states, and their exclusive right to do so." 38. This was the premise on which the first Congress had acted in drafting the Bill of Rights. 1. May agree with Justice Benjamin Cardozo that free speech is the matrix, the indispensable condition, of nearly every other freedom. 39. But the fact remains that the one time the American people had an opportunity to express themselves on the issue in the first Congress, they rejected the application of the First Amendment to the states. Charles Warren had prophesied in 1926 that by enlarging the 14th Amendment to protect free speech, the court had opened the door to adoption of the rest of the Bill of Rights. 40. Faced with mounting pressure to do so, Justice Cardozo, in Palco v. Connecticut 41 fashioned a confining doctrine ordered liberty, some immunities. 42. 36. Charles Warren, the new liberty won under the 14th Amendment. 38. Harv. L. Rev. 431, 441, 1925, emphasis in the original. 37. 1 Annals of Congress 435, 755, 1st Cong, 1st Session, Gales and Seaton 1834, print bearing running head History of Congress. Supertext accompanying notes 4-6. 38. Quoted in Felix Frankfurter, John Marshall and the Judicial Function, 69. Harv. L. Rev. 217, 226, 1955. 39. Palco v. Connecticut, 302 U.S. 319, 327, 1937, 40. Warren, Super Note 36 at 458-60. 41. 302 U.S. 319, I-937. 42. Justice Cardozo confusingly referred to the privileges and immunities that have been taken from earlier articles of the Federal Bill of that are valid as against the federal government by force of the specific pledges of particular amendments have been found to be implicit in the concept of ordered liberty, and thus, through the 14th Amendment, become valid as against the states. Such portions of the Bill of Rights as had been absorbed in the amendment, he continued, rested on the belief that neither liberty nor justice would exist if they were sacrificed. Absorption proceeded from those principles of justice so rooted in the tradition and conscience of our people as to be ranked as fundamental. 43. Plainly this was judicial rewriting of the Constitution in the teeth of the Founders' rejection of application of the Bill of Rights to the states. And it finds no warrant in the history of the 14th Amendment, which associated fundamental rights with the limited category set out in the Civil Rights Act. Insofar as selective incorporation derives from the Due Process Clause, the argument runs into the evidence found by Dean James Bond in his study of the ratification debates rights and brought within the 14th Amendment by a process of absorption. 302 U.S. at 326-327. Privileges and immunities are located in Article 4, 2, not in the Bill of Rights. Cardozo's mistaken reference led Curtis to conclude, prior to the adoption of the 14th Amendment, these privileges and immunities had been held to limit the power of the federal government only and not the states. So one could reasonably conclude from the plain language of the amendment that it was intended to extend the protection of the Bill of Rights against the states. Curtis. Reply 48, emphasis added. Article 4, 2, however, entitles a migrant from one state to the privileges and immunities of a citizen in another state, infra Chapter 7 text accompanying notes 12-20, and it has no application to the federal government. Nor can one obviously derive from the amendment's privileges or immunities of a citizen of the United States an intention to extend the Bill of Rights against the states. This exhibits both Curtis' misunderstanding of historical fact and his tendency to mistake assertion for proof. 43. 302 U.S. at 325. That those who debated I of the 14th Amendment paid scant attention to the Due Process Clause. 44. The Republicans, he found, represented that the Due Process Clause guaranteed only procedural fairness. 45. Rarely was its meaning elaborated. Any elaboration compared it to the Due Process Clause of the Fifth Amendment, and as Bond ob. serves, a phrase said to mean only what it meant in the Fifth Amendment could scarcely have been intended as a shorthand expression of every other right included in the Bill of Rights. 46. He concluded that no one in these states, Illinois, Ohio, and Pennsylvania, believed that the Due Process Clause protected any substantive rights, much less all those rights enumerated in the Bill of Rights. No one even hinted that the Due Process Clause incorporated any, much less all, of the Bill of Rights guarantees. 47. Ordered liberty, wrote Louis Lusky, who is a friend to broad judicial power, is a vehicle for whatever meaning the court gives it, and thus enables the court to apply its own conceptions of public policy. 48. Louis Hankin observed, it 44. James E. Bond, the original understanding of the 14th Amendment in Illinois, Ohio, and Pennsylvania, 18 Akron L. Rev. 435, 461, 1985. 45. ID. 443. The usual meaning at that time was unquestionably procedural, the procedural rights of the accused in court, as well as the right to own property, to contract, to appear as witnesses, were what they principally had in mind. Joseph James, The Framing of the 14th Amendment 198, 1965. 46. Bond 457-58, see also Justice Frankfurter, infra Chapter 7 text accompanying note 5. 47. Bond 464. 48. L. Lusky, by what right? 105, 1975. He comments, It is too vague to describe a national objective. It says that order and liberty are both to be sought, but provides no standard for reconciling the eternal conflict between them. ID 107 Levy noted Frankfurter's view that selective incorporation provides no formula other than a merely subjective test for determining which rights were in and which were out. Levy, Supernote 3 at 65. Is hardly possible to see in the Due Process Clause some purpose to select some specifics of the Bill of Rights and not the whole. Ordered liberty, he justly considers, is an uncertain, debatable, changeable touchstone, and it therefore lends itself to unlimited judicial manipulation. Point 49 of Cardozo's Touchstone, The Conscience of Mankind, Henkin. Remarks, there is no relation historical, linguistic, or logical between that standard and the specific provisions, or any specific provision, of the Bill of Rights. It reduces to how the court reads that conscience, 50 a most unreliable guide. Several justices have shared such views. In a book written by Justice Owen Roberts after his retirement, he stated in a passage quoted by Justice William Douglas, that the cases will fall on one side of the line or the other as a majority of 9 justices appraise conduct as either implicit in the concept of ordered liberty or as lying without the confines of that vague concept. 51 Justice Byron White likewise re 49L. Henkin, Selective Incorporation in the 14th Amendment, 73 Yale LJ. 78, 79, 1963. Curtis urges that after brooding over the matter, Professor Fairman slowly concluded, however, that implicit in the concept of ordered liberty was about as close as one could come to the vague aspirations that the framers had for die privileges or immunities clause. Curtis, Book 6. Like Curtis, who now diverges from Kroski in some significant ways, ID 8, I too may be permitted to differ with Fairman in this particular. To my mind the framers were quite clear as to the contents of the privileges or immunities clause. To them the clause did not represent vague aspirations. Nor can the framers, deeply committed to states' rights, be charged with encroaching on the state sovereignty secured by the 10th Amendment under cover of vague aspirations. 50 ID 78, 75. Curtis considers that Palco reached the right result for the wrong reason. Curtis, Reply 49. He pins his faith to the legislative history. 51-0. Roberts, The Court, and the Constitution 80, 1951, quoted in Poe v. Ullman, 367 U.S. 518-19, 1961, Douglas, J., dissenting. Of course, Roberts added, in this view, the Due Process Clause of the Fifth Amendment guard the concept as no more than a means whereby a majority of the court can impose its own philosophical predilections upon states' legislatures or Congress. 52 and Justice Black maintained that the concept merely embodied natural law due process notion s by which this court frees itself from the limits of a written constitution. 53 Cardozo's reliance on the traditions and conscience of our people is refuted by the refusal of the first Congress to apply the Bill of Rights to the states. That, to borrow from learned hand, was the last formal expression of the people's will. Point 54 No departure from that expression can be found in the history of the 14th Amendment. Instead, but for the narrow enclave of the Civil Rights Act, the framers clearly withheld from the court power to intrude into state regulation of domestic affairs. It needs constantly to be borne in mind that, as Judge Richard Posner reminds us, apply the Bill of Rights to the ment may be repetitious of many of the other guarantees of the first 8 amendments and may render many of their provisions superfluous, a result that argues against the absorption doctrine. Such concede errata ions are brushed aside by Leonard Levy. The framers of the Bill of Rights were in many respects careless, even haphazard, draftsmen. They enumerated particular rights associated with due process and then added the Due Process Clause itself, probably as a rhetorical flourish, a reinforced guarantee, and a genuflection toward traditional usage. Levy, Supernote 3 at 66. Chief Justice Taney, however, stated, every word appears to have been weighed with the utmost deliberation, and its force and effect to have been fully understood. Holmes v. Jennison, 39 U.S. 14 Pet. 540, 571, 1840. For examples of the framers' fastidious care in selecting words, see Raoul Berger, Federalism, The Founders' Design 92-93, 1987. Many framers and ratifiers sat in die First Congress and profited from resolutions of the several states which accompanied the several ratifications. 52 dissenting in Robinson v. California, 370 U.S. 660, 689, 1962. Dissenting in Winship, 397 U.S. 358, 381-82, 1970. Learned Hand, The Spirit of Liberty 14, 1952. The judge has no right to divination, of public opinion which runs counter to its last formal expression. States through the Due Process Clause and you weaken the states tremendously by handing over control of large areas of public policy to federal judges. It is hard to believe that this was intended by all the state legislators whose votes were necessary to ratify the 14th Amendment. 55 In a broader context, Horace Flack, a pioneer student of the 14th Amendment, wrote that the radical proposals were designed to increase the powers of the federal government very much, but to do it in such a way that the people would not understand the great change intended to be wrought in the fundamental law of the land. He observed that had the people been informed of what was intended by the amendment as envisaged by the radicals, they would have rejected it. 56. They could not ratify what had not been disclosed. Justice Samuel Miller, a contemporary of the 14th Amendment and a keen observer of the political scene, declared shortly after adoption of the 14th and 15th Amendments, "We do not see in those amendments any purpose to destroy the main features of the general system. Under the pressure of all the excited feeling growing out of the war, our statesmen have still believed that the existence of the states with power for domestic and local government was essential to the working of our complex system of government. And he rejected a construction that would subject states to the control of Congress, in the exercise of powers heretofore universally conceded to them in the absence of language which expresses such a purpose too clearly to admit of doubt." 57. Chief Justice William Rehnquist considers that 55 R. Posner, The Federal Courts, Crisis and Reform 194, 195, 1985. See also info Chapter 4 text accompanying notes 10 to 15. Horace Flack, The Adoption of the 14th Amendment 237, 1908. 57 Slaughterhouse Cases, 83 U.S. 16 Wall. 36, 82, 78, 1872. Miller was one of the great justices. 58 And Harold Hyman, a Reconstruction historian, wrote of Miller's opinion in the slaughterhouse cases that the law world of the 1870s acquiesced generally and tenaciously to slaughterhouse doctrine on federalism. 59 That view constitutes a contemporary construction that unsettled principles carries great weight. 60 Hereafter I shall show that the radical designs were defeated and that the amendment was presented to the people as having very narrow scope, applicable to the South, not the North. Let it here suffice that David Donald, a Reconstruction historian, wrote, "Disturbed by the revolutionary changes Sumner hoped to bring about in the South, Republican congressmen were horrified that he proposed to extend them to the North as well." 61 And Alexander Bickel noted that conservative Republicans who considered the Freedmen's Bill applicable only in the South an appropriate concession to offer to the radicals evidently felt quite differently about a statute which might be applied to their constituencies. 6258 W. H. Rehnquist, The Supreme Court, How It Was, How It Is 185, 1987. 59 H. Hyman, Federalism, Legal Fiction and Historical Artifact. 1987 Brigham Young Law Review 905, 922. Justice William Johnson referred in 1827 to the presumption that the contemporaries of the Constitution have claims to our deference because they had the best opportunity of informing themselves of the understanding of the framers of the Constitution, and of the sense put upon it by the people when it was adopted by them. Ogden v. Saunders, 25 U.S. 12 Wheat. 212, 290, 1827. 61 David Donald, Charles Sumner, and the Rights of Man 299, 1970. 62 A. Bickel, The Original Understanding and the Segregation Decision, 69 Harv. L. Rev. 1, 40, 1955. Chapter 2 Antecedents of the 14th Amendment. One who would understand the 14th Amendment must begin with its relation to the Civil Rights Act of 1866, which proceeded on a parallel track in the 39th Congress. 1 The framers considered that the amendment was essential either to preserve the act from repeal by a subsequent Congress or to constitutionalize it. Because of doubts concerning Congress's power to enact it. 2 On either theory, the amendment did not go beyond the act. The act was deemed to be incorporated in the amendment. Preliminarily, 2 controversies generated by the 13th Amendment need to be noted. 1. Did it authorize enactment of the Civil Rights Act which shielded specified rights from discrimination? And 2. Did it confer citizenship? First, in contrast to the Democrats, Michael Curtis asserts, Republicans relied on the 13th Amendment for power to pass the Civil Rights Act. 3 In fact, Republican opinion was divided. 4 John Bingham, among others, was convinced that Congress lacked power to pass the act, a belief that Curtis considers was probably correct. 5 At best, Curtis, Book 57. 2 For citation see Berger, Judiciary 23 Note 12. 3 Curtis, Book 81. 4 Super Note 2. 5 Curtis, Book 107, 103. United States v. Harris, 106 U.S. 629, 643, 1882, 20. There was a conflict of opinion. ****6 Harold Hyman, an activist sympathizer, acknowledged that there was a large stream of constitutionalism for the argument that the 13th Amendment diminished states' powers not one whit beyond abolition. 7 Hyman's statement is at war with Curtis' assertion that only a handful of Republicans thought Congress lacked power to pass the Civil Rights Bill. 8 Second, although the slaves had been emancipated, the Dred Scott decision cast a shadow over their citizenship. Hence, the freedmen were made citizens of the United States by the Civil Rights Bill because, Senator Lyman Trumbull explained, he wished to end the very controversy, whether the Negro was a citizen or not. 9 Late in consideration of the 14th Amendment it was proposed to make one born in the United States a citizen thereof and of the state wherein he resided. Senator Jacob Howard stated that this settles the great question of citizenship and removes all doubts as to what persons are or are not citizens of the United States. 10 So too, Justice Miller referred to Dred Scott and said, to remove this difficulty primarily, the first section was framed, that that its main purpose was rejected the notion that under a provision of the Constitution which simply abolished slavery and involuntary servitude, we should with few exceptions, invest Congress with power of the whole catalogue of crimes. 6 Supernote 2. 7 H. Hyman, A More Perfect Union 428, 1973. 8 Curtis, Book 80. Of a disagreement between Wilson and Bingham about whether Congress had power to enact the Civil Rights Bill under other constitutional provisions, Curtis remarked, to remove such doubts was one of the reasons the 14th Amendment was passed. Curtis. Book 126. 9 Globe, 39 Cong, 1st Sess. 1285, 1866. Curtis states, according to Trumbull, blacks were made citizens by the 13th Amendment. Curtis, Book 49. Kander calls for recognition that according to Trumbull the Issacharat, vast contract overt. Globe 2890. To establish the citizenship of the Negro can admit of no doubt. 11 Patently, the 13th Amendment sheds little, if any, light on the meaning of the 14th. The Civil Rights Act. The Civil Rights Act did not stop with the bestowal of citizenship but went on to specify certain rights that were to be free of discrimination, testimony that the rights did not, in the framers' view, flow automatically from the bestowal of citizenship. Point 12 Before examining the bill it needs to be stressed that the framers deemed the bill and the 14th Amendment to be identical. The grasp of the scope of the bill therefore will inform us as to the ambit of the amendment. As Fairman stated, over and over in this debate on the amendment the correspondence between Section 1 of the amendment and the Civil Rights Act is noted. The provisions of the one are treated as though they were essentially identical with those of the other. 13 Thus, George Latham stated that the Civil Rights Bill, which is now a law, covers exactly the same ground as the amendment. 14 Martin Thayer said, it is but incorporating in the Constitution the principle of the Civil Rights Bill which has lately become a law. 15 Howard J. Graham, an early advocate of an abolitionist reading of the amendment, stated that virtually every speech in the debates on the amendment Republican and Democrat alike said or agreed that the amendment was designed to embody or in 11 Slaughterhouse Cases, 83 U.S. 16 Wall. 36, 73, 1872. 12 C. Shell Berger, Infra Chapter 6 Text accompanying Note 19. 13 Fairman, 44. 14 Globe 2833. Corporate The Civil Rights Act. 16 Horace Flack, a broad constructionist of the amendment, wrote, Angeli all said that it was but an incorporation of the Civil Rights Bill. There was no controversy as to its purpose or meaning. 17 In a contemporaneous decision, Justice Bradley declared that the first section of the bill covers the same ground as the 14th Amendment. 18 The Civil Rights Act was a response to the black codes whereby the South sought to set emancipation at 0.19. Senator Henry Wilson said that the vagrant laws of Virginia were used to make slaves of men whom we have declared to be free. 20 The code set up elaborate systems of bound apprenticeship, labor restrictions, vagrancy laws, limits on property ownership and craft employment, virtually chaining a black to his habitat. 21 Trumbull tellingly to 16 H.J. Graham, Every Man's Constitution 391, Note 73, 1968. 17 H. Flack, The Adoption of the 14th Amendment 81, 1908. For similar expressions during the ratification campaign, see Infra Chapter 4 Text accompanying Notes 2022. 18 Livestock Dealers and Butchers Association v. Crescent City Livestock Landing Co., 15F. Ca. 649, 655, CCD. Law. 1870, No. 8, 408. 19 A major inspiration for the 1866 law, Alfred Kelly wrote, was the resentment and alarm that the enactment of the Black Codes had produced among the radical Republicans. A. Kelly, Cleo, and the Court, An Illicit Love Affair, 1965 S. Ct. Rev. 119, 147. The Joint Committee on Reconstruction noted the acts of cruelty, oppression, and murder, which the local authorities are at no pains to prevent or punish. Avens 94. 20 Avens 138. The Bald Declaration by Edmund Redd of South Carolina. The general interest both of the white men and of the Negroes requires that he should be kept as near to the condition of slavery as possible. Sums up the purpose of the Black Codes. Morton Keller. Affairs of State 202-4, 1977. 21 Keller, Supernote 20 at 203. For additional citations see Berger, Judiciary 2425, and see the Ordinance of Opelousas, L.A., Avens 130. Curtis observes that the codes restricted such basic rights as the freedom to move, to contract, to own property, to assemble, and to bear arms. Republicans were unwilling to tolerate such deprivations, as the passage scribes some of these black codes. That of Mississippi provides that no Negro shall own or hire lands, that he shall not sue or testify against a white man, that he must be employed by a master before the second Monday in January or he will be bound out, in other words sold into slavery. The Code of Alabama provides that if a Negro who has contracted to labor runs away he shall be punished as a vagrant. What that meant is illustrated by the Tennessee Code. The vagrant Negro may be sold to the highest bidder to pay his jail fees. 22 Senator William Stewart explained that the Civil Rights Bill was designed simply to remove the disabilities existing by laws tending to reduce the Negro to a system of peonage. It strikes at that, nothing else. That is the whole scope of the law. 23 earlier, Senator Henry Wilson had urged the framers to ensure that the freedman can go where he pleases, work when and for whom he pleases, that he can sue and be sued, that he can lease and buy and sell his own property, real and personal. 24 The one pervading purpose of the 14th Amendment, said Justice Samuel Miller, was the protection of the newly made freeman and citizen from the oppression of those who formerly exercised unlimited dominion over him. 25 That clearly had no application to the North. Section I of the bill squarely took aim at these evils, providing in pertinent part of the Civil Rights Bill would show. Curtis, Book 35. The bill made no provision for a right to assemble or bear arms, nor did any spokesman for it read these terms into the bill. 22 Avens 135. 23 ID. 204, emphasis added. 24 ID. 98 25 Slaughterhouse cases, 83 U.S. 16 Wall. 36, 71, 81, 1872. Senator Timothy Howe, a pronounced radical. 6 Charles Fairman, History of the that there shall be no discrimination in civil rights or immunities on account of race, but the inhabitants of every race shall have the same right to make and enforce contracts, to sue, be parties and give evidence, to inherit, purchase, lease, sell, hold and convey real and personal property, and to full and equal benefit of all laws and proceedings for the security of person and property, and shall be subject to like punishments, and to none other. 26 This specific enumeration reflected a sentiment expressed at the outset by Senator John Sherman, who desired to secure such rights to the freedmen, naming them, defining precisely what they should be. 27 The words civil rights and immunities had aroused concern, for Martin Thayer explained that to avoid any misapprehension as to what the fundamental rights of citizens are, they are stated in the bill. The same section goes on to define with greater particularity the civil rights and immunities which are to be protected by the bill. Hat enumeration, he added, precludes any possibility that the general words which have been used can be extended beyond the particulars which have been enumerated. 28 Despite such assurances, Bingham, draftsman of the 14th Amendment, took violent exception to the oppressive scope of the bill. Supreme Court of the United States 1297, 1971, emphasized that the South denied the plainest and most necessary rights of citizenship: the right to hold land, the right to collect their wages by the processes of law, the right to appear in the courts as suitors for every wrong done them. Globe, S. App. 219 See infra Chapter 4 Text accompanying Note 7 to 14. 26 Avens 121. 27 ID. 97, emphasis added. 28 ID. 169 Against such particularization, Bingham's reference to the Civil Rights Bill as a bill providing for enforcement of the Bill of Rights, Curtis, Book 72, carries little weight, the less because he was neither manager nor leading spokesman on behalf of the bill. The term civil rights as used in this bill does include and embrace every right that pertains to the citizen as such. If civil rights has this extent, what, then, is proposed by the provision of the first section? Simply to strike down by congressional enactment every state constitution which makes a discrimination on account of race or color in any of the civil rights of the citizen. By the Constitution of my own state, Ohio, neither the right of the elective franchise nor the franchise of office can be conferred except upon a white citizen. Now what does this bill propose? To reform the whole criminal and civil code of every state government. 29 Justice Black, for whom Bingham was an authoritative expositor, observed that Bingham objected to the Civil Rights Bill because it would actually strip the states of the power to govern, centralizing all power in the federal government. To this he was opposed. 30 Bingham's expostulation led to the deletion of civil rights and immunities. James Wilson, chairman of the House Committee on the Judiciary and manager of the bill for the House, explained that in order to remove the difficulty growing out of any other construction beyond the specific rights named in the section, our amendment strikes out all of those general terms and leaves the bill with the rights specified in the section. The deletion was made, he said, because some gentlemen were apprehensive that the words we proposed. 29 Avens 186, 188, emphasis added. The phrase "there shall be no discrimination in civil rights" must be stricken out, Bingham said, or the constitutions of the states are to be abolished. ID. At 186. Hamilton had assured the 1,787 ratifiers that there is one transcendent advantage belonging to the province of the state governments: the ordinary administration of criminal and civil justice. Federalist number 17 at 103, Mod. Lib. Ed. 1937, Adamson v. California, 332 U.S. 46, 100, 1947, dissenting opinion. To strike out might give warrant for a latitudinarian construction not intended. 31 The effect of the Bingham-Wilson incident was summarized by the Supreme Court in Georgia v. Rachel, 1966. The legislative history of the 1866 Act clearly indicates that Congress intended to protect a limited category of rights. The Senate bill did contain a general provision forbidding discrimination in civil rights or immunities preceding the specific enumeration of rights. Objections were raised in the legislative debates to the breadth of the rights of racial equality that might be encompassed by a prohibition so general. An amendment was accepted striking the phrase from the bill. 32 Coming after many Republican statements of unorthodox beliefs. 33 This incident cries out for explanation. How can the bar to a latitudinarian construction, the emphasis on the named specific rights, be reconciled with an effort to read the Bill of Rights into the bill? Why did Bingham, who so strenuously protested against an oppressive invasion of the state's domain, embrace in the lesser privileges of the amendment the very purpose he had rejected in the bill? Opposed to those earlier unorthodox beliefs is the undeniable fact that the House voted for the deletion, that the oppressive language is missing from the Act. 34 The fact is, as Alexander Bickel observed, the words no discrimination in civil rights had been deleted because Republicans who had expressed fears concerning its reach would have to go forth and stand on the platform of the 31 Avens 191, emphasis added. 32 384 U.S. 780, 791, 1966, emphasis added. 33 Infra, Chapter 7 Text accompanying notes 46 to 59, and Infra text accompanying notes 40 to 48. 34 Act of Apres 19, 1866, 14 Stat. 27. 14th Amendment. 35 They simply dared not hold out to the ratifiers that the North, which had not been guilty of the offensive practices of the South, would be deprived of control over its own civil and criminal administration. But we must not expect logical progression from Bingham. Notwithstanding his ringing condemnation of the oppressive scope of the Bill's civil rights, of its purported reform of the whole civil and criminal code of every state, he yet proposed in the very same speech to enforce the Bill of Rights against the states. 36 Unaware that he would thus in great part accomplish the very outreach that he had condemned. Earlier he had explained, after quoting from Barron v. Baltimore, that although as ruled the existing amendments are not applicable to and do not bind the states, they are nevertheless to be enforced and observed in the states by the grand utterance of that immortal man, who while he lived, stood alone in intellectual power among the living men of his country, and now that he is dead, sleeps alone in his honored tomb by the sounding sea. Daniel Webster. 37 Intoxicated by his own rhetoric, Bingham does not pause to inquire on what theory are laws that do not bind to be enforced. 38 Are we to conclude that the practiced lawyers who listened to Bingham would exalt a Webster utterance above a Marshall decision that remained the reigning law? 39 35a. Bickel, The Original Understanding and the Segregation Decision, 69 Harv. L. Rev. X, 61-62, 1955. 36 Avens 186, see Super Note 29 and Infra text accompanying Note 37. 37 Avens 158. 38 Bingham is one who used ringing rhetoric as a substitute for rational analysis. Wallace Mendelson, M.R. Justice Black's 14th Amendment, 53 Min. L. Rev. 711, 716, 1969. 39 See Infra Chapter 5 text accompanying Note 94. The lawyers on the Joint Committee substituted precise legal concepts for Bingham's impressionistic verbiage. His draft referred to the Equal Protection Clause. Putting to one side the irrelevancy of the Webster quotation, Stevens, leader of the Radicals, said the 14th Amendment was needed because the Constitution limits only the action of Congress, and is not a limitation on the states. 40 Certainly, Bingham's colleagues in the Joint Committee did not accept every word that fell from his lips as gospel. According to Benjamin Kendrick, editor of the committee's journal, Bingham stood almost alone. A great many Republicans, including the entire New York delegation, were opposed to his proposed amendment. 41 Curtis notes that despite Bingham's appeal, many were not convinced. 42 Not long after, Stevens, also a member of the committee, stated, "In all this contest about Reconstruction I do not propose either to take his counsel, recognize his authority, or believe a word he says." 43 It is more reasonable to conclude that the framers acted on Bingham's representation that he drew for privileges or immunities on Article 4, 2, 44 where under the words had acquired an accepted connotation. In truth, Bingham's confusion and hairpin turns could only confuse his hearers. Consider his emphasis in the oppressive speech on the reserved rights of the states. The Constitution does not delegate to the United States the of the Fifth Amendment, from which it was notably absent. The lawyers substituted its due process clause and a separate equal protection provision. Curtis, Book 62. So too, he had first employed the Article 4 terms the citizens in each state, which would have left the situation unchanged. See Avens 158. Presumably the lawyers perceived the need to shift to citizen of the United States. 40 Curtis, Book 86. 41 Benjamin Kendrick, The Journal of the Joint Committee on Reconstruction 214-15, 1914, Flack 59. 42 Curtis, Book 71. 43 Kong. Feb 39 Cong, 2d Ses. 816, Jan. 28, 1867. 44 Curtis, Book 63, Avens 150. Power to punish offenses against the life, liberty, or property of the citizen in the states, but leaves it as the reserved power of the states, to be by them exercised. 45 Again, the care of the property, the liberty, and the life of the citizen, under the solemn sanction of an oath imposed by your federal constitution, is in the states, and not in the federal government. I have sought to effect no change in that respect in the constitution of the country. 46 So too, I have always believed that the protection in time of peace within the states of all the rights of person and citizen was of the powers reserved to the states. And so I still believe. Now what does this civil rights bill propose? To reform the whole civil and criminal code of every state government. 47 What sense did it make to inveigh against a reform of the whole civil and criminal code of every state? And in the same breath insist that the criminal and civil provisions of the Bill of Rights must be enforced against the states? This goes beyond a charge of inconsistency. It suggests that Bingham's confused utterances must have confused his listeners. 48 Moreover, they voted to delete a threat to reform the state civil and criminal codes, and it offends common sense to conclude that they veered with Bingham and accepted an unorthodox theory that the Bill of RJGHTS governed their codes. Then too, James Wilson assured the House that we are not making a general criminal code for the states. 49. 45 Avens 186. ID. 187 47 ID. 188 48 See also infra chapter 9 text accompanying notes 10 to 13, is 17. Privileges or immunities with Justice Harlan. I agree that the Privileges or Immunities Clause was expected to be the primary source of substantive protection. The Equal Protection and Due Process Clauses were relegated to a secondary role, as the debates and other contemporary materials make clear. One Nevertheless, in the slaughterhouse cases, 1872, the Supreme Court virtually deprived the clause of meaning too, and in the more than 100 years that have since elapsed, that judgment has been left standing. Since the ongoing debate in large part pivots on the meaning of the clause, it will be instructive to seek historical light on what it meant to the framers. The terms privileges and immunities are first met in Article 4 of the Articles of Confederation, the better to secure and perpetuate mutual friendship and intercourse among the people of the different states in this union, the free inhabitants of each of these states shall be entitled to all privileges and immunities of free citizens in the several states, and the people of each state shall have free ingress. And 1 Oregon v. Mitchell, 400 U.S. 02, 164, 1970. In his study of the ratification debates, Dean Bond found that the debate focused primarily on the Privileges and Immunities Clause. Bond 445. 283 U.S. 16 Wall. 36, 1872. The effect of the decision was to make the Privileges and Immunities Clause practically a dead letter. Stanley Morrison, DIES. The 14th Amendment incorporate the Bill of Rights. 2 Stan. L. Rev. 140, 144, 1949. I. Regress to and from any other state, and shall enjoy therein all the privileges of trade and commerce, as the inhabitants thereof respectively. 3 For the founders, the enumerated privileges of trade and commerce limited the general words privileges and immunities for conforming to their drive for compressed utterance. The framers phrased Article 4, 2, more succinctly. The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. There was no discussion of this provision in the Federal Convention, suggesting familiarity with its terminology, the more because a large number of delegates, Madison included, had been members of the Continental Congress and were familiar with the Articles of Confederation. Contemporary with adoption of the 14th Amendment, the court in Paul v. Virginia spoke of Article 4, 2, in terms of the antecedent Articles of Confederation provision. It gives them the right of free ingress into other states and regress from them, a tacit identification of the 2 Articles. 5 Shortly thereafter, Justice Miller stated in the Slaughterhouse Cases, 3H. S. Commager, Documents of American History M. 7th ed. 1963, emphasis added. 4 Madison stated in Federalist No. 41 at 269, Mod. Lib. Ed. 1937 For what purpose could the enumeration of particular powers be inserted, if these and all others were meant to be included in the preceding general power? Nothing is more natural or common than first to use a general phrase, and then to explain and qualify it by a recital of particulars. But the idea of an enumeration of particulars which neither explain nor qualify the general meaning is an absurdity. Cited by Joseph Story, com. Ment Aries on the Constitution of the United States 9/11 at 664, 5th ed. 1905, 575 U.S. 8 Wall. 168, 180, 1968. Privileges or immunities. There can be but little question that the purposes of both these provisions is the same, and that the privileges and immunities intended are the same in each. In the Articles of Confederation we have some of these specifically mentioned, and perhaps enough to give some general idea of the class of civil rights meant by the phrase. 650 years later Chief Justice White declared in United States v. Wheeler that the text of Article 4.2 of the Constitution makes manifest that it was drawn with reference to the corresponding clause of the Articles of Confederation and was intended to perpetuate its limitations. 7 The limited scope of Article 4.2, delineated by these cases, was confirmed even earlier before the 14th Amendment by other cases. In the first of these cases, Campbell v. Morris, 1797, Justice Samuel Chase, soon to become a justice of the Supreme Court, stated on behalf of the Maryland court that counsel were agreed that a particular and limited operation is to be given these words privileges and immunities and not a full and comprehensive one. The court are of the opinion it means the peculiar advantages of acquiring and holding real as well as personal property, that such property shall be protected and secured by the laws of the state, in the same manner as the property of the citizens of the state is protected. Point 8. In explaining the Civil Rights Bill, Senator Lyman Trumbull, chairman of the Senate Judiciary Committee, read a more extended version of these remarks to the Senate. Point 9 and asterisk 83 U.S. 16 Wall. 36, 75, 1872. 7254 U.S. 281, 294, 1920, emphasis added. Curtis notes the relation of Article 4, 2, to the predecessor Article 4 of the Articles of Confederation. Curtis, Book 65. Asterisk 3H. And MCH. 535, 554, MD. 1797. Other opinion, Abbott v. Bailey, was rendered by the Massachusetts Court in 1827, stating in part, the privileges and immunities secured to the people of each state in every other state can be applied only in case of removal from one state to another. They shall have the privileges and immunities of citizens, that is they may take and hold real estate, and may, according to the laws of such state, eventually enjoy the full rights of citizenship without the necessity of being naturalized. Point 10. This too was read by Trumbull to the Senate. Point 11. Then Trumbull read from Corfield v. Coriel, an opinion by Justice Bushrod Washington on Circuit, 1823, 12, saying that he enumerates the very rights belonging to a citizen of the United States which are set forth in the first section of this bill. 13. For the convenience of the reader, an extended quotation is here set out. The next question is, whether this act infringes that section of the Constitution, Article 4, 2, which declares that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. The inquiry is, what are the privileges and immunities of citizens in the several states? We feel no hesitation in confining these expressions to those privy legs and immunities which are in their nature fundamental, which belong of right to the citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this Union, from the time of their becoming free, independent and sovereign. What these fundamental principles are, it would perhaps be more tedious than difficult to enumerate. They may, however, be all comprehended under the following general heads: protection by the 10-6 Pic. 89, 91, Mass. 1827. Avens 121 12-6 F. Ca. 546, CCED. Pa. 1823, No. 3220, emphasis added. 13. Avens 122, emphasis added. Privileges or immunities: government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety, subject, nevertheless, to such restraints as the government may justly prescribe for the general good of the whole. The right of a citizen of one state to pass through, or to reside in any other state, for purposes of trade, agriculture, professional pursuits, or otherwise, to claim the benefit of the writ of habeas corpus, to institute and maintain actions of any kind in the courts of the state, to take, hold, and dispose of property, either real or personal, and an exemption from higher taxes or impositions than are paid by other citizens of the state, may be mentioned as some of the particular privileges and immunities of citizens which are clearly embraced by the general description of privileges deemed fundamental, to which may be added the elective franchise, as regulated and established by the laws or constitutions of the states in which it is to be exercised. Point 14. Trumbull immediately pointed out that the bill did not provide for the elective franchise. Point 15. The exclusion of suffrage alone argues against an expansive reading of Corfield. Senator Sumner regarded suffrage as youth-only sufficient. Later adding that if the 14th Amendment is inadequate to protect persons in their right to vote, it is inadequate to protect them in anything. 16. Reliance on Corfield for an expansive interpretation is misplaced, if only because Washington went on to say, W.E. cannot accede to the proposition that, under this provision, Article 4, 2, of the Constitution, the citizens of the several states are permitted to participate in all the rights. 14. This was read to the Senate by Trumbull, ID. Emphasis added. 15. ID 16. Globe 685, emphasis in the original, Cong. Globe, 40th Cong, 3D Ses. 1008, 1869. Without suffrage, said Senator Samuel P. Muroy, the Negro has no security. Globe 1182. Which belong exclusively to the citizens of any other particular state. 17. It denied an out-of-state migrant the right to dredge for oysters in New Jersey waters, hardly evidencing an expansive interpretation. Curtis translates Corfield as recognizing Article 4 as protecting a set of basic national liberties, relying on Justice Roberts in Hague v. CIO. The purpose of this section was to create rights of citizens of the United States. Such was the view of Justice Washington. 18. Corfield furnishes no evidence for that view. Instead, after reciting the Article 4 provision, which refers to the citizens of each state, it said the inquiry is, what are the privileges and immunities of citizens in the several states, not of the United States, later referring to the right of a citizen of one state to pass through, or to reside, in any other. An erroneous reading is not legitimized because it comes from the court. Be it assumed that Corfield is more comprehensive than the rights the Civil Rights Act enumerates, it yet may not be invoked to enlarge the scope of the later act. Trumbull hastened to disclaim Corfield's inclusion of suffrage and underscored the very rights which are set forth in the first section. We should not substitute Corfield for the Act's own and later enumeration. 17 Curtis, Book 67. Corfield held that a migrant could not dredge for oysters in the host state. The ratification debate. After canvassing the ratification materials, Charles Fairman concluded that they confirmed that the Bill of Rights was not incorporated in the amendment. Point 1. That view is powerfully buttressed by Dean James Bond's recent study of the ratification debates in Illinois, Ohio, and Pennsylvania. 2. It contains striking repetitions of the views expressed by the framers. The vast bulk of the ratification sources are newspaper articles and reports of campaign speeches. With the exception of Pennsylvania, Dean James Bond states, the state legislatures kept no records of their debates. The legislative debate in Pennsylvania, he comments, reads like a reprise of the 6-month campaign debate that preceded it. 3. There are a few governor's messages, but most are quite general. 4. In the 3 states on which Bond concentrated, he observes that debate did not focus exclusively or even primarily on the first section of the 14th Amendment. The principal issue in those states was control of the national government. 5. Republicans feared that Democrats would wrest control of the House because with emancipation. Southern Fairman 81 ETSEQ 2 Bond 435. See also Curtis, Book 145. 3 Bond 461. 4 Curtis, Book 145. 5 Bond 438. Representation would no longer be limited to 3/5 of the blacks as Article I.3 provided. Now each voteless freedman counted as a whole person, a threat that Section 2 of the 14th Amendment countered by making representation proportional to enfranchisement of the blacks. 6. Let us for the moment retrace our steps. Disturbed by the revolutionary change Sumner hoped to bring about in the South, wrote Senator Sumner's biographer, David Donald, Republican congressmen were horrified that he proposed to extend them to the North as well. 7. 8. Those who cite violations of free speech in the South, denials of protection in the South. 8. Where freedmen were terrorized, maimed, and murdered. 9. Overlooked that the North was given little or no reason to conclude that it too was the target of the amendment. In fact, remarks made by leading spokesmen in the 39th Congress would lead the framers to believe that the Civil Rights Bill would have no operation in the North. James Wilson said that if the states would all practice the constitutional declaration of Article 4.2 and enforce it, we might very well refrain from the enactment of this bill into a law. 10 northern states respected the rights secured by Article 4.2. Senator Trump Bull likewise had stated that the bill will have no operation where all persons have the same civil rights without regard to color or race. 11. The Civil Rights Bill, said Senator Berger, Judiciary 15-16. 7. David Donald, Charles Sumner, and the Rights of Man 299, 1970. 8. Curtis, Book 134, 135, 138, 144, 147, 148. 9 Bond 449, 444, Super Chapter 2 Note 19, Infra Chapter 6 Text accompanying Note 51, See Chapter 8 Text accompanying Note N. 10 Avens 163-64. James Wilson said that blacks must have the same liberty of speech in any part of the South as they have always had in the North. Curtis, Book 144. Avens 122. In his criticism of President Johnson's veto of the Civil Rights Bill, Senator Trumbull said, this bill in no manner interferes. Stewart, was designed to forestall reducing the Negro to a system of peonage. If all the Southern states will repeal such laws, he continued, this bill will simply be a nullity, it will have no operation. 12 Such expressions strikingly surface in the ratification debates. Joseph James, who independently sifted the ratification materials, concluded that wherever the framers discussed the amendment, it was presented as a necessary limitation to be placed on the South to safeguard the Union. Though the possibility of its operation to some extent in the North had been pointed out in Congress, such statements formed no part of the Republican campaign. Procedure. 13 Proponents of the amendment, wrote Bond, downplayed the extent to which Congress would interfere with state authority. 14 It is inconceivable, given attachment to state sovereignty over local matters. 15 That the North would tamely have accepted drastic curtailment of its own control of criminal administration. It will be recalled, as Bond also notes, that the civil rights with the municipal regulations of any state which protects all alike in their rights of person and property. It would have no operation in Massachusetts, New York, Illinois, or most of the states in the Union. Avens 200. 12 ID. 204 13 James 167. On August 31, 1866, Columbus Delano pointed out that the first section 14th Amendment was made necessary by the perilous position of Northern men and loyal Southerners in the South. ID. 162 James noted that on July 18, 1866, Governor Norton of Indiana said that the reason for the Due Process Clause provision was the discrimination practiced by the Southern states. ID. 159 See also Senator Howe, Super Chapter 2 Note 25. And James states that the possibility of the amendment's operation in the North was seldom alluded to and often denied. ID. 191. 14 Bond 45 515 Chapter 5 Text accompanying Notes 22-45. Bill had been fueled by the Black Codes, which convinced the Republican majority that white Southerners intended to reinstitute slavery by denying newly freed blacks the rights to contract, to hold property and sue, 16 precisely the particularized rights enumerated in the bill. This was the limited category of rights which the framers considered were identical with and incorporated in the amendment. Speaking in Chicago in August 1866, Senator Trumbull, who had piloted the bill through the Senate, clearly and unhesitatingly declared one of the amendment to be a reiteration of the rights as set forth in the Civil Rights Bill, 17, which did not include any reference to the Bill of Rights. In Indiana, Senator Lane affirmed Trumbull's statement concerning the first section, and Senator Sherman endorsed those views in a speech on September 29, 1866. 18 Senator Poland spoke to the same effect in November 1866. 19 In sum, statements of congressmen before their constituents definitely identify the provisions of the first section of the amendment with those of the Civil Rights Bill. 20 The simple, most commonplace explanation of the first section, Bond wrote, was that it constitutionalized the Civil Rights Bill. He concluded that the citizens under 16 Bond 443, 17 James 161, 18 ID 162, 164, 19 Curtis, Book 252 Note 46. In Pennsylvania, proponents explained over and over again that one wove the principles of the Civil Rights Bill into the Constitution. Senator Bingham bluntly stated that one embodied the Civil Rights Bill. Representative Day cheerfully admitted that the purpose of one was to write in substance the Civil Rights Bill. Bond 461-62. When the amendment was submitted to the states for ratification, states Horace Flack, the Northern press with few exceptions, if any, took the view that the first section of the amendment reenacted or gave authority for the Civil Rights Bill. Flack 145. Standing of the 14th Amendment was that it simply made constitutional the bill's guarantee of civil rights. 21 This identification is confirmed by the repeated emphasis that the indispensable civil rights were the right to contract, to sue, to testify, and otherwise resort to the courts, to hold and transfer property, and to the full and equal benefit of all laws for the protection of person and property. 22 When a stump speaker expanded on the point, he generally listed the very rights enumerated in the Civil Rights Bill. The right to sue, to be protected in their person and property, the right of locomotion, the right to go where they please and own property where they please. 23 Curtis downgrades this evidence. Several congressmen made these vague statements. 24 But he acknowledges that a speech by Senator John Sherman saying that the sum and substance of the first clause was the right to come and go, to sue, and to make contracts, seems inconsistent with incorporation of the Bill of Rights. 25 He admits, in other words, what I have steadily maintained, that the enumeration of particular rights in the Civil Rights Bill excludes the unmentioned Bill of Rights. When proponents of the amendment explained that one protected civil rights or civil liberty, Bond concluded, they could scarcely have had in mind a different set of civil rights from those they had so shortly before included in the Civil Rights Bill. 26 In sum, Dean Bond has shown that the ratification debates confirm the legislative history with respect to the view. 21 Bond 443, 448. 22 ID 446, 44,723 ID 448 24 Curtis, Book 141, 253 Note 46, emphasis added. 25 ID 253 and 46, emphasis added. Bond 448-49. That the Civil Rights Act and the 14th Amendment were identical, that the amendment, like the Act, aimed to protect the rights to contract, hold property, and have access to the courts, and have the rights of locomotion liberty as defined by Blackstone, and that the Act was designed to operate in the South. Part 2 Opposition Views. Some preliminary consideration so convincing, in my judgment, is the evidence hereinbefore set forth that, to borrow the words of Van Alstyne, it is indeed astonishing that the answer should be thought doubtful at this late date. 1 Nevertheless, he hails Michael Curtis' recent challenge to the established learning 2 as the most powerful response to doubts respecting the incorporation doctrine yet published. 3 He is joined by Leonard Levy, who considers that Curtis alters the path of scholarship with his excellent work. 4 Eugene Gressman also weighs in, stating that Curtis does a masterful job in undermining the Berger-Fairman thesis and in demonstrating the faulty and short-sighted nature of their examination of the framers' original intention. 5 Notwithstanding their august imprimatur, it will appear, as Curtis said of Fair 1 Super Chapter I text accompanying Note 2. 2 ID. Note 2. 3 ID. Forward at 9. Van Alstyne is not an unbiased observer. Earlier he had dismissed my views out of hand as narrow. W. Van Alstyne, Interpreting the Constitution, The Unhelpful Contributions of Special Theories of Judicial Review, 35 U. FLA. L. Rev. 209, 234 Note 65, 1983. For the reason why, see Berger, Judiciary 69-76, 419-27. 4 Levy, Dust Jacket of the Curtis Book. In 1972, Levy concluded that the historical record is inconclusive. L. Levy Judgments, Essays in American Constitutional History 136, 1972. S.E. Gressman, Book Review, 1 New Law Books Reviewer 57, 59, 1986. Man, that much of Curtis's mountain of evidence is beside the point. 6 To proponents of judicial activism, Curtis' book is understandably welcome, for it seems to supply historical justification, draped in all the trappings of scholarship, for their activist advocacy. It is of the genre described by a fellow AC. Tivist, Paul Brest, as not political theory but advocacy scholarship amicus briefs ultimately designed to persuade the court to adopt our various notions of the public good. 7. Curtis was moved to write because he is alarmed that a rollback of civil liberty is well underway because Berger's analysis may give impetus to a reaction already begun, that would strip citizens of federal protection against state infringement of their rights to freedom of speech. 8. Gressman observed that Curtis has a passionate concern for civil liberties, 9. Thereby exhibiting his commitment to a thesis. Motivation, Curtis has written, is not important if the 6. Curtis, book IOO. All is grist that comes to Curtis Mill. Consider, Senator Trumbull submitted a petition from citizens of Quincy, Illinois, demanding absolute equality of political as well as civil rights, ID 56, in light of Trumbull's explanation that political rights were excluded from the Civil Rights Bill, Super Chapter 3 text accompanying Note 15. In the event, suffrage was left to the states by the 14th Amendment. Berger, Judiciary 5268. See also Infra Chapter 8 Note 77, Senator Howard. For the anti-Negro sentiment in Southern Illinois, see Infra Chapter 6 text accompanying Notes 88 and 89. 7. P. Brest, The Fundamental Rights Controversy, The Essential Contradiction of Normative Scholarship, 90 Yale LJ. 1063, 1109, 1981. Lovey wrote, History for the activist is a protean instrument, useful for legitimating a predetermined result. Lovey, Super Note 4 at 78. 8. Curtis, Reply 47, 46. 9. Gressman, Super Note 5 at 57. Gressman himself is not dispassionate, he brands the Slaughterhouse decision as infamous, ID. At 60, that is, of shameful badness, vileness, or abominableness. Oxford Universal Dictionary, I 955, as a contemporaneous construction, Slaughterhouse is scarcely deserving of such utter reprobation. See Super Chapter 1 text AC. Accompanying Notes 58 to 59. Facts are true. 10. Passionate dedication to a cause, however, is apt to distort the judgment of what the facts are, to promote wishful thinking, and to result in partisan propaganda. As John Morley observed, passion appears hopelessly fatal to anything like success in the pursuit of truth, who does not reveal herself to followers thus inflamed. 11. Curtis' partisanship leads him to fall short of scholarly duties. For example, one who undertakes to tear down the scholarship of others is under a duty of unimpeachable accuracy, of stating their position fairly. 12. Duties he does not perform. Curtis' thesis did not spring from the blue. He tells us that most influential on his thought was the powerful critique of Fairman's article by William Krosky, which Michael Curtis, Judge Hans History, an analysis of history and method in Jaffrey v. Board of School Commissioners of Mobile County 86W. VA. L. Rev. 109, in, 1983. 11F. N. Hurst, Early Life and Letters of John Morley 94, 1927. As long ago as 1942, I indicated that I liked it no better when Justice Black read my predilections into the Constitution than when the Four Horsemen read in theirs. Raoul Berger, Constructive Contempt, a Postmortem. 9U. Chi. L. Rev. 602, 1942. Thus I am opposed to anti-abortionists, to prayer in the schools, and yet consider that the respective Supreme Court decisions in those cases are without constitutional warrant. Morley lauded the temper which seeks truth for its own sake apart from the consequences, and apart from its agreement or disagreement with reigning convictions. Hurst, Super at 96. 12. Curtis cannot bring himself to state his opponent's case fairly and accurately. For example, Berger's analysis contains contradictions. First, he said that Bingham's references to the Bill of Rights meant and were understood to mean only the Due Process Clause of the Fifth Amendment and Article 4, Section 2. Curtis, Book 123. He cites, page 249, note 240. To page 141 of my Judiciary, where it states, as Lehrman pointed out, the antecedent of Bingham's remark was Article 4 Seconds 2, and the Fifth Amendment Due Process Clause which Bingham equated with equal protection. So it was not Berger but Fairman who said. Moreover, Bingham himself stated, as Curtis noted, Book 57, that the Congress shall have power to make all laws which shall be necessary and proper to se. Brilliantly illuminates the forgotten relation of the 14th Amendment to the Bill of Rights. 13. Taking no notice of Fairman's devastating reply. 14. It is an eloquent comment on the weight of Krosky's article that Justice Black, writing 14 years after the article appeared, as Curtis notices, unfortunately did not cite Krosky. 15. Black, who clung to his theory despite the court's obdurate rejections, would have been eager to embrace some solid historical confirmation. His omission to cite Krosky's impassioned elaboration of his theory testifies that Black had little confidence in Krosky's scholarship. Krosky, it must be stated bluntly, was an untrustworthy scholar. 16. One example must suffice. Despite the legislative history confirmation that the Bill of Rights was not to apply to the states, Krosky dismissed Marshall's iniquitous doctrine of Barron v. Baltimore as without any warrant at all. 17. But as Dean John Hart Ely recently wrote, in terms of the original under cure to citizens of each state all privileges and immunities of citizens in the several states, art. 4 seconds. 2. And to all persons in the several states equal protection in the rights of life, liberty, and property, Fifth Amendment. Throughout, Curtis reduces incontrovertible facts to Berger's bare assertions. 13 Curtis, Book 121, 8. 14 Charles Fairman, A Reply to Professor Krosky, 22 U. Chi. L. Rev. 144, 1954. 15 Curtis, Reply 49 Note 22. 16 For more extended documentation, see Raoul Berger, Congress v. The Supreme Court 22-46, 1969. 17 William Krosky, Politics and the Constitution in the History of the United States 1076, 1091, 1953. Julius Goebel wrote that Krosky's performance, measured even by the least exacting of scholarly standards, is without merit. M.R. Krosky, coming to his task with a new axe to grind, has seemingly forsworn all canons of objectivity to make himself a grindstone that suits his purposes. J. Goebel, Book Review, 54 Column. L. Rev. 450, 451, 195 plus, History, Levy observes, was on the side of the Supreme Court. Levy, Super Note 4 at 67. Standing, Barron was almost certainly decided correctly. 18 The soundness of Barron has been, and remains, virtually beyond dispute, regardless of the 14th Amendment. That said, I agree with Sidney Hook that what makes a thing true is not who says it, but the evidence for it. 19 Consequently, I shall painstakingly examine the facts Curtis musters in his effort to overthrow conventional learning. It is a splendid irony that a judicial activist such as Curtis should rely on the original intention of the framers 20, a doctrine that is anathema to his fellow activists and which they have consigned to outermost limbo. 21 But they cannot have it both ways. Selective application of original intention, according to whether it serves a particular purpose, is obviously arbitrary. Then too, in seeking to ascertain the original intention, I have ever confined myself to an intention that is clearly discernible. Curtis' history, as will appear, is rarely clear and very often conflicting, and therefore is an inconclusive index of the original intention. Guides to Interpretation A. State sovereignty. For understanding the scope of the 14th Amendment, the continued attachment of the North to state control of internal affairs is far more important than the abolitionist anti-slavery background upon which Curtis so heavily relies. Tarnished as state sovereignty was by the in 18 J. H. Ely, Democracy and Distrust 196, 1980. 19 Sidney Hook, Philosophy and Public Policy 121, 1980. Curtis, Book 9-12 21 Levy, who extols Curtis, wrote that issues of public policy should not be decided merely because of the original meaning of words in the Constitution, and derides an antiquarian historicism that Huggold frees the Constitution's original meaning. Levy, Super Note 4 at 71. Equities of slavery for which it was invoked by the South, the North remained deeply attached to the principle of states' rights. Although the North was determined to bar the return of the emancipated slaves to serfdom by the South's Black Codes 22 eradication of inequality, as C. Van Woodward remarked, would require a revolution in the North as well. 23 A revolution for which the North was unprepared. 24 And, as we have seen, of which it was not really apprised. The radical leaders, Horace Flack wrote, were as aware as any one of the attachment of a great majority of the people to the doctrine of states' rights. The right of the states to regulate their own internal affairs. 25 At the outset, Roscoe Conkling, a member of the Joint Committee on Reconstruction, said, the proposition to prohibit states from denying civil or political rights to any class of persons, encounters a great objection on the threshold. It trenches upon the principle of existing local sovereignty. 26 Other Republicans were of the same mind. 27 John Bingham, draftsman of the 14th Amendment, also recognized that the citizens must rely upon the state for their protection. I admit that such is the rule under the Constitution as it now stands. And thereupon he read to his fellows Madison's statement in Federalist No. 45. 22 The Black Codes had convinced a majority in Congress that white Southerners intended to reinstitute slavery by denying newly freed blacks the rights to contract, hold property and sue. Bond 443. See also Super Chapter 2 text accompanying notes 42-47. 23 V. Woodward, The Burden of Southern History 79, I-960. 24 Super Chapter 4 text accompanying notes 8-14. 25 Flack 68. H.J. Graham, Every Man's Constitution 312, 1968 No one reading the debates carefully will question the framers' devotion to federalism, even the extreme radicals. 26 Evans M. 27 For example, Robert Hale said, all powers having reference to the relationship of the individual to the municipal government, the power reserved to the federal states will extend to all the objects which, in the ordinary course of affairs concerns the lives, liberties, and properties of the people, and the internal order, improvement, and prosperity of the state. 28 Like his Ohio colleague Bingham, Columbus Delano said, there are certain rights of citizenship that are exclusively within the control of the states. 29 And George Latham stated that Congress has no right under the Constitution to interfere with the internal policy of the several states. 30 Such sentiments were summarized by a sagacious observer, Justice Samuel Miller, shortly after adoption of the 14th Amendment. We do not see in these amendments any purpose to destroy the main features of the general system. Under the pressure of all the excited feeling growing out of the war, our statesmen have still believed that the existence of the states with powers for domestic and local government was essential to the perfect working of our complex form of government. 31. As Don Berger has recently concluded, there was a widespread and tenacious resistance to the interventionism federalism aggressively embodied. 32 of local jurisdiction and legislation are in general reserved to the states. ID 153. See also George Latham, ID 190-91, Columbus Delano, ID 178. 28 Evans 159. Madison also stated in No. 39 of the Federalist that the jurisdiction of the proposed federal government extends to enumerated objects only, and leaves to the states a residuary and inviolable sovereignty over all other objects. Federalist No. 39 at 249, Mod. Lib. Ed. 1937, Bingham repeated, the care of the property, the liberty, and the life of the citizen is in the states and not in the federal government. I have sought to effect no change in that respect. Evans 187. 29 Evans 178. 30 ID 190-91. 31 Slaughterhouse Cases, 83 U.S. 16 Wall. 36, 82, 1872. 32 Donnie Fehrenbacher, the Dred Scott Case, Its Significance in American Law and Politics 581, 1978. It is against this tide of historical evidence that Curtis asserts, jading Republicans gave the states' rights argument short shrift. 33 Citing William Lawrence, who said, "It is better to invade the judicial power of the state than to permit it to invade, strike down, and destroy the civil rights of citizens." 34 Lawrence directed this fire at Southern restrictions on the freedmen. Outraged by the Black Codes, the North set out to protect a set of fundamental rights that would enable emancipated slaves to exist. 35 But the North was far from ready to clothe the former slaves with a full panoply of rights, the less because it was apprehensive of undue interference with the state's right to order their own internal affairs. 36 Thus, Senator James Patterson of New Hampshire was opposed to any law discriminating against blacks in the security and protection of life, liberty, person, and property, but said that beyond this I am not prepared to go. 37 For him, life, liberty, and property did not have 33 Curtis, Book N. 34 ID 35 As Lawrence stated, it is idle to say that a citizen shall have the right to life, yet to deny him the right to labor whereby alone he can live. It is a mockery to say that a citizen may have a right to live, and yet deny him the right to make a contract to secure the privileges and the rewards of labor. Evans 206. See also Super Chapter 2 text accompanying notes 19-25. 36 Michael Perry, himself an activist, concurs in the view that the proposition that the 14th Amendment incorporates the Bill of Rights constitutes an invasion of rights reserved to die states by the 10th Amendment, an invasion of such magnitude as to demand proof that such was the framers' intention. M. Perry, Book Review, 78 Column. L. Rev. 685, 690, 1978. The point was made by Judge Richard Posner, Super Chapter 1 text accompanying note 55. 37 Globe 2699. See also Senator Stewart, info text accompanying note 52. Curtis stresses that the most common Republican refrain in the 39th Congress was that the life, liberty, and property of American citizens must be protected against denial by the states. Curtis, Book 41. But he acknowledges that although Republicans rejected the notion that states could invade the fundamental rights of citizens, they wanted to. The unbounded compass that Curtis throughout his book assigns to those terms. Delano, concerned lest blacks could serve as jurors, believed that citizens' rights are to be guaranteed by the laws of the states and by Congress, when there is power given by the Constitution to enforce those rights. But he did not believe that the rights of the states are utterly overwhelmed and dethroned. 38 And Bingham, as we have seen, made an even more forcible objection. 39 This commitment to traditional state-federal relations meant, Alfred Kelly wrote, that the radical Negro reform program could be only a very limited one. 40 Preserve the states. They did not want the federal government to supplant them altogether or usurp their basic functions. ID. Given that no black codes threatened black rights in the North, it is incumbent on Curtis to prove that the North knowingly consented to federal usurpation of state control over criminal and civil administration. Moreover, the framers, as will appear, associated fundamental rights with the limited category enumerated in the Civil Rights Bill. See also Super Chapter 4 text accompanying notes 8-14. 38 Evans 178. It is difficult to reconcile this statement with Curtis' attribution to Delano of associating individual liberties with Bill of Rights liberties. Curtis, Book 41. Judge Robert Hale, a New York Republican, warned the House that there are other liberties as important as the liberties of the individual citizen, and those are liberties and rights of the states. Evans 155. Senator Oliver Morton, an Indiana Republican, stated in 1868, I still recognize the doctrine of states' rights. There are rights that belong to the states, secured by the same Constitution that secures the rights of this government, and therefore they are equally sacred. Evans 324. In the House, John Farnsworth of Illinois, who had been a proponent of the 14th Amendment, said in 1871, I do not believe in centralization of the power of government, nor in abolishing the state lines or state governments or abridging their powers. Avens 508. 39 Super Chapter 2 Text accompanying notes 2932. 48. Kelly, comment on Harold H. Hyman's paper in New Frontiers of American Reconstruction 55, H. Hyman ed. 1966, Hyman notes Republican unwillingness to travel any road more rugged than the Civil Rights Freedmen's Bureau Extension 14th Amendment route that left it. Given this deeply rooted devotion to preservation of state control over internal matters, underscored by the 10th Amendment, 41 equivocal or confused utterances must not be construed to curtail state sovereignty. One who argues for such curtailment has the burden of proof. 42 Writing in 1954, Herbert Wexler observed that there is a burden of persuasion on those favoring national intervention in state matters. 43 The exceptional nature of federal intervention was underscored in 1938 by Justice Louis Brandeis. The Constitution, he wrote, preserves the autonomy and independence of the states. Federal supervision of their action is in no case permissible except as to matters specifically delegated to the United States. Any interference, except as thus permitted, is an invasion of the authority of the state. 44 States master of their own fates. H. Hyman, A More Perfect Union 470, 1973, see also ID. 440, 448. The pervasive attachment to federalism, state control of local institutions, Philip Paludan repeatedly emphasizes, was the most potent institutional obstacle to the Negro's hope for protected liberty. P. Paludan, A Covenant with Death 15, 31, 51, 54, 1975. 41 Senator Frederick Frelinghuysen, who read the 14th Amendment broadly, agreed in 1871 that the 14th Amendment must not be used to make the general government imperial. It must be read together with the 10th Amendment. Thus reading the 14th Amendment, I do not consider it now expedient for the general government to assume a general municipal jurisdiction over crime in the states. Avens 542. 42 Raoul Berger, Federalism, The Founders' Design 150-157, 1987. 43 H. Wexler, The Political Safeguards of Federalism, The Role of the States in the Composition and Selection of the National Government, 54 Column. L. Rev. 543, 545, 1954. 44 Erie Re. Co. V. Tompkins, 304 U.S. 64, 78-79, 1938, emphasis added. The undelegated, residuary, and inviolable powers, Federalist No. 39 at 249, expressly guaranteed by the 10th Amendment, are not to be curtailed under cover of what Chief Justice Rehnquist referred to as the vaguely worded prohibitions against state action, the fuzzy gender. Earlier, in the slaughterhouse cases, Justice Miller had rejected a construction of the 14th Amendment that would subject states to the control of Congress in the exercise of powers heretofore universally conceded to them in the absence of language which expresses such a purpose too clearly to admit of doubt. 45 These were but expressions of the principle earlier formulated by Chief Justice Marshall, an opinion which is to establish a principle never before recognized should be expressed in plain and explicit terms. 46 Curtis inferences from his collation of Republican statements fails to take this rule of construction into account. V. Abolitionism vs. Racism. Curtis labors under the grand illusion that the 14th Amendment was produced by the anti-slavery crusade. 47 He notes that prior to the Civil War prejudice against blacks was extensive. While only a handful of radical political abolitionists had advocated the abolition of slavery before Lincoln espoused its cause, he asserts that radical abolitionism had become Republican orthodoxy by 1866 as a result of Lincoln's support for emancipation. 48 So he is led to conclude that the far-reaching program of some abilities of the 14th Amendment. W.H. Rehnquist, The Supreme Court, How It Was, How It Is 180, 1987. In Noble State Bank v. Haskell, 219 U.S. 104, No, 19a, the court itself stated, per Justice Holmes, that as it often is difficult to mark the line where what is called the police power of the states is limited by the Constitution of the United States, judges should be slow to read into the latter and lemus mutere as against the lawmaking power. 4583 U.S. 16 Wall. 36, 78, 1872. United States v. Burr, 25 F. Co. 55, 165, C. CVA. 1807, No. 14693. For an extreme application of this rule, see Pearson v. Ray, 386 U.S. 547, 554 55, 1967. 47 Curtis, Book 6. 48 ID. 29, 34. Abolitionists equally commended itself to most Republicans. Triumph ND he asks, if abolitionists' ideas were an anathema to most Republican congressmen, why in the previous session of Congress had they abolished slavery in the states, the main goal of the radical political abolitionists? 49 It escapes him that, unfortunately, a northerner could oppose slavery and yet remain a racist. The matter was cogently summarized by Henry Monahan. We forget that many mid-19th century Americans, perhaps a clear majority, opposed slavery and racial equality with equal intensity. They could logically believe that emancipation required that the freedman possess certain rights to personal security and property. Simultaneously they could favor rank discrimination against blacks in political and social matters. Point 50. The fact, noted by David Donald, is that racism ran deep in the North, and the suggestion that Negroes should be treated as equals to white men woke some of the deepest and ugliest fears in the American mind. 51. While Senator William Stewart considered that Negro suffrage will endanger our national existence, he said, "I am not in favor of turning the Negro over to oppression in the South. I am in favor of legislation that shall secure him a chance to live, a chance to hold property, a chance to be heard in the courts." 52. The framers of the 14th Amendment represented a constituency that had just emerged from a wrenching, bitterly fought war, a war that left them drained physically and emotionally. It had begun with a drive to save the Union. 49 ID. N8. 50H. Monahan, the Constitution goes to Harvard, 13 Harv. CRNCL. Rev. 117, 126, 1978. 51D. Donald, Charles Sumner, and the Rights of Man 202, 252, 1970. And had gone on to emancipate the slaves. Now the weary North was far from ready to embark on fresh crusades for the realization of still other abolitionist goals. The North was finally converted to abolition of slavery, not so much by abolitionist theorizing. Abolitionists were widely disliked if not hated. 53. But because slavery had led to a bloodbath. Point 54. That peculiar institution had to be destroyed. But it by no means follows that the North swallowed abolitionist theorizing whole. Abolition of slavery, it needs to be remembered, did not touch the North, for their slavery did not exist. Bingham asked, "Is the Bill of Rights to stand in our Constitution here?" After, as in the past 5 years within 11 Southern states, a mere dead letter. 55. Recognition that the mischief did not extend to the North. Curtis himself observes that Republican congressmen typically insisted on protection within the Southern states. 56. Whereas the 13th Amendment, which abolished slavery, Fairman noted, had been generally popular among Northerners, the Civil Rights Bill, as James G. Blaine recalled, was legislation of a different type, which, particularly in the Middle and Western states. 53. The abolitionists were regarded throughout most Northern circles as disagreeable and intemperate radicals and were heckled, harrowed, and even killed by Northern mobs. Dan Lacey, The White Use of Blacks in America. 54, 1972, see also Curtis, Book 39. For the persistence of such feelings, see info text accompanying notes 80 to 90. 54. James Russell Lowell wrote, "Our war has not been distinctly and avowedly for the extinction of slavery, but a war rather for the preservation of our national power and greatness, in which the emancipation of the Negro was forced upon us by circumstances and accepted as a necessity." J.R. Lowell, Abraham Lincoln, in 28 Harvard Classics 441, 455, 1910. 55. Avens 158. 56. Curtis, Book 56, emphasis added, see Super Chapter 4 text accompanying notes -15. Touched upon deep feelings. 57. Obliviousness to such facts leads Curtis to assert, the major fault with Professor Fairman's effort to understand the 14th Amendment is that it overlooked the anti-slavery origins of the amendment. 58. But it is, in fact, Curtis who turns his back on the two powerful countervailing tides of public opinion during this period of our history: pervasive detestation of the abolitionists and rampant racism in the North. Although Curtis recognizes that prior to the Civil War prejudice against blacks was extensive, he overlooks its continuing virulence during and after the war. It does not suffice to cite Lincoln's 1856 remark about equality in the Declaration of Independence. 59. While ignoring his later re-57-6 Charles Fairman, History of the Supreme Court of the United States N. 68, 1971. Robert Hale of New York protested that Bingham's amendment takes away from these states the right to determine for themselves what their institutions shall be. Oregon has not been contumacious towards this union. Avens 155. 58. Curtis, Book 100. Levy likewise wrote in 1972 that the evidence of 1866 to 1868 the framers' debates must be read in the light of a received tradition of abolitionist constitutional argument. Levy, Super Note 4 at 70. 59. Curtis, Book 16 to 17. In 1789 the Democratic movement was in abeyance, and a Thermidorian reaction in full swing. The federal constitution put a stopper on those leveling and confiscatory demands of democracy. S.E. Morrison and H. S. Commager, The Growth of the American Republic 300, 1950. It is an historical fallacy to read modern mores back into the Declaration of Independence. Jefferson, who penned it, predicted emancipation, but wrote, "It is equally certain that the two races will never live in a state of equal freedom. So insurmountable are the barriers which nature, habit, and opinion have established between them." Quoted in Alexis de Tocqueville, Democracy in America 378, 1900. In truth, the Constitution did not embody the equality sounded in the Declaration, as Stevens pointed out to the framers. Globe 536. On March 18, 1868, he reiterated, The Constitution of 1787 did not carry out the principles of government which were intended by the fathers when in 1776 they laid the foundations. The actions of the convention in framing the Constitution bartered away for the time being some of those inalienable rights. Cong. Globe, 40th Cong, 2d Ses. 1767, 1868. Marx to a delegation of black leaders who called on him in the White House, "There is an unwillingness on the part of our people, harsh as it may be, for you free-colored people to remain with us. Even when you cease to be slaves, you are far removed from being placed on an equality with the white man. I cannot alter it if I would. It is a fact. 60 Fear that emancipated slaves would flock north in droves and compete with white labor alarmed the North. 61 Letters and diaries of Union soldiers, c. Van Woodward recounts, reveal an enormous amount of antipathy towards Negroes. 62 Racism, Reconstruction historian David Donald recounts, ran deep in the North. 63 For this the debates in the 39th Congress furnish abundant confirmation. George Julian, an Indiana radical, deplored the proverbial hatred of Negroes. "The real trouble," he said, "is we hate the Negro." Senator Henry Lane referred to the almost ineradicable prejudice, Senator William Stewart spoke of the nearly insurmountable prejudice, and James Wilson re 60 Woodward, Super Note 23 at 81. 61 C. V. Woodward, Seeds of the Failure in Radical Reconstruction Policy, in New Frontiers of American Reconstruction 121, 128, 131, 132, H. Flyman ed. 1966, James Blair said that the working men of the North desire that the blacks who are going north should be provided with a more suitable home than is to be found among the white population. Avens 36. In 1862, Senator Lyman Trumbull reprehended a tirade against the state of Illinois because we do not want to receive the free Negroes of Virginia. ID. Senator Thomas Hendricks of Indiana stated, "The policy of the state has been to discourage their immigration. The people have been unwilling that the white laborer shall be compelled to compete for employment with the Negro." Avens 230. Woodward, Super Note 23 at 82, 83. The reaction of the average Union veteran to his contacts with the freedmen bordered on contempt. S.E. Morrison _ The Oxford History of the American People 715, 1965. 63 Donald, Super Note 51 at 202. Minded his fellows of the iron-cased prejudice against the blacks. 64 These were not foes of protection for blacks, rather they were Republican and radical proponents of black protection. Notwithstanding, John Sherman stated in the Senate in 1867, "We do not like Negroes. We do not conceal our dislike." 65 As late as 1869, Henry Wilson, a Massachusetts radical, could state in the Senate that there is not today a square mile in the United States where the equal rights and privileges of those colored men has not been in the past and is not now unpopular. 66 Consider Curtis' treatment of such facts. Berger asserted that these congressmen were influenced by Negrophobia. 67 But even Curtis' own authority, Harold Hyman, wrote, "Negrophobia tended to hold even the sparse Reconstruction institutions that the nation created to loathe, and played a part in Reconstruction incompleteness." 68 The fact is, as Hyman's disciple Philip Paludan noted, racism was as pervasive during Reconstruction as after. Americans clung firmly to a belief in the basic inferiority of the Negro race, a belief supported by the preponderance of 19th century scientific evidence. 69 What lies beneath the politics of Reconstruction, so far as it touched the Negro, wrote Russell Nye, is the prevailing racist policy tacitly accepted by both parties and the general public. 70 All this is ironically dispatched by Curtis. Still, they the framers were willing to invade states' rights, as conventionally understood, to protect blacks whom they sub 64 Globe 257, 739, PN, 2799, 2948. Woodward, Super Note 61 at 128. Avens 340. Curtis, Book N8, emphasis added. Hyman, Super Note 40 at 447. 69 Paludan, Super Note 40 at 54. 70 Russell Nye, comment on C. V. Woodward's paper, in New Frontiers of American Reconstruction 148, 152, 1966. Poseley disliked. But they were not willing to interfere with states' rights by requiring the states to obey the Bill of Rights guarantees that protect whites and blacks alike. 71 Like others who share his current sentiments, he refuses to see that the North's readiness to protect blacks from the South's attempt to reimpose the shackles of serfdom did not mean that the North was ready to surrender control of its own administration of other local, internal affairs. There are similar problems in Curtis' account of abolitionist influence. He does not grasp that pre-Civil War abolitionist speeches during the drive to abolish slavery did not reflect post-war sentiment in the North. Racism was a potent weapon for Democrats. 72 William Lloyd Garrison, the indomitable abolitionist who had been drag-fed through the streets of Boston with a rope around his neck to be hanged. 73 accurately sensed the new mood when he declared that anti-slavery society served no useful purpose now that slavery was abolished and closed down the Libera. Tour 7 Curtis' emphasis on abolitionist influence on anti-slavery activists, ignores the anti-abolitionist feeling in the North and in the 39th Congress. Woodward observed that during the war years, the great majority of citizens in the North still abhorred any association with abolitionists. 75 Scarcely fertile soil for the sowing of abolitionist ideology. Senator William Fessenden, co-chairman of the Joint Committee on Reconstruction, similarly held the extreme radicals in abhorrence. 76 Senator Edgar 71 Curtis, Book N8, emphasis added. C. Monahan, Supertext accompanying Note 50. 72 Curtis, Book 29. See Infra Chapter 6 text accompanying Notes 87 to 88. 73 Curtis, Book 39. 74 Donald, Super Note 51 at 233. 75 Woodward, Super Note 23 at 73. 76 Benjamin Kendrick, The Journal of the Joint Committee of 15 on Reconstruction 257, 1914. Cowan ridiculed the notion that the antipathy that never sleeps, that never dies, that is inborn, down at the foundation of our natures, is to be swept away by a half-dozen debates and the reading of half-a-dozen reports from certain abolitionist societies. 77 and Thaddeus Stevens, The Scourge of the South. 78 was openly hated by many moderate Republicans. 79 In the Joint Committee, Stevens' measures were more often voted against than voted for. 80 His Senate counterpart, Charles Sumner, was distrusted when not detested. 81 Senator Trumbull scathingly commented in 1870 that it has been over the idiosyncrasies, over the unreasonable propositions, over the impractical measures of Sumner that freedom has been proclaimed and established. 82 The nature of abolitionist theorizing, moreover, won lit favor with the majority of framers of the 14th Amendment. Curtis notices attempts by anti-slavery lawyers to develop some remarkable theories to undergird their legal attack on slavery. 83 Joel Tiffany, a leading abolitionist theorist, for example, held that slavery was unconstitutional, even in the states. 84 Some Republicans believed that slavery in the territories would deprive slaves of due process of law. 85 And John Bingham had argued that the Due Process Clause had banned slavery in federal territories. He thought that slavery was incompatible. 77 Globe 343, 344-45. 78 Fawn Brody, Thaddeus Stevens, The Scourge of the South, 1959, 79 ID. 259 80 ID. 268 81 Donald, Super Note 51 at 248. 82 M. Benedict, A Compromise of Principle 39, 1974. 83 Curtis, Reply 54, C. Graham, Infra Text accompanying Note 94. 84 Curtis, Book 42. With the Bill of Rights. 86 But the fact, as Curtis notes, is that doctrines such as Tiffany's were not accepted by most Republican congressmen. 87 Curtis recognizes that in contrast to radical abolitionists, most Republicans admitted that slaves were unprotected by the Constitution. 88 And that none of the political platforms of the major anti-slavery parties advocated interference with slavery in the states where it already existed. 89 Mainstream views were firmly anchored in historical fact, to mention only Madison's assurance to the Virginia ratifying convention that the Constitution did not allow interference with slavery in the states. 90 This was not undone by the later Due Process Clause. The Fifth Amendment was not intended to nullify the carefully framed compromises on the slavery issue. Nevertheless, Curtis urges that Tiffany's theories provided the basis for a plausible civil libertarian reading of the Constitution. 91 Even among abolitionists there were renowned dissenting voices. William Lloyd Garrison and Wendell Phillips rejected radical anti-slavery constitutional thought. 92 A neo-abolitionist, Howard J. Graham, who, Curtis considers, contributed much to our understanding of the anti-slavery origins of the 14th Amendment. 93 wrote that the abolitionist theory of racialized due process was 86 ID. 47, 102. On the other hand, Bingham said that slaves were not protected by the Constitution. ID. 101, a contradiction not noticed by Curtis. 87 ID. 4288 ID. 46 In his debates with Douglas, Lincoln said, "We have no right to disturb slavery in the states where it exists." H.M. Hindman, Further Reminiscences 334, 1912. 89 Curtis, Book 91. 90 ID. 1991 ID. 42 to 4392 ID. 4593 ID. M. 64 14th Amendment and Bill of Rights frankly heretical. 94 The lawyers who sat in the 39th Congress were unlikely to embrace frankly heretical views out of hand. Curtis' pervasive analytical flaw is his tacit assumption that the conservative moderate majority which, according to M. L. Benedict, controlled the 39th Congress, was converted by the frankly heretical views of the abolitionists. That conversion runs counter to fact. In truth, a Republican-conservative coalition 95 Benedict has shown, enacted their program with the sullen acquiescence of some radicals and over the open opposition of many. 96 Benedict is in accord with David Donald. 97 and he 94 Graham, Super Note 25 at 242. Some Republicans, Curtis notes, frankly recognized that their constitutional views were unorthodox. Curtis, Book 52. Graham wrote, that this anti-slavery constitutional theory was extremely heterodox is clear. It was not primarily the product of minds trained in vigorous case analysis or statutory construction. It confused moral with civil and constitutional rights. It made the Declaration of Independence, the basic constitutional document. The Federal Bill of Rights a source rather than a limitation of federal power. Graham, Super Notes 25 at 237 to 38. 95 for example. Senator Trumbull, oft quoted by Curtis, was a Republican leader of preeminent influence. Throughout Reconstruction as a whole he tended to be conservative. Curtis, Book 73. 96 Benedict, Super Note 82 at 210. Benedict's statement is rendered by Curtis as Berger said that a Republican centrist conservative coalition was in control of the 39th Congress. Curtis, Book N8. To prove the attitude of congressional Republicans towards Reconstruction, he cites Benedict for there was much agreement among Republicans on fundamentals. ID. 37 It is true that they were united in abolishing slavery, but radical attempts to go much further were rejected. Benedict concluded that the radicals did not dominate Congress during the Reconstruction era. More Republicans, scaled consistently, conservative than radical, in the House consistent non-radicals, conservative and centrists, still outnumbered radicals. Benedict, Super at 27, 23. Benedict notes that Senate Reconstruction policy after 1865 was framed by Anon. Is confirmed by the defeat by a vote of 125 to 12 in the House and 34 to 4 in the Senate of radical insistence that Tennessee provide for Negro suffrage. 98 What Senator Sumner insisted was the only sufficient guarantee for black security. 99 This was after the submission of the 14th Amendment to the ratifiers. It is such votes, not what abolitionists had said outside the halls of Congress, that illuminate the framers' intent. Senator Sherman told a Cincinnati audience in September 1866, during the ratification campaign, that we defeated every radical proposition in it, 100 an assurance meant to gratify his constituency. 101 Senator. Radical Joint Committee on Reconstruction and a Conservative Judiciary Committee. ID. 37 Between them they fashioned the Conservative Reconstruction Program of the 39th Congress. ID. 146 to 47. David Donald observed that moderates had to check extreme radical proposals or be defeated in the districts they represented. D. Donald, The Politics of Reconstruction 51 to 52, 1965. For similar expressions during the ratification campaign, see Infra Chapter 6 text accompanying Note 66 to 71. See also Bickel, Infra Conclusion Note 6. 97 Donald, Super Note 96 at 51 to 52. Commending the 14th Amendment, Senator Richard Yates said, "If we do not meet the views of the radicals, we at all events have the medium, the moderation which has been agreed upon." Avens 237. Morton Keller stated, "It is true that the specifics of Reconstruction policy were determined primarily by moderate leaders such as Senator Lyman Trumbull and William Fessenden, who sought to limit the degree to which the federal government interceded to protect the civil rights of the freedmen." M. Keller, Affairs of State 61 to 62, 1977. 98 Globe 685. Without suffrage, said Senator Samuel Pomeroy, the Negro has no security. ID. 1182 ID. 3980, 4000. 100 James 167. 101 It was a rather consistent practice to disavow radical influence in framing of the congressional proposal. ID. The New York Herald stated that the amendment is not the platform of Thaddeus Stevens, Sumner, or any of the noisy radicals in Congress. They can do nothing. It was adopted against all their remonstrances and in spite of their threats. NY. Herald, Sept. 28, 1866, quoted in Benedict, Super Note 82 at 198. Fessenden, co-chairman of the Joint Committee, was unwilling to allow the process of Reconstruction to be controlled by the radicals. 102 Taking no notice of these facts, Curtis asserts, Fairman's belief that anti-slavery ideas were limited to the most radical Republicans was simply a mistake. 103 It is Curtis who is mistaken. 102 Kendrick, Super Note 76 at 174. Chapter 6 Some Curtis misconceptions. Let us now consider Curtis' treatment of specific items of evidence. The Civil Rights Act and the 14th Amendment are identical. Originally Curtis asserted that Stevens denied that the amendment and the Civil Rights Bill were identical. That was only partly true. 11 pointed out that this is a misleading version of Stevens' comment on the 14th Amendment. Some answer your Civil Rights Bill secures the same things. That is partly true, but a law is repeatable by a majority. 2 But for that solitary exception, Stevens plainly was not repudiating the general opinion that the Act and the Amendment were identical. Nevertheless, Curtis now repeats that Stevens, manager of the 14th Amendment in the House, denied that the amendment and the Civil Rights Bill were identical. That was, as he said, only partly true. 3 To persist in repeating a palpable half-truth after it has been called to his attention speaks volumes for Curtis' standards of scholarship. He notes statements by some congressmen that the 1 Curtis, Adventures 104 2 Berger, Reply 4, emphasis added, 3 Curtis, Book 103. Amendment incorporated the substantial protections of the Civil Rights Bill, but argues that this excludes the Bill of Rights whereas these provisions are by ordinary use of language laws for security of person and property. 3 For a phrase contained in the bill. When the legislative history discommodes him, Curtis, though ostensibly leaning on the legislative intention, substitutes his own reading of ordinary words. In yet more strained fashion, Curtis argues that the claim that the 14th Amendment is absolutely the same as the Civil Rights Bill is absolutely inconsistent with the language of the 14th Amendment. If the amendment had been designed merely to prohibit discrimination in certain rights that states chose to accord their own citizens, then the due process and privileges and immunities clauses would have been superfluous. To say that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, and property without due process of law is a very odd way of saying that the state is prohibited from discriminating in certain rights it gives its citizens. Point 5 That the 14th Amendment seems to Curtis a very odd way of expressing the framers' purposes cannot overcome the all but unanimous agreement that the Act and the Amendment were identical. 6 Pretending to search for the 4 ID 72, 77, 100, and 4. For ordinary meaning, see Infra Chapter 7 text accompanying Note 5, and Justice Frankfurter, Infra Note 7. 5 ID 11819. 6 Curtis converts the unanimous array of those who considered bill and amendment to be identical, Super Chapter 2 text accompanying Notes 13 to 18, into a few said that die amendment and bill were identical. Curtis, Book 93. This is an improvement on his earlier statement that Berger attempts to tie the privileges and immunities clause of the 14th Amendment to the Civil Rights Bill and to establish their complete identity. Curtis, Reply 8. He simply cannot bring himself to acknowledge framers' intention. Curtis ignores their explanations when it undermines his thesis. **** 7 Privileges or immunities were far from superfluous, they were words of art. 8 That identified the category of rights that were not to be abridged. Justice Harlan, it will be recalled, considered that the privileges or immunities clause was expected to be the primary source of substantive protection, that the due process and equal protection clauses were relegated to a secondary rule. 9 A role I would describe as adjective. The equal protection clause, as its history edge inescapable facts. For emphasis on such identity during the ratification campaign, see Super Chapter 4 text accompanying Notes 17 to 21. 7 What seems very odd to Curtis puzzled the justices not at all. Led by Justice Field, the 4 dissenters in slaughterhouse cases, 83 U.S. 16 Wall. 36, 96, 1872, stated that in the first section of the Civil Rights Act Congress has given its interpretation of these terms privileges or immunities, the right to make and enforce contracts, etc. Although the majority construed the phrase more narrowly, it yet stated in comparing Article 4, 2, and the 14th Amendment that there can be little question that the privileges and immunities are the same in each. ID 75 Justice Frankfurter stated in his concurring Adamson opinion that adoption of the Due Process Clause would be a strange way of saying that every state must thereafter initiate prosecutions through indictment by grand jury, must have a trial by a jury of 12 in criminal cases. 322 U.S. 46, 63, 1947, for which the 5th and 6th Amendments made explicit provision. How very odd of Curtis to swallow so strange a reading. In similarly strange fashion, Curtis argues that the claim that the 14th Amendment clearly supplied power to pass the bill, if anything, supports the conclusion that the amendment was designed to apply the Bill of Rights to the states, relying on the fact that Wilson, Thayer, and Bingham all analyzed the bill as an attempt to enforce the Bill of Rights, specifically the Due Process Clause of the 5th Amendment. Curtis, Book 109, emphasis added. But incorporation of one provision excludes wholesale adoption of all the others. See Infra Note 43. 8 Infra Chapter 7 text accompanying Note 10. Oregon v. Mitchell, 400 U.S. 112, 163, 164, 1970. Discloses, embodied the Act's prohibition of discrimination with respect to the rights there specified 10 privileges or immunities. And the Due Process Clause afforded access to the courts for protection of those rights. What is very odd about that? Instead of employing the negative no discrimination of the bill, the amendment offered to blacks the same described rights as whites enjoyed, accompanied by enforcement. Suppose, Curtis argues, the amendment and the bill were identical. If they were, it follows that the Civil Rights Bill included a federal standard of due process. 11A Federal Standard of Due Process is a construct of the modern court, as yet hidden from the minds of the framers. 12 In Walker v. Savinet, a decision contemporaneous with adoption of the amendment, the court declared that due process in the states is regulated by the law of the states. 13 Next Curtis asserts that since the bill made all persons born in the United States citizens, they would have all the rights E-F citizens, rights that most Republicans who spoke on the subject believed included the protection of the Bill of Rights liberties against infringement by the states. 14 But those liberties were in fact protected only against the federal government, not the states. And Curtis overlooks that the bill did not merely confer citizenship, it went on to specify certain rights that the newly made citizens would enjoy. 15. 10 Infra Chapter 8 text accompanying Notes N, 12, 20, 24, see also Berger, Judiciary 166-92. Curtis, Book 104 12 see Super Chapter 1 text accompanying Notes 20 to 28. 1392 U.S. 90, 93, 1875. See Infra Chapter 8 text accompanying Note 95. 14 ID 104, emphasis added. Curtis ignores the framers' repeated rejection of proposals to bar all discrimination. See Berger, Judiciary 163-164, in for conclusion text accompanying notes 1-3. 15. Curtis acknowledges that the Civil Rights Act listed certain specific rights, such as the right to testify and to hold property. These were justly described by Georgia v. Rachel as a limited category of rights, and that the framers repeatedly rejected proposals to prohibit all manner of discrimination. 16. The perils of reliance on definitions of citizenship are illustrated by a Democrat's appeal to Webster's dictionary definition of a citizen as one who had the privilege of exercising the elective franchise. 17. Yet we have it from Senator Jacob Howard, a pivotal Curtis authority, that 3/4 of the states of this union could not be induced to vote to grant the rights of suffrage to the colored race. 18. That the grant of rights resided in the discretion of the states was made unmistakably clear by Samuel Shell Berger, a vigorous proponent of the Civil Rights Bill. If this section did in fact assume to confer or define or regulate these civil rights, which are named by the words contract, sue, testify, inherit, and see, then it would be an assertion of the reserved rights of the states and the people. But, sir, except so far as it confers citizenship, it neither confers nor defines nor regulates any rights whatever. Its whole effect is not to confer rights under local law. It is natural to read the general words in light of the specific ones. Curtis, Book 103. It is more than natural, it is a long established rule of law. Specific words prevail over the general in the same or another statute which might otherwise be controlling. Ginsburg and Sons v. Popkin, 285 U.S. 204, 208, 1932. See also Forco Glasgow v. Transmura Products Corp. 353 U.S. 222, 1957, and see Infra Chapter 8 Note 7, and Madison, 3 Farren 366. 16 384 U.S. 780, 791, 1966, Berger Judiciary 163-64, Infra Conclusion text accompanying notes 1-3. 17 Bond 451. Trumbull told the Senate that the granting of civil rights does not carry with it political privileges. A man may be a citizen in this country without a right to vote. The right to vote depends upon the legislation of the various states. Avens 197. I8 Avens 220, emphasis added. In the House, Wilson said that had it been supposed that the 13th Amendment authorized Congress to regulate suffrage, it would never have passed Congress, never have received the sanction of the states. ID 173. Or regulate rights, but to require that whatever of these enumerated rights and obligations are imposed by state laws shall be for and upon all citizens alike without distinction based on race or former condition of slavery. 19 Curtis finds these remarks qualified and ambiguous, as if the bill merely encompassed equal protection. 20 E4 gets the opening phrase of the bill, there shall be no discrimination in civil rights and immunities. Although these words were deleted upon Bingham's insistence that they were oppressive and unduly encroached on the state's domain. 21 The remainder of the bill shows that the ban on discrimination remained the goal. 22 Curtis is critical of Shell Berger because he seems to have felt that states could continue to refuse to allow married women to testify after the passage of the bill. Such a rule of law seems to be the very denial of due process forbidden by the Civil Rights Bill in the case of blacks and by the 14th Amendment in the case of all persons. 23 Since, however, the bill outlawed discrimination only on account of race, it did not apply to women. Speaking to the 14th Amendment, Senator Jacob Howard, one of the pillars of Curtis' thesis, stated that by the law of nature women and children were not regarded as the equals of men. 24 At this time it was accepted that a woman's place. 19 Avens 188. Shell Berger also said that the bill is not meant to usurp the powers of the states to punish offenders generally against the rights of citizens in the several states, but its whole force is expended in defeating an attempt, under state laws, to deprive races and the members thereof as such of the rights enumerated in this act. This is the whole of it. Avens 189. 20 Curtis, Book 78. 21 Super Chapter 2 text accompanying notes 29-32. 22 ID. Text accompanying note 26. 23 Curtis, Book 78, emphasis added. Was in the home. Soon the court held that the amendment did not require a state to admit a woman to the bar. 25 Against this background Curtis concludes that the inescapable implication of the assertion that the Civil Rights Bill and Section I of the amendment are identical is that at least some of the rights in the Bill of Rights applied to the states prior to the passage of the 14th Amendment. 26 This makes identical turn somersaults. No reference to the Bill of Rights is to be found in the history of the Civil Rights Bill, so Curtis would read back into the Bill rights that were first discovered in the amendment by the modern court. In stating that the amendment was identical with the bill, the framers merely meant that the amendment did not go beyond the bill. They did not intend to expand the scope of the amendment by identifying the amendment with the bill. Bingham's rejection of the oppressive ambit of civil rights and immunities alone would bar Curtis' unfounded inference. Finally, when some proponents of the amendment observed that Section I simply reenacts what is already in the Constitution, Bond concluded, they had in mind the Privileges or Immunities Clause of Article 4 rather than the Bill of Rights. There is no record in Pennsylvania, Ohio, or Illinois of any advocate of the 14th Amendment explaining that the privilege 25 Bradwell v. State, 83 U.S. 16 Wall. 130, 1872. Justices Bradley, Swain, and Field concurring, said, the natural and proper timidity of and delicacy which belongs to the female sex unfits it for many occupations of civil life. ID. 100. 26
about other causes of firefighter deaths, such as stress, falls, and product of combustion, but not the fireground danger of sudden burning building
collapse.
Tended to curtail
state sovereignty further by making the Bill of Rights applicable to the states. 28 Selective incorporation. Curtis proffers some historical proof that the framers contemplated selective incorporation. I have found over 30 examples of statements by Republicans during the 38th and 39th Congresses indicating that they believed that at least some Bill of Rights liberties limited the states. I found no statements by Republicans indicating that the states were free under a proper understanding of the law to violate rights in the Bill of Rights. The often expressed idea that the amendment protected fundamental rights could provide a basis for selective incorporation. 29. Given Howard J. Graham's concession that radical Republican views were frankly heretical in Curtis' words, radically unorthodox. 30 The conversion of the majority is not to be assumed but must be proved. As Leonard Levy wrote in similar case, there is no reason to believe that Bingham and Howard expressed the views of the majority of Congress. 31 The framers' careful employment of words of art but for equal protection argues to the contrary. Curtis himself is troubled by their explicit provision for some cases but none for incorporation of the Bill of Rights. 32 Let us consider Curtis' arguments seriatim. That some 28 see Super Chapter 5 text accompanying notes 42 to 46, and see Judge Posner, Super Chapter 1 note 55. 29 Curtis, Book 112, emphasis added. 30 ID. 126, see also Super Chapter 5 notes 93, 95, 100, Infra Chapter 7 text accompanying note 46. 31 L. Levy, Judgments, Essays on American Constitutional History 77, 1972. 32 Infra Chapter 7 text accompanying notes 48 to 54. Republicans thought some Bill of Rights liberties limited the states. Raises the question, did the speakers agree on which liberties? Among the abolitionists, upon whom Curtis heavily relies, there was general agreement. 10 Broke found only about the Due Process Clause and the First and Fourth Amendments. 33 10 Broke denied that all abolitionists put forward all the first 8 amendments to combat all phases of slavery. They certainly did not. 34 Nor may we deduce a general agreement that future interpreters would be left selectively to incorporate their favorite provisions. Of such an agreement there is no hint. Curtis' appeal to fundamental rights as a basis for selective incorporation stands no better. Fundamental rights, as will appear, were associated by those who explained the Civil Rights Bill with the limited category of rights protected against discrimination by that bill, not by the Bill of Rights. 35 What could be a more proper understanding of the law than the Supreme Court's long-standing decision in Barron v. Baltimore that the Bill of Rights does not apply to the states? Non-abolitionist lawyers familiar with Chief Justice Marshall's opinion, read to them by Bingham 36 had no occasion to question whether the states were free to violate a law that did not apply to them. Then 2. Curtis 2 Bell. Weathers, Senators Howard and Bingham, whose views, Curtis considers, are entered to very great weight. 37 Read against selective incorporation. Howard stated that to these privileges and immunities should be added the personal. 33 Jacobus 10 Broke, equal under law 127, 1965. The rights in the other amendments, 10 Broke wrote, received only casual, incidental, and infrequent reference. ID. 127-34 ID. 126 to 2735 Infra Chapter 8 text accompanying notes 141. 36 Avens 157, J.A. Rights guaranteed and secured by the first 8 amendments. 38 Curtis recognizes that Howard's speech militates strongly in the direction of full incorporation. 39 Bingham referred to this immortal Bill of Rights, and asked, is the Bill of Rights to stand in our Constitution? A mere dead letter. 40 Curtis considers that Bingham referred to the first 8 amendments. 41 Here is still another conflict, between those who were for full incorporation and those who spoke of differing select rights, a conflict that renders the several Republican remarks inconclusive evidence of original intention. On the basis of this melange Curtis charges Judge Friendly with disregard of virtually all the evidence. 42 In truth, the framers did their own selective incorporation. Out of the Bill of Rights they selected and incorporated the Due Process Clause in the 14th Amendment, and under the long-established rule that mention of A excludes the unmentioned B, reinforced by the Joint Committee's rejection of the Just Compensation Clause of the Bill of Rights. 43 They thus barred attribution to them of an intention to license selective incorporation of other items of the Bill of Rights. 38 Avens 219. 39 Curtis, Book M. 40 Avens, 150, 158. 41 Curtis, Book number 42 ID. H2. 43 Expressio Unius est exclusio ald ius, United States v. Arredondo, 31 U.S. 6 Pet. 691, 725, 1832. In the Pennsylvania Ratification Convention, James Wilson said that if the enumeration is not complete, everything not expressly mentioned will be presumed to be purposely omitted. 3. Max Farrand, Records of the Federal Convention 0/1787 144, 190. Egbert Benson said in the First Congress, "It cannot be rationally intended that all offices shall be held by good behavior, because the Constitution had declared one office to be held by this tenure." 1 Annals of Congress 505, and C. Alexander White, ID. 517 C. Infra Chapter 8 Note 8. The 14th Amendment as a criminal code. We have seen James Wilson's assurance, for example, that we are not making a general criminal code for the states. 44 Curtis comments that a code specifies offenses such as larceny and fornication. 45 Let a code of criminal procedure suffice. Judge Flenry friendly ended his critique, the Bill of Rights as a code of criminal procedure. 46 Justice Frankfurter wrote that the 14th Amendment is not the basis of a uniform code of criminal procedure federally imposed. 47 To Fairman's argument that the country would not have tolerated having the federal provisions on grand jury, criminal jury, fastened on them in 1866, Curtis retorts that it ignores the realities of the political process, because the 1866 campaign dealt with gut issues, example the political power of the rebellious southern states, racism, and protection for loyalists in the South. Those were issues that could and did defeat politicians. No politician is likely to be defeated for advocating grand juries, criminal juries of 12, etc. Fairman's argument, he continues, assumes that Republicans in state legislatures would allow the South. For Curtis, rejection of the just compensation proposal by the Joint Committee does not rank nearly as high as Howard's intimation that the amendment would overturn court decisions holding that the states could take private property without just compensation. Finally, American courts had held that the law of the land clause or due process clause of state constitutional law prohibited taking without just compensation. Curtis, Book 85. His preference for what Howard implied over the vote of the Joint Committee of both houses illustrates how he tailors his cloth to fit his thesis. 44 Globe 220. See also Shell Berger, Super Note 19, Bingham, Super Chapter 2 Text accompanying Note 29. 45 Curtis, Book 125. 4655 California. Lee Rev. 929, 1965. 47 Felix Frankfurter, Law and Politics 192-93, 1939. A dramatic increase of political power by counting disenfranchised blacks for the purposes of representation rather than provide for jury trials in civil cases where the damages exceed $20. Politicians do not behave in this fashion. 48 This sets up a false issue and a false antithesis. Local control over criminal administration was and remains a gut issue, YMS continuing adherence to the state's death penalties notwithstanding the court's crusade to abolish and hobble them. Curtis would be hard-pressed to name one northern politician who openly preferred federal to state control of criminal and civil administration in his own state. 49 Nor was the North faced by a choice between a federal takeover of local criminal administration and a contraction of southern representation geared to black disenfranchisement. For the latter, 2 provided for a pro-rata diminution of representation, while 1 provided for a due process trial which northerners desired to secure to southern blacks. Politicians were not faced by a distressing choice between the two, they were in tandem. The issue, rather, is whether the North was apprised that the amendment called upon it to surrender state control of criminal administration. Security of person and property. Curtis sets great store on the penultimate clause of the Civil Rights Bill, equal benefit of all laws and proceedings. For 48 Curtis, Book 105. 49 Justice Frankfurter, concurring in Adamson v. California, 332 U.S. 46, 64, 1947, stated, "It could hardly have occurred to these states which had no rigorous grand jury requirement that by ratifying the amendment they had uprooted their established methods of prosecuting crime and fastened upon themselves a new prosecutorial system." Chief Justice Chase feared that even loyal people in the northern states might oppose the amendment because of its threat to states' rights. James N. 8. See Super Shell Berger Note 19, and Chapter 5 text accompanying Notes 23-32. The security of person and property. He insists that the provisions of the Bill of Rights are, by ordinary use of language, laws for security of person and property. 50 Now the guarantee of security of person and property responded to the acts of cruelty, oppression, and murder whereby the South terrorized the freedmen. 51 Such offenses gave rise to rights under state law as Bingham recognized. 52 Existing law held the Bill of Rights inapplicable to the states, so it is idle to invoke the ordinary use of language, a treacherous guide to legal terms. Law does not mean dissenting abolitionist opinion. Then there is Bingham's insistence that state sovereignty demanded deletion of the word civil rights, which followed in order to forestall a latitudinarian construction not intended. 53 To make security of person and property the vehicle of that very construction would be to kick the devil out the door and let him return through the window. Courts will avoid an unreasonable construction, one that is plainly at war with the purpose of the draftsman. 54 Again, Shell Berger stated that the right to contract, sue, testify, and see was necessary for the protection of the rights of person and property. 55 Such specification and more. Then too, Thayer said that the rights enumerated in the Civil Rights Bill preclude the extension of the Gen 50 Curtis, Book 72, ID. 77, 104. 51 See Super Chapter 2 Note 19. 52 Bingham, Super Chapter 2 text accompanying Note 45. See Hamilton Super Chapter 2 Note 29. 53 Super Chapter 2 Text accompanying Notes 29 to 31. 54 North American Utility Securities Corp. V. Posen, 176F. 2D 194, 196, 3 DCIR. 1949, Wilson stated that his amendment strikes out all of these general terms. Super Chapter 2 Text accompanying Note 31, emphasis added. Arrow words beyond the particulars which have been enumerated. 56 Curtis would distinguish this on two grounds. I. Thayer was engaged in denying that the words civil rights and immunities included the state law right to vote. The deletion of the civil rights phrase and enumeration of specified rights rendered it unnecessary to state that other rights were excluded. 2. While asking why these fundamental rights should not be extended to the freedmen, Thayer concluded why should they not have full and equal benefit of all laws and proceedings for the security of person and property. 57 The reasonable inference is that Thayer considered that laws and proceedings for the security of person and property were synonymous with these fundamental rights. Thayer was not expressly circumscribing one generality only to replace it by an even more unlimited one, as Wilson confirmed, to obviate any other construction beyond the specific rights named in the section. Our amendment strikes out all of those general terms and leaves the bill with the rights specified in the section. 58 Although the penultimate clause was not physically stricken, the intention to confine the bill to the specified words governs. Curtis, it will be recalled, summons the original intention for his thesis. Consider Curtis' paraphrase of William Lawrence's comment on the Civil Rights Bill that citizens have certain absolute rights including personal security, personal property, and liberty, and that the Bill of Rights declared that no person should be deprived of life, liberty, or property without. Curtis, Book 7957 ID. 79-80, emphasis in original. 58 Avens 191, emphasis added. Curtis notes that John Thomas, like a number of his colleagues, sought to ensure for blacks the rights to acquire and dispose of personal and real property, to testify, and to have just compensation. 59 What weight can be attached to this in light of the Joint Committee's rejection of Bingham's motion to add to the amendment the clause nor take private property for public use without just compensation? 60 Here we have an unimpeachable fact, and Curtis consumes a page to explain the fact away, setting forth some complicated suppositions to demonstrate that the rejection proves nothing except at the time it was submitted the committee found the form of Bingham's proposal deficient. 61 He would rob the unequivocal rejection of meaning by sheer speculation. That the rejection went beyond form is attested by the fact that just compensation never did find its way into the amendment. And the rejection of just compensation again testifies that the framers were loath to interfere with control over local matters beyond a limited category set forth in the Civil Rights Act. Late in the discussion of the amendment, Senator James Patterson, who voted for it, declared, "I am opposed to any law discriminating against them. Blacks in the security and protection of life, liberty, person, and property, and the proceeds of their labor. Beyond this I am not prepared to go." 62 Plainly Patterson, unlike Curtis, did not understand life, liberty, and property to be of unbounded scope. 63 Their life, liberty, and property protected by the same laws that protected whites. Curtis, Book 54. Whites were not protected against state action by the Bill of Rights. 59 Curtis, Book 77. 60 ID. 84, Bickle 42. 61 Curtis, Book 84. Globe 2699. 63 For similar remarks, see Berger, Judiciary 170-71. As has been noted, the framers meant to protect the blacks from outrage, terror, and oppression. Super Chapter 2 Note 119, Chapter 4 Note 9, Info text accompanying Notes 95-76. Ratification debate. Curtis devotes a chapter the amendment before the states to the subject. He takes no account of Senator Sherman's statement in September 1866 to a Cincinnati audience that we defeated every radical proposition in it. 64 Nor does he notice the statement in the New York Herald of September 28, 1866, that the amendment is not the platform of Thaddeus Stevens, Sumner, or any of the noisy radicals in Congress. They can do nothing. It was adopted against all their remonstrances and in spite of their threats. 65 It was, said Joseph James, a rather consistent practice to disavow all radical influence in the framing of the congressional proposal. 66 Earlier the Chicago Tribune, a radical paper, considered that the proposed amendment might be a good election platform even if it failed to represent radical principles. 67 Bond, echoing Benedict, observed that radicals did not control the Republican Party. H.A.B. Ing failed to shape the amendment entirely to their liking, the radicals accepted one as a compromise. 68 For this we need go no further than Curtis' oft-cited radical, Senator Yates, who said of the amendment, "We have the medium between extremes. If we do not meet the views of the radicals, we have at all events the medium, the moderation which has been agreed upon." 69 These statements should dispose of Curtis' reliance on the beliefs of some radicals in the rankly heretical abolitionist views. Curtis notes a common theme in messages by the Gover. 64 James 167-65 M. L. Benedict, A Compromise with Principle 198, 1975. James 167-67 ID. 134. Nors was that the amendment would protect the rights or liberty 5 of citizens in the United States, but remarks that the messages are silent on exactly what rights the governors thought were encompassed by the phrase rights of citizens of the United States. Except for the governor's insistence that the amendment would protect liberty, they failed to discuss its legal effect. 70 But this is of no moment, he claims, because the messages are fully consistent with an intent to apply the Bill of Rights to the states. To read the messages as inconsistent with that goal, one has to assume that references to the rights of citizens of the United States, or to Liberty 5 exclude the liberties in the Bill of Rights. 71 Curtis erroneously shifts the burden of proof. He would require critics of incorporation to prove the negative, that the terms do not include the Bill of Rights, before he proves the intention to incorporate it. Since application of the Bill of Rights to the states drastically curtails the right of the northern states to control their own internal affairs, that purpose has to be proved, not assumed. What Chief Justice Marshall said of such extraordinary intervention remains true today. Had the 1866 framers contemplated it, they would have declared their purpose in plain and intelligible language. 72 In an opinion contemporary with adoption of the 14th Amendment, Justice Miller rejected a construction that would subject state to the control of Congress, in the exercise of powers heretofore universally conceded to them in the absence of language which expresses such a purpose too clearly to admit of doubt. 73. Curtis' argument is replete with citations to the pursuit. 70 Curtis, Book 146-47. 71 ID 147-72 Super Chapter 1 Text accompanying Note 9. 73 Slaughterhouse Cases, 83 U.S. 16 Wall 36, 78, 1872. Of Happiness, 74 Which in his hands becomes an overflowing cornucopia. Protection was not a vague abstraction for the North, it spelled protection against flogging and outrage in the South. 75 Let Curtis' own witness, William D. Kelly, speak. Northerners could go south, Kelly said, but once there they could not express their thoughts as freemen and receive the protection they were entitled to as citizens of the Republic. 76 Nor was liberty enigmatic, but as stump speakers were apt to explain, it meant the right of locomotion, the right to go where they please and own property where they please. 77 Made necessary by the black codes which would chain blacks to their hovels. 78 It serves no useful purpose to beat a tattoo on the phrase pursuit of happiness. 79 Without explaining what it embraces. Happiness obviously is a protean term, one man's meat is another man's poison. It means one thing to rock music fans who flock to a multi-decibel discotheque and something else again to the luckless neighbors. Realizing that happiness is too vague to be enforceable, Justices Field and Bradley sought to tie it to identifiable rights. Field declared that by the right of men to pursue happiness is meant the right to pursue any lawful business or vocation. A.D. Bradley stated, the right to follow any of the common occupations of life is an undeniable right. It was formulated as such under the phrase pursuit of happiness in 74 Curtis, Book 07, 132, 142-49. 75 Bond 443, 449, Avens 131, 199, Super Chapter 4 Note 9. 76 Curtis, Book 138. The failure of the Southern state governments to protect the freedmen had outraged the Unionists. Bond 448. 77 Bond 448, see also Wilson, Super Chapter 2 Text accompanying Note 24. 78 For brutal examples, see Avens, 95, 109, 121, 135, 136, 149, 168, 171, 199. 79 Curtis, Book 117, 132, 142, 149. 80 Butchers Union Co. v. Crescent City Co., M.U.S. 746, 757, 1884. The Declaration of Independence. 81 It is food for thought that with the pursuit of happiness before them, the framers clung to the traditional triad life, liberty, and property. For they were bent on safeguarding the protection of person and property. 82 Nothing more. Curtis citations do not compel a contrary conclusion. Columbus Delano said in Ohio on August 31, 1866, that one provides that the privileges and immunities of these citizens shall not be destroyed or impaired by state legislation, and it provides that no man shall be deprived of life, liberty, and property without due process of law. I know very well that the citizen of the South and of the North going south have not hitherto been safe in the South, for want of constitutional power to protect them. 83 Delano confirms that the mischief was violence in the South, from which citizens must be protected. Protection in its primary, concrete sense save the freedmen from lynching. Delano, moreover, was opposed to conferring upon blacks the right of being jurors, and he did not believe that the rights of the states are utterly overwhelmed and dethroned. 84 In fact, he inveighed against an authority to go into the states and manage and legislate with regard to all the personal rights of the citizens' rights of life, liberty, and property. 85 Another Curtis witness is General John Alexander Logan, Republican candidate for Congressman at large from Illinois, who suggested that the rights of citizens include 81 ID. At 762. See, example Wyndham, Avens 171, Super Text accompanying Note 75-77 Madison's proposed Bill of Rights had a happiness phrase, but it did not survive one Annals of Congress 434. Curtis, Book 138-39. The right to own property, to sue, and to protection of life, liberty, and property. 86 William Gillette considers that he was a wily Republican politician from anti-Negro Southern Illinois, who wanted to scrap the Negro office holding guarantee, no doubt accurately reflecting the will of his constituency. 87 And who said, the Negro equality talk against. The amendment is all a bugbear and humbug. I don't consider a nigger my equal. 88 Thus Logan is a most unlikely witness for a broad construction of the amendment. Then there is Senator Richard Yates of Illinois, who asked, do you suppose any of you can go south and express your sentiments freely and in safety? No. We will rally around the flag, shouting the battle cry of freedom. His remarks, Curtis recounts, were met with tremendous applause. 89. Earlier, Yates had proposed that no state shall, in any manner, recognize any distinction on account of race, but was decisively voted down, 38 to 7.90. Notwithstanding, he voted for the amendment as the Council of 86 Curtis, Book 131, 132. 87 William Gillette, The Right to Vote, Politics and the Passage of the 15th Amendment. 68, 1965. 88 Bond 467. Bond notes that Illinois, Indiana, Iowa, and Ohio prohibited or severely restricted Negro migration and settlement within their boundaries. ID 441 Note 33. Senator Sherman stated in 1867 in Ohio, we do not like Negroes, we do not conceal our dislike. C.V. Woodward, Seeds of Failure in Radical Race Policy, in New Frontiers of the American Reconstruction. 128, H. Hyman ed. 1966, Senator Henry Wilson, a Massachusetts radical, acknowledged that there is not a square mile in the United States where the equal rights and privileges of the colored man has not been in the past and is not now unpopular. Kong. Globe, 40th Cong, 3d Ses. 672, 1869. Bond observes that the Democrats chose to run against the nigger, and Republicans were constrained to defuse the racist attack. Bond 441, 442. 90 Globe App. 98, Globe 1287, emphasis added. Moderation, even though it did not meet the views of the radicals. 91 He was well aware that the moderation which has been agreed on. 92 Overcame any radical speeches to the contrary. Thus Curtis' own witnesses undermine rather than advance his cause. And his incessant reiteration of generalities is oblivious to the truth encapsulated by justice. Frankfurter, it's the details that determine judgment. Generalities don't amount to a hill of beans. 93 Barron v. Baltimore Chief Justice Marshall held in Barron v. Baltimore, it will be recalled, that the Bill of Rights did not apply to the states. Curtis' chief authority, John Bingham, recognized that as ruled the existing amendments are not applicable to and do not bind the states. 94 Curtis states, however, that leading Republicans believed that the Bill of Rights were already binding on the states. 95 Although he notes Republicans' recognition that their views were unorthodox. 96 And some believed that a constitutional amendment was required to correct Barron v. Baltimore. 97 A conflict of opinion to say the least. Curtis avers that Bingham did not agree that Barron v. Baltimore had been correctly decided because he believed the states were required to obey the Bill of Rights. By the oath state officers took to support the Constitution. 91 Avens 237. 92 ID 93 Harlan B. Phillips, Felix Frankfurter Reminiscences 198, I-960. 94 Avens 158. 95 Curtis, Book 124. 96 ID. 52, see also Supertext accompanying Note 31. 97 Curtis, Book 233 Note 201. 98 This is a pretty example of circular reasoning. Only if the states were bound by the Bill of Rights did the oath come into play. Hence, Kroski tells us, Bingham actually drew a draft of I of the amendment upon the assumption that his own constitutional ideas and those of some of his Republican brethren and not the Supreme Court's constitutional decisions, were the standing law. 99 One may not assume that the framers overruled a constitutional decision sub silentia. When they deemed it necessary to overrule Dred Scott, the framers, Curtis notices, explicitly wrote national citizenship into the 14th Amendment. 100 In truth, Bingham was utterly confused as to what Barron v. Baltimore held. He believed, Curtis tells us, that the rights in the Bill of Rights were protected from state infringement by the Privileges and Immunities Clause of Article 4, Section 2. Still he was aware of decisions like Barr. Ron v. Baltimore to the contrary. 101 Barron, however, held that the Bill of Rights did not apply to the states. It said nothing whatsoever about Article 4. That article, moreover, had nothing to do with the Bill of Rights, which came into being after the Constitution was adopted. And it provided only that visitors from a sister state should enjoy Sir 98 Curtis, Adventures 100. William Kroski, Charles Fairman's Legislative History and the Constitutional Limitations on State Authority, 22 U. Ch. L. Rev. 25, 1954, emphasis in original. Among the several defects contained in Bingham's proposal of February 26, 1866, Curtis remarks, was the assumption that Bingham's views and those of a number of his colleagues not the decisions of the Supreme Court, accurately stated the law. The proposal assumed without providing explicitly that contrary to Dred Scott free blacks were citizens of the United States. Curtis, Book 62-63. 100 Curtis, Adventures 97. 101 Curtis, Book 61. Obtain rights of a resident in the host state. Under Barron, the resident himself did not enjoy the protection of the Federal Bill of Rights. Section 5 of the 14th Amendment. Curtis would rob 5 of the 14th Amendment of its meaning. Republicans, he writes, repeatedly said that the passage of the amendment put enforcement of its principles beyond the power of congressional majorities. These statements clearly presuppose judicial enforcement. 102 The amendment, to be sure, disabled future congressional majorities from repealing its principles. But its 5 provides that the Congress shall have power to enforce by appropriate legislation the provisions of this article. And in 1879 the Supreme Court declared that it is not said that the judicial power shall extend to enforcing the prohibitions and protecting the rights and immunities guaranteed. Congress is authorized to enforce the prohibitions by appropriate legislation. 103 102 ID. 130, emphasis added. 103 Ex Part Virginia, IOOUS. 339, 345, 1879. Joseph James concluded that there was little inclination to bestow new powers on the judiciary, but rather to lean on augmented power of Congress. James 184. Henry Monahan wrote, I am unable to believe that in light of the then prevailing concepts of representative democracy, die framers, or ratifiers of one intended the courts, rather than the national legislature pursuant to 5, to weave the tapestry of federally protected rights against state government. H. Monahan, The Constitution Goes to Harvard, 13 Harv. Cr. and Cl. L. Rev. 113, 124, 1978. Curtis citations do not pretend to counter these pronouncements. Curtis, Book 251 Note 295. Thus Garfield merely stated that the amendment would place the Civil Rights Bill beyond the possibility of repeal, put it above the reach of political strife. Avens 213. Senator Howard X. Plain that it was the purpose of the amendment to give validity to constitutional power to enact the bill. Avens 228. Neither citation has the remotest relevance to judicial enforcement. The literal terms of 5 are confirmed by Reconstruction history. Senator Oliver Morton adverted in 1872 to the great fact that the remedy for violation of the 14th and 15th Amendments was expressly not left to the courts. The remedy was legislative, because in each the amendment itself provided that it shall be enforced by legislation. 104 The reason is not far to seek. From at least Dred Scott onward the court was in ill repute. Bingham stated that the court had dared to descend from its high place in the discussion and judgment of purely judicial questions to the settlement of political questions which it has no more right to decide for the American people than has the court of St. Petersburg. 105 104 Cong. Globe, 42c. Cong, 2d Session, 525, 1872. For additional citations, Cr. Berger, The 14th Amendment, Light from the 15th, 74 NW. UL. Rev. 311, 351 Note 242, 1979. Curtis states, Berger argued that the amendment was to be enforced by Congress only, not the courts. Curtis, Book 128, again reducing incontrovertible facts to Berger argues. Emphasis added. Of course, Congress could delegate enforcement of its legislation to the courts. 105-6 Charles Fairman, History of the Supreme Court of the United States. Chapter 7 of Privileges or Immunities. The argument that the framers of the 14th Amendment intended by the Privileges or Immunities Clause to incorporate the Bill of Rights is central to Curtis' thesis. He conceded that his thesis is intensely controversial. It has never, for instance, been accepted by the United States Supreme Court. 1. And he confessed that it is difficult to show that Republicans read the original Privileges Clause of Article 4, 2, to require the states to obey the Bill of Rights. 2. His goal was to find the probable Republican understanding of a question to which they devoted comparatively little direct attention. 3. Curtis approaches privileges or immunities with some individual theories of construction. He considers that the words are a natural way to describe the rights in a Bill of Rights. 4. On the other hand, just as Frankfurter declared, those reading the English language with the meaning it ordinarily conveys would hardly recognize the 14th Amendment as a cover for the various explicit provisions of the first 8 amendments. 5. The explicit adoption of one phrase due process from the 8 amendments. Curtis, Book 2. 2. Curtis, Reply 57. 3. Curtis, Book 15-16. 4. Curtis, Rep. $48. 5. Adamson v. California, 532 U.S. 46, 63, 1947. 91. Would lead a reader to ask why such particularity if all 8 were tacitly adopted. Bingham explained that he drew the terms from Article 4, 2, of the original Constitution. 6. Since the Bill of Rights was added later, Article 4, 2, could not comprehend the as yet unborn disregard of these Inces leads Curtis to say that James Garfield believed that the Bill of Rights limited the states, quoting Garfield, "Citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states." 7. The language of Article 4, 2, not of the Bill of Rights. Nor did Trumbull indulge in a natural reading. Instead, he first read the relevant judicial constructions and said in lawyer-like fashion, this being the construction as settled by judicial decisions 8 and William Lawrence concede D that the court citing Abbott and Corfield have by construction limited the words all privileges to mean only some privy legs. 9. In modern terminology, the terms had become words of art. The Supreme Court stated in similar case, we should not assume that Congress used the words in their ordinary dictionary meaning when they had already been construed as terms of art carrying a special and limited connotation. 10. By substituting his natural meaning for their technical connotation, Curtis is changing the rules to suit his needs. Curtis' rejection of facts that do not fit his preconceived notions is strikingly exemplified by his treatment of the question whether Article 4, 2, was confined to migrants. 6. Curtis, Book 57, 62. So he was understood by William Higbee, a Roddy Cal. He thought that Article 4, 2, and the Fifth Amendment Due Process Clause constituted precisely what will be provided by the Bingham Amendment. Avens 152. 7. Curtis, Book 51 to 52. 8. Avens 122, emphasis added. 9. ID 207, emphasis added. 10. Yates v. United States, 354 U.S. 298, 319, 1957. From another state. He frames the issue by paraphrasing what Berger believed to be the conventional understanding. The clause was, Berger asserted, not intended to control the powers of state governments over the rights of their citizens, but simply to ensure that a migrant citizen would enjoy the basic rights a state accorded to its citizens. Because blacks were not usually migrants, the clause as conventionally understood, was of no help to them. 11. It was not merely Berger who alone believed and asserted. The antecedent of Article 4, 2, was Article 4 of the Articles of Confederation, which provided for free ingress and regress to and from any other state. Passing on Article 4, 2, of the Constitution, Abbott v. Bailey declared that it can be applied only in cases of removal from one state to another. 12. Corfield likewise referred to the right of a citizen of one state to pass through, or to reside in, any other states. 13. Senator Trumbull advised the Senate that the cases relate entirely to the rights which a citizen in one state has on going into another state, and not to the rights of the citizen belonging to the state. 14. As Curtis notes, William Lawrence stated, citizens removing from one state to an other were entitled to the privileges that persons are entitled to in the state to which the removal is made. 15. Two contemporary decisions confirm this understanding. Paul v. Virginia said that Article 4, 2, gives to citizens of one state the right of free ingress into other states, and egress from them. 16. Shortly thereafter, the Slaughterhouse. 11. Curtis, Book 114, emphasis added. 12. Super Chapter 3 text accompanying Note 10. 13. Super Chapter 3 text accompanying Note 14. 14. Avens 137, emphasis added. Cases quoted from Corfield that Article 4, 2, threw around privileges and immunities no security for the citizen of the state in which they were claimed and exercised. Its sole purpose was to prevent discrimination against out-of-state citizens with respect to rights granted to its own citizens. 17. Although Justice Field dissented from the narrow view of the majority of 5 in the Slaughterhouse cases respecting the scope of privileges or immunities, he too observed that what Article 4 did for the protection of the citizens of one state against the hostile and discriminating legislation of other states, the 14th Amendment does for the protection of every citizen of the United States against hostile and discriminating legislation against him in favor of others, whether they reside in the same or different states. 18. To disparage such undeniable facts by labeling them Berger's beliefs and assertions, and by prejudicially asserting that Dred Scott, of course, had limited the clause to protection of temporary visitors from another state. 19. Is Dipler able advocacy? It was precisely because Article 4, 2, did not protect the resident emancipated black that the Privileges or Immunities Clause of the 14th Amendment was made applicable to a citizen of the United States. A leading Democratic opponent, Senator Garrett Davis, understood this full well and therefore proposed to substitute the Article 4, 2 formula, explaining that it would apply only where a citizen of one state goes into another state, whereas, he said, Senator Trumbull proposes now to apply this bill where the citizen is domiciled in the state where he was born. 21,783 U.S. 16 Wall. 36, 77, 1,872, emphasis added. 18 ID. 100-01. Against this, Curtis argues that Bingham and others who framed the 14th Amendment relied on a reading of the Privileges and Immunities Clause of Article 4, Section 2, by which it protected a body of national privileges and immunities of citizens of the United States, including those in the Bill of Rights. This reading may have been incorrect. 21 Curtis compounds Bingham's muddle-headedness, for he cites to Barron v. Baltimore for incorrect. 22 Barron, however, made no reference to Article 4, 2, but held that the Bill of Rights did not apply to the states. Nor could the article comprehend the Bill of Rights because that came into existence after adoption of the Constitution. Incorrect or not, Curtis opines, it does not matter. Because in the redrafting of Bingham's first proposal, the amendment was rewritten to secure privileges and immunities of a citizen of the United States from state abridgment. 23 rewriting, however, underscores that abolitionist assumptions were incorrect and that deficiencies therefore had to be rectified. 24 explicit provision, therefore, did not ratify prior incorrect assumptions. Curtis recounts that Bingham had written an early version of the amendment on the assumption that his Consti 21 Curtis, Book 114. 22 ID. 264 Note 151. 23 ID. 114, emphasis added. Curtis recounts, the final version of Section 1 was rewritten to incorporate this understanding explicitly. ID. 113. 24 The radical Thaddeus Stevens knew that the Constitution is not a limitation on the states. The amendment supplies that defect. Curtis, Book 86. On behalf of the 4 dissenters in slaughterhouse cases who argued for a broader construction of privileges or immunities, Justice Field stated that by virtue of the 14th Amendment, a citizen of a state is now only a citizen of the United States residing in that state. The fundamental rights now belong to him as a citizen of the United States. 83 U.S. At 95, emphasis added. See Field, Supertext accompanying Note 18. Constitutional theories and those of a number of his colleagues, not the decisions of the Supreme Court, were the law of the land. 25 An assumption that his hard-headed colleagues Trumbull and Fessenden hardly shared. 26 When the draftsmen adopted citizen of the United States, they did not endorse Bingham's flawed premise. Rather, they dismissed his unorthodox assumptions by employing specific terms to remedy an undeniable lack. They turned from the privileges of a citizen of each state to those of a citizen of the United States, and all the wishful thinking of Bingham and Co. cannot make the same what they were at pains to differ. In G 8.27 For they made persons born in the United States citizens both of the United States and of the state wherein they reside. Whatever the private meaning that Bingham attached to terms he confessedly borrowed from Article 425 Curtis, Reply 66. Yet Bingham explicitly noted the case of Barron v. Baltimore to show why his amendment was required. Curtis, Book IOI. 26 A heavy phalanx of Republican politicos, including Sherman and Trumbull, were states' rights nationalists, suspicious of any new functional path the nation traveled. H.M. Hyman, A More Perfect Union 312, 1973. Curtis himself acknowledges that Bingham's assumption was a defect. Curtis, Book 62-63. 27 Slaughterhouse Cases, 83 U.S. 16 Wall. 36, 74, 1872, declared that a citizenship of the United States and a citizenship of a state are distinct from each other. That distinction eluded Bingham. The amendment is exactly in the language of the Constitution, that is to say, it secures to the citizens of each of the states all the privileges and immunities of citizens of the several states. It is to secure to the citizen of each state all the privileges and immunities of citizens of the United States in the several states. Avens 160, emphasis added. Curtis' statement that even Berger believed that the Privileges and Immunities Clause of the 14th Amendment went beyond the conventional judicial interpretation of Article 4, Curtis, Book 127, must be confined to the substitution of citizen of the United States for the earlier citizen of the several states. The narrow judicial interpretation of the scope of the Privileges and Immunities Clause was left untouched. Giles Hotchkiss, a New York radical, believed the Privileges or Immunities section was identical to the guarantee already in the Constitution. Curtis, Book 71. C. And the Fifth Amendment, it cannot overcome the settled meaning Trumbull called to the attention of the framers. 28 In evaluating the shift from the Article 4 citizen of each state to citizen of the United States, it bears emphasis that the latter phrase was employed, as Senator Trumbull explained, to end that very controversy, whether the Negro is a citizen or not. 29 It was not designed to broaden the scope of privileges or immunities. So the court declared in a decision contemporary with the adoption of the amendment did not add to the privileges and immunities of a citizen. It simply furnished an additional guarantee for the protection of such as he already had. 30. We are indebted to Curtis for a fascinating glimpse of the operation of Bingham's mind. He calls our attention to go read, if you please, the words of the Constitution itself, Article 4, 2, the citizens of each state, being ipso facto citizens of the United States, shall be entitled to all the privileges and immunities of citizens, supplying the ellipsis of the United States, in the several states. 31 What a charmingly simple method of constitutional revision, no more tortured rationalization, simply supply the ellipsis. Never mind that citizenship of a state is not the same as that of the United States, that to substitute one for the other is to rewrite the Constitution and significantly to alter a citizen's rights. 4. As was said in United States v. Supertext accompanying Note 18. 28 Supertext accompanying Note 8. 29 Globe 1285. Stevens regarded the citizenship provision as an excellent amendment, long needed to settle conflicting decisions. Avens 237. Minor v. Happersett, 88 U.S. 21 Wall. 162, 171, 1874. 31 Curtis, Book 59. Bingham read Article 4, 2, to the House. Avens 157. He considered his ellipsis to be the self-evident meaning of the article. Curtis, Book 61. Citizen of each state does not, however, self-evidently meant citizen of the United States. Justice Miller stated that Article 4.2 did not profess to control the Cruikshank. The rights of citizenship under one of these governments will be different from those that he will have under the other. 32. As we have seen, Curtis originally conceded that it is difficult to show that Republicans read the original Privileges and Immunities Clause to require the states to obey the Bill of Rights. 33. By the time he came to write his book, those difficulties had vanished. Now he could flatly state, most Republicans who spoke on the subject in 1866 believed that the states were already required to obey the Bill of Rights. Even those who did not accept die unorthodox Republican doctrines could agree that the Bill of Rights were privileges and immunities of citizens of the United States that should be shielded from hostile state action. 34. That was not the view of Thaddeus Stevens, the radical leader. The Constitution limits only the action of Congress and is not a limitation of the states. 35. Senator Trump Bull called attention to the judicial constructions of Article 4.2, none of which alluded to the Bill of Rights. 36. Others power of state governments over the rights of its own citizens. Its sole purpose was to require that the rights granted by a state to its own citizens, the same, neither more nor less, shall be the measure of the rights of citizens of other states within your jurisdiction. Slaughterhouse Cases, 83 U.S. 16 Wall. 36, 77, 1872. There were radical Republicans, example Higby, who read Article 4.2, literally, so that a citizen of New York would have been treated as a citizen in die state of North Carolina. Curtis, Book 68. 92 U.S. 542, 549, 1875. 33 Supertext accompanying Note 2. 34 Curtis, Book 91. 35 ID. 97 Curtis states, several Republicans, of course, believed a constitutional amendment was required to correct Barron v. Baltimore. ID. 233 Note 201. Stevens and Bingham were among them, Infratext accompanying Notes 47 and 48. 36 Super Chapter 3 text accompanying Notes 8 to 14. Were sadly confused. The disparate Republican views make the legislative history invoked by Curtis inconclusive. Curtis has yet to reconcile his expansive reading of privileges or immunities with Bingham's insistence that civil rights or immunities be deleted from the Civil Rights Bill because the terms were oppressive and would strike down state constitutions. 38 If notwithstanding, Bingham could fantasize about the Bill of Rights in reliance on the immortal and irrelevant words of Daniel Webster, the fact remains that the House, unmoved by Bingham's fantasy, voted to delete the oppressive words. It cannot reasonably be assumed that the House silently reversed itself by adopting privileges or immunities. Curtis himself says of an early draft of the amendment which prohibited discrimination in civil rights that its general language failed to take account of and overrule the doctrine of Barron v. Baltimore that the Bill of Rights did not limit the states' 39 privileges or immunities is no less general than discrimination in civil rights and equally would not overrule Barron. It is reasonable to conclude that the framers adopted privileges or immunities precisely because the phrase, being of settled meaning, was not subject to the oppressive objection. The lawyers addressed by Senator Trumbull would readily understand the cases he quoted, holding, as William Lawrence later said, that privileges or immunities only applied to some, not to all, privileges. 40 By a glance at 37 Hiram Price understood the intention of the amendment is to give the same rights, privileges, and protection to the citizens of one state going to another that a citizen of that state would have who had lived there for years. Avens 156. Such protection for migrants was already provided by Article 4.2. 38 Super Chapter 2 text accompanying Notes 29 to 31. 40 Super Text J5 accompanying Note 9. The Constitution. They could easily perceive that the privileges or immunities of Article 4 did not embrace the as yet unborn Bill of Rights. Whatever the unorthodox beliefs of diverse Republicans so tirelessly recapitulated by Curtis, they cannot without more overcome Congress's adoption of the technical terms privileges or immunities, which the framers could perceive, and in fact were given to understand, were of limited scope. A less expansive, non-oppressive construction would be better attuned to their attachment to state control of their own civil and criminal administration. Such considerations elicit no comment from Curtis. Referring to my attribution to the Republicans of an unorthodox reading of Article 4.2, in fact, the attribution is his own. 41 He concludes that any attempt to define the 14th Amendment's privileges or immunities clause by a rule of construction that gives it the orthodox content of the privileges and immunities of Article 4 is not legitimate because it defeats the intention of the framers. 42 But he has failed to demonstrate that the rankly heretical views of some Republican radicals convinced the moderate conservative majority who were told by Trumbull that the words had a settled meaning. To the contrary, Senator Sherman boasted that we defeated every radical proposition. 43 Against this, Bingham's understanding of Article 4.2 is not of crucial importance. 44 Before long, Bingham himself was to recognize that the privileges or immunities of the 14th Amendment were no greater than those of Article 4. On January 30, 41 Curtis, Book N6, Infratext accompanying Note 46. 42 Curtis, Book N6. 43 James 167. 1871, he submitted a report of the House Committee on the Judiciary, reciting, The clause of the 14th Amendment, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States," does not, in the opinion of the committee, refer to the privileges and immunities of citizens of the United States other than the privileges and immunities embraced in the original text of the Constitution, Article 4, Section 2. The 14th Amendment, it is believed, did not add to the privileges or immunities before mentioned, but was deemed necessary for their enforcement as an express limitation. Upon the power of the states. 45 There were two dissenters from the report. Bingham was not one of them. In light of his prior reliance on that immortal man, who sleeps alone in his honored tomb beside the sounding sea, for locating the Bill of Rights in Article 4, it is highly interesting that the report quotes Daniel Webster's emphasis that Article 4 put it beyond the power of any state to hinder entry for the purposes of trade, commerce, buying and selling. Lawyer that he was, Webster well knew the judicial constructions limiting the clause. It is time to examine more closely Curtis' reliance on the erroneous beliefs of some, not all, Republicans, that, for example, Barron v. Baltimore was wrongly decided, that the Article 4:2, citizen of each state language really meant citizen of the United States. Some Republicans, Curtis acknowledges, frankly recognized that their constitutional views were unorthodox. Republicans, he states, operated from unorthodox legal premises. 46 All the wishful thinking in the world cannot convert what is into what ought to be. Stevens put the matter in proper focus, the Consti 45 Avens 466, emphasis added. Tuition including the Bill of Rights limits only the action of Congress and is not a limitation on the states. This amendment supplies that defect. 47 Beliefs could not cure the defect. For that an amendment was needed, as Bingham recognized. Bingham explicitly noted the case of Barron v. Baltimore to show why his amendment was required. 48 Curtis notices three explicit amendments. Republicans rejected Dred Scott and instead believed that all free persons born in the United States were citizens of the United States. Still, they explicitly wrote into the 14th Amendment national citizenship for all persons born in the United States. Some believed, contrary to Barron v. Baltimore, that the states could not deprive persons of due process. Still, they wrote this limitation into the 14th Amendment. Finally, leading Republicans believed that no state could abridge the privileges and immunities of citizens of the United States, including those privileges secured by the Bill of Rights. This idea also was written into the 14th Amendment. 49 From this Curtis infers that for Republicans the amendment was simply declaratory of existing constitutional law, properly understood. 50 This represents yet another erroneous belief. A declaratory statute declares what the law is and ever had been in order to remove doubts. 51 DC What the law is was stated by Barron v. Baltimore and was subsisting law in 1866. A declaratory act would confirm, not 47 ID. 86 Senator Howard, who with Bingham is one of the two pillars of Curtis' case, stated that the first 8 amendments do not operate in the slightest degree as a restraint or prohibition upon state legislation. States are not affected by them. Avens 219. 48 ID. 101, emphasis added. See Super Chapter 6 Note 99. 49 ID. 91, emphasis added. 50 ID. Emphasis added. 51 1 William Blackstone, Commentaries on the Laws of England. 86, 1765 to 1769. Overrule, it. Radical abolitionist repudiation of Barron did not give rise to the doubt which a declaratory statute would dispel. 52 Curtis' three examples demonstrate that the framers well knew how to articulate their aims. Curtis notes that the amendment was rewritten to incorporate this understanding citizens of the United States explicitly. 53 Aware of the significance of the framers' resort to explicit provisions, Curtis states, one could ask why the Bill of Rights was not explicitly written into the 14th Amendment, as due process and citizenship were. The reason, of course, is that the rights in the Bill of Rights make up the most important, but not all, of the rights of a citizen of the United States. 54 By this reasoning, a failure explicitly to provide justifies an interpolation going far beyond the express provision. By this twisted logic, express provision for due process was unnecessary because omission of the Bill of Rights testifies to an intention to comprehend all its rights. 55 That inference is confuted by the record. First, Bingham vehemently protested against the oppressive breadth of the word civil rights, which thereupon were deleted in order to foreclose an unintended latitudinarian construction. Second, time and again the framers rejected motions to prohibit all discriminations. 56 One such proposal had been made by St. Vance. In the end he pleaded for the amendment, though lamenting, as did Senator Fessenden, that it did not go far. 52 Curtis, Book 42, 48, 121. 53 ID. H5, emphasis added. 54 ID. 125, emphasis added. 55 An omission of the words implies an omission of the purpose. Perry v. Chicago Title and Trust Co., 182 U.S. 438, 448, 1901. 56 For citations, see Berger, Judiciary 163. Enough but represented the most that the people would accept. 57 To turn a blind eye to such undeniable facts, to resort instead to strained speculation and distortion, to dismiss what leading spokesman said because to his eyes it seems very odd renders Curtis scholarship suspect. 58 In a decision contemporaneous with the 14th Amendment, respecting the First Amendment right to assemble, Chief Justice Waite declared. This was not intended to limit the powers of the state government, but to operate upon the national government alone. For their protection in its enjoyment, therefore, the people must look to the state. The power for that purpose was originally placed there, and it has never been surrendered to the United States. 59 Waite cannot very well be taxed with ignorance of the 14th Amendment. To the contrary, as Justice William Johnson earlier observed, contemporaries had the best opportunity of informing themselves of the understanding of the framers, and of the sense put upon it by the people, when it was adopted by them. 60 Justice Black's discovery that the amendment incorporated the Bill of Rights had to wait for almost 80 years, and then only to be consistently rejected by his brethren. 57 Benjamin Kendrick, The Journal of the Joint Committee of 15 on Reconstruction 46, 1914, Globe 3148, 705, quoted infra-conclusion text accompanying notes 1-3. 58 Yet Curtis has the temerity to declare that Professor Fairman's treatment of the amendment lacked balance. Curtis, Book 109. History for the Activist is a protean instrument, useful for legitimating a predetermined result. L. Levy, Judgments, Essays in American Constitutional History 78, 1972. 59 United States v. Cruikshank, 92 U.S. 542, 552, 1875, emphasis added. Ogden v. Saunders, 25 U.S. 12 Wheat. 212, 290, 1827. Chapter 8 Fundamental and Absolute Rights. Fundamental Rights. Curtis rings the changes on fundamental rights, jumping off from Korfeld's reference thereto, and quoting Trumbull's citizens of the United States have fundamental rights such as the rights enumerated in this bill. One such as is not illustrative of a larger class but indicates that the subsequent enumeration determines the meaning of fundamental rights. 2 Moreover, Trumbull observed that Korfeld enumerates the very rights belonging to a citizen of the United States which are set forth in the first section of the bill. 3 Thus the bill specified the fundamental rights, and howsoever Korfeld may be read, the subsequent bill is the higher authority. Curtis also quotes from Trumbull's criticism of President Johnson's veto of the bill, Ejac State, so that it does not abridge the great fundamental rights belonging under the Constitution to all citizens. May Curtis, Book 114. 2 See Oxford Universal Dictionary, such 2. 3 Avens 122, emphasis added. This statement carried weight with Justice Field. Corfield, he stated, was cited by Senator Trumbull with the observation that it enumerated the very rights belonging to a citizen of the United States set forth in the first section of the Act. That these were the great fundamental rights set forth in the Act. Slaughterhouse Cases, 83 U.S. 416 Wall. 36, 98, 1872. Field and his fellow dissenters read the privileges and immunities phrase more broadly than did the majority. J. 105. Grant or withhold such rights as it pleases. Emphasis in original. From this he deduces, clearly in 1866 Trumbull had in mind some absolute rights seen as belonging to citizens under the Constitution, for Trumbull was concerned why a particular right, privileges and immunities, and with its scope. This he tied to specifics. The great fundamental rights set forth in the bill, the right to acquire property, the right to come and go at pleasure, the right to enforce rights in the courts, to make contracts, and to inherit and dispose of property. These are the very rights that are set forth in this bill as pertaining to every freeman. This was his answer to the question, what are the rights of citizens? 5 One might rely on this quotation, Curtis says, to prove that there was not room left in the privileges and immunities clause of the 14th Amendment for the Bill of Rights liberties. 6-7 But he disparages this in reliance on Trumbull's above-quoted criticism of President Johnson's veto. Curtis forgets that the specific governs the general, that Trumbull's hearers would not infer that he was attempting to enlarge the specific enumerations of the bill by implications drawn from what he allegedly had in mind. Some absolute rights. Such inferences must also account for Martin Thayer's. For Curtis, Book 117. Curtis regards the italicized remarks as more precise than Trumbull's explicit enumeration. ID. 73 5 Avens 122, emphasis added. Such facts undermine Curtis' reliance on Fairman's concession that the reference to fundamental rights in Corfield clouts the simple anti-discrimination reading of Article 4, Section 2, that he advocated. Curtis, Book 115. 6 Curtis, Book 117. 7 Ginsburg and Sons v. Popkin, 285 U.S. 204, 208, 1932, Forco Glasgow. V. Transmura Products Corp., 353 U.S. 222, 1957. The rule is of long standing, where a thing is given or limited by particular words in a statute, this shall not be taken away or altered by any subsequent general. Parallel explanation to the House, to avoid any misapprehension as to what the fundamental rights of citizenship are, they are stated in the bill. The same section goes on to define with greater particularity the civil rights and immunities which are protected by the bill. And he added, when those civil rights which are first referred to in general terms in the bill are subsequently enumerated, that enumeration precludes any possibility that the general words which have been used can be extended beyond the particulars which have been enumerated, and that the bill was for the protection of the fundamental rights thus enumerated of citizenship, and nothing else. 8. What could more precisely bar resort to generalities for expansion beyond the particulars? Such assurances were calculated to allay fear of undue encroachment on the state's sphere. 9. Even a radical, William Wyndham 10 said that under the Civil Rights Bill, Black's words. 4. Matthew Bacon, A New Abridgment of the Law, Statutes. Section 2, p. 645, 1759. C. Curtis Concession, Super Chapter 2 Note 32. 8. Avens 169. Thayer echoed the maxim expressio unius est exclusio ald irius. See Super Chapter 6 Note 43. Curtis would distinguish Thayer's remarks on the ground that he merely denied that the bill included the right to vote. Curtis, Book 79. As Wilson made plain, it is not necessary to mention every item that is not included. More significant is Thayer's statement that the amendment incorporated in the Constitution the principle of the Civil Rights Bill, which has lately become a law, in order that it shall be forever incorporated in the Constitution. Curtis, Book 86. Samuel Shell Berger, addressing a bill in 1869 to secure the privileges or immunities of the 14th Amendment, referred to the well-known and universally recognized principle of law, expressio unius ex exclusio ald irius. Avens 347. See Super Chapter 6 Note 43. 9. See Judge Posner, Super Chapter 1 Note 55. See also Super Chapter 5 Text accompanying Notes 24 to 31. Shall have an equal right, nothing more, to make and enforce contracts, to give evidence in court, and to hold and enjoy real and personal property. It merely provides safeguards to shield them from wrong and outrage, and to protect them in the enjoyment of that lowest right of human nature, the right to exist. Its object is to secure to a poor, weak class of laborers the right to make contracts for their labor, the power to enforce the payment of their wages, and the means of holding and enjoying the proceeds of their toil. 11. Emphasis on generalities in place of the limiting particulars sets at naught the framers' carefully drawn purposes. As Senator Sherman stated, the bill defines what are the incidents of freedom, and says that these men must be protected in certain rights, and so careful is its language that it goes on to define those rights: the right to sue and be sued, to plead and be impleaded, to acquire and hold property, and other universal incidents of freedom. 12. Curtis concedes that although many Republicans believed that fundamental rights not explicitly listed in the Constitution were included, there was no consensus on what these rights were. 13. The absence of a consensus vitiates the attempt to forge legislative history from disparate utterances. Curtis also observes that much of what Republicans had to say does seem confused if read without understanding the anti-slavery background and in light of modern legal ideas. 14. It is a historical fallacy to impose upon the past a creature of our own imagining. 15. One must be on his guard, wrote Felix Frankfurter, against attributing to Lan Gage of an early legal doctrine the implications which the Avens 171, emphasis added, 12 ID. 144. 13. Curtis, Book 82, emphasis added. 14 ID. 100, emphasis added. 15 H. Richardson and G. Sales, Parliament, and Great Councils in Medieval England, 77 LQ. Rev. 213, 224, 1961. Evolution of experience has put into it. 16. A caution earlier sounded by Justice Iredell. 17. Curtis himself recognizes that, of course, it is anachronistic to see the Republican understanding of rights essential to freedom in light of fashionable modern ideas. 18. And as we have seen, in seeking to filter anti-slavery ideology into the thinking of the majority of the framers, Curtis is wildly off course. 19. Behind the utterances of Trumbull, Sherman, et.al. was reluctance to expand rights unduly lest they encroach on a state's control over its own internal affairs. As Trumbull's criticism of President Johnson's veto makes clear, this bill in no manner interferes with the municipal regulations of any state which protects all alike in their rights of person and property. It could have no operation in Massachusetts, New York, Illinois, or most of the states in the Union. 20. This reflects the framers' devotion to state sovereignty. 21. State control of local institutions. Philip Buludan repeat. 16. Felix Frankfurter, The Commerce Clause under Marshall, Taney and Wade. 60, 1937. 17. We are too apt, in estimating a law passed at a remote period, to combine in our consideration all the subsequent events which have had an influence upon it, instead of confining ourselves, which we ought to do, to the existing circumstances at the time of its passing. Where v. Hilton, 3 U.S. 3 Dolly. 199, 267, 1796. In the construction of the language of the Constitution, we are to place ourselves as nearly as possible in the condition of the men who framed the instrument. Ex Part Bain, 112 U.S. 1, 12, 1887. Walton Hamilton and Douglas Adair, The Power to Govern. 104, 1937. It is the importation of meaning, opinion, and the intellectual world of here and now which makes evidence inconclusive, muddles understanding, and shunts inquiry to false leads. 18. Curtis, Book 67. 19. Super Chapter 5 Text accompanying Notes 47 to 101. 20. Avens 200. The impact of the bill and the amendment on the North was largely downplayed. Attention was focused on Southern misdeeds. Super Chapter 4 Text accompanying Notes 7 to 15. 21. Super Chapter 5 Text accompanying Notes 23 to 45. Edley emphasized, was the most potent institutional obstacle to the Negro's hope for protected liberty. 22 Wilson assured the House that if the states would all practice the constitutional declaration of Article 4 and enforce it, we might very well refrain from the enactment of this bill into a law. 23 Plainly the bill did not postulate an indeterminate catalog of absolute rights. Its face shows that it struck at discrimination with respect to enumerated particulars. The entire structure of this bill, said Wilson, rests on the discrimination on account of race. 24 Not content with the framers' own specification of fundamental rights, Curtis ransacks Blackstone. Wilson had cited Blackstone to explain the great fundamental civil rights to the House, saying, Blackstone classifies them under 3 articles as follows: 1. The right of personal security, which, he says, consists in a person's legal and uninterrupted enjoyment of his life, his limbs, his body, his health, and his reputation. 2. The right of personal liberty, and this, he says, consists in the power of locomotion, of changing situation, or moving one's person to whatever place one's inclination may direct, without impairment or restraint, unless by the course of law. 3. The right of personal property, which he defines to be the free use and enjoyment, and disposal of all his acquisitions, without any control or diminution save only the laws of the land. 25-22 Philip Paludan, A Covenant with Death 15, 13, 51, 54, 1975. See also H. Hyman, A More Perfect Union 470, 1973. 23 Avens 163-64. The derivation of the bill from Article 4 is constantly to be borne in mind. Chairman Trumbull explained that it had been patterned on the privileges and immunities of Article 4, 2. Avens 122-23. 24 ID. 164-25 Curtis, Book 74-75 for locomotion. See Super Chapter 2 text accompanying notes 22-24, Super Chapter 6 text accompanying note 77. Fundamental and absolute rights. These rights were expressed in the life, liberty, and property of the Due Process Clause, terms which had a down-to-earth meaning for the framers. The life of the emancipated black was being threatened and often taken in the South. 26 Consequently, the Civil Rights Bill guaranteed security of person and property, and the framers frequently used those terms. 27 Explaining, as did Wyndham, in order to shield them from wrong and outrage. 28 They employed the particulars of Die Bill, Shell Berger explained, because those rights were necessary for the protection of the rights of person and property. 29 Wilson himself, referring to the due process protection of life, liberty, and property, told the House, I understand that these constitute the civil rights to which the bill relates. 30 Blackstone's definition of liberty as the power of locomotion, of moving freely from place to place, snugly met the Black Code's attempts to fetter the freedman. Senator Henry Wilson urged the framers to ensure that the freedman can go where he pleases. 31 The Civil Rights Bill, Trumbull explained, secures the right to go and come at pleasure. 32 During the ratification campaign it was stressed that the bill secured the right to be protected in their person and property, though Wilson stated, thousands and tens of thousands of harmless black men have been wronged and outraged by violence, and hundreds upon hundreds have been murdered. Avens 171. And see Super Chapter 4 Note 9. 27 Curtis, Book 77, 78, 79. 28 Super Text accompanying Note N. James Wilson referred to laws barbaric and treatment inhuman. Avens 164. See also Super Chapter 2 Note 19, Chapter 6 Note 63. 29 Super Chapter 6 Text accompanying Note 55. 30 Avens 189. 31 Super Chapter 2 Text accompanying Note 24. 32 Avens 122, see also James Wilson, Super Chapter 2 text accompanying Note 24. Right of locomotion, the right to go where they please. 33 All that was involved, to quote Chancellor Kent, as did Wilson, was the right of personal security, the right of personal liberty, and the right to acquire and enjoy property. 34 So there was no occasion to invest life, liberty, and property with unplumbed depths. Not satisfied with such mundane explanations, Curtis searches Blackstone and emerges with references to Magna Carta, the Petition of Right, the Habeas Corpus Act, the English Bill of Rights, and Act of Settlement. 35 The last, governing succession to the throne, is altogether irrelevant to our republic. In Federalist No. 84, Hamilton said that Magna Carta and the Bill of Rights have no application to constitutions, professedly founded upon the power of the people. 36 True, the Bill of Rights was soon added to the Constitution, but of what use was it to specify rights in the bill if the enumeration was expansible by mere refer-ins to Blackstone? If more than those specifications was involved, the framers were entitled to be told. And what relevance does Blackstone's reference to the Bill of Rights have in light of Barron v. Baltimore's ruling that our own Bill of Rights does not apply to the states? Consider Magna Carta. It requires trial by jury of one's peers, but the framers of the 14th Amendment were assured that blacks could not serve as jurors. 37 Certainly Wilson, who read Blackstone to the House, did not take Curtis' untrammeled view. He explained that civil rights and immunities did not mean that. 33 Bond 448. 34 Avens 164. 35 Curtis, Book 75. 36 The Federalist, No. 84 and 558, Mod. Lib. Ed. 1937, 37 Berger, Judiciary 163, Infratext accompanying Note 59. In all things civil, social, and political, all citizens, without distinction of race or color shall be equal. Nor do they mean that all citizens shall sit on juries, or that their children shall attend the same schools. I understand civil rights to be simply the absolute rights of individuals, such as the right of personal security, the right of personal liberty, and the right to acquire and enjoy property. 38 These had been defined by the Blackstone excerpt he quoted. And he rejected a construction that the bill invades the states. In respect to those things which properly and rightfully depend on state regulations and laws, instancing school laws and jury laws. 39 Wilson, wrote Alfred Kelly, an activist, declared for a narrow interpretation of the measure in unequivocal terms. 40 In his own pioneer study of the 14th Amendment's history, Alexander Bickel commented, Wilson thus presented the Civil Rights Bill to the House as a measure of limited and definite objectives. In this he followed the lead of the majority in the Senate. And the line he laid down was followed by others who spoke for the bill in the House. 41 Absolute rights. In comparing the Civil Rights Bill and the 14th Amendment, Curtis addresses the argument that the Civil Rights Bill was merely designed to protect blacks by granting them equal protection in certain narrow rights secured by state law, the right to contract, own property, and the like. The 14th Amendment, in turn, merely insert 38 Avens 163, quoting Kent's commentaries. 39 Avens 189. 40 Alfred Kelly, the 14th Amendment reconsidered, the segregation question, 54 Mitch. L. Rev. 1049, 1066, 1965. 41 Bickel 17. Port the Civil Rights Bill read narrowly. The whole object, according to this view, was to grant certain rights to blacks, basically, the rights to contract, sell, testify, and to equal protection of certain state laws. 42 It is Curtis' depressing habit to label as argument that which is indisputable. Disparagement of narrow rights. Read narrowly conflicts with the court statement that the legislative history of the 1866 Act clearly indicates that Congress intended to protect a limited category of rights. 43 As the evidence herein detailed confirms. He goes on to comment, the argument claims that the 14th Amendment is absolutely the same as the Civil Rights Bill. Since the Act was merely to secure blacks against discrimination and not to displace non-discriminatory state law, by this view the 14th Amendment does not protect Bill of Rights, liberties, or any other absolute rights that states cannot abridge. 44 For this Curtis cites my discussion of the Act, wherein I considered his argument that if the amendment and the bill were identical, it follows that the Civil Rights Bill contained a federal standard of due process, observing that since the object of the Act merely was to secure blacks against discrimination, not to displace undiscriminatory state law, that interpretation meant the standard of the state. 45 No reference was made by me to the amendment. The focus of my government by judiciary, it needs to be borne in mind, was on the substantive rights enumerated in the Civil Rights Bill. Those rights were to be free of discrimination and included access to the courts for their protection. The 42 Curtis, Book N8. 43 Super Chapter 2 Text accompanying Note 32. 44 Curtis, Book N8, 09. 45 ID. 247 Notes 194-95, Berger, Reply 4-5. Amendment tersely articulated the purposes of the bill in several clauses. I would not urge that identical means absolutely the same in every particular. There was a difference between Act and Amendment. As Stevens pointed out, the amendment could not be repealed by a subsequent Congress. 46 Curtis' reliance on legislative history is incompatible with making a fortress out of the dictionary. Let us recur to Curtis' argument that to read the amendment to prohibit discrimination in certain rights that states choose to accord their own citizens renders the privileges or immunities and due process clauses superfluous. 47 This argument is built on Curtis' straitjacket understanding of the word identical. Since we are analyzing an historical relation, it will be useful to begin with the Civil Rights Bill. The Civil Rights Bill unquestionably, the bill was aimed at racial discrimination. There shall be no discrimination in civil rights or immunities on account of race. 48 Although this clause was deleted in deference to Bingham's protest against its oppressive invasion of the state's domain, the anti-discriminatory essence of the bill remained in the Act's provision that all citizens born in the United States shall have the same right to make and enforce contracts, to sue, etc., as is enjoyed by white citizens. 49 Senator Trumbull, manager of the bill, explained that it will have no operation in 46 Super Chapter 6 text accompanying Note 2. 47 Curtis, Book 09, quoted Super Chapter 6 at Note 5. 48 Super Chapter 2 text accompanying Note 26. 49 ID, Avens 243. Wilson emphasized that a colored citizen shall not, because he is colored, be subjected to obligations, duties, pains, and penalties from which others are exempted, in short equality in the exemptions of the law. ID 163. See also Wilson, Infratext accompanying Note 59. Any state where the laws are equal, where all persons have the same civil rights without regard to color or race. 50 After the bill was vetoed by President Andrew Johnson, Trumbull assured the framers that it in no manner interferes with any state which protects all alike in their rights of person or property. 51 Similarly, Samuel Shell Berger stated, whatever rights as to each of these enumerated civil, not political, matters the state may confer upon one race, shall be held by all races in equality. it secures equality of protection in those enumerated civil rights, which the states may deem proper to confer upon any one race. 52. Martin Thayer emphasized that the enumeration of rights in the bill precludes any possibility that the general words which have been used can be extended beyond the particulars which have been enumerated. 53. Plainly, the act did not displace non-discriminatory state law, it only required that if whites were given certain rights by states they must also be enjoyed by blacks. Even so limited, the bill, Bingham protested, constituted an oppressive invasion of the state's domain, hence, the word civil rights were deleted in order to foreclose an unintended latitudinarian construction. 54. Curtis asserts that the ban on discrimination collides with the absolute rights of personal security, personal liberty, and the right to acquire and enjoy property. 55. He relies on remarks, labeling them as inalienable, absolute rights, of which a state cannot deprive him, and argues 50 ID 122, 51 ID 252 ID 188, emphasis added. Curtis regards these remarks as qualified and ambiguous. Curtis, Book 78. This from one who tortures every utterance to find a place for the Bill of Rights. 53. Super Chapter 2 Text accompanying Note 28. 54 ID. Text accompanying Notes 29 to 32. That if the states could eliminate such rights so long as they did it for all their citizens, the rights would not be inalienable. 56. Curtis' reliance on Trumbull lends him no aid. Trumbull noted in arguing for the Civil Rights Bill, the rights to personal liberty, personal security, and the right to acquire property are declared to be inalienable rights. 57. Nevertheless, as has been noted, Trumbull stated that the bill will have no operation where all persons have the same civil rights without regard to color or race, that it in no manner interferes with any state which protects all alike. 58. Clearly Trumbull was only concerned with discrimination, leaving the states free to withhold or repeal laws conferring rights. Nor does another such citation to Wilson advance Curtis' case. Wilson, House manager for the bill, observed that the entire structure of this bill rests on the discrimination on account of race. 59. He also stated that had the southern states complied with Article 4, the bill would have been unnecessary. 60. And he assured the framers that the bill did not mean that in all things, civil, social and political, all citizens without distinction of race or color shall be equal. 61. There remains Curtis' citation to William Lawrence. There are certain absolute rights which are inherent, and of which a state cannot constitutionally deprive a citizen. 62. And he stated that citizens may not be stripped by 56 ID. 57 ID. During the ratification campaign, Trumbull declared that Section 1 of the amendment was a reiteration of the rights as set forth in the Civil Rights Bill. Super Chapter 4 Note 17. 58 Havens 122, and Super Text accompanying Note 51. 59 Havens 164. 60 ID. 163 to 64. State authority of the means by which citizens may exist. 63 But this was against the background of Southern denial of those rights to blacks alone. He amplified, it is idle to say that a citizen shall have the right to life, and yet deny him the right to labor, whereby alone he can live. It is a mockery to say that a citizen may have a right to live, and yet deny him the right to make a contract to secure the privileges and rewards of his labor. 64 The very spelling out in the Civil Rights Act of rights that were to be free from discrimination precludes an attribution to the framers of a doctrine of absolute rights that were beyond state power to withdraw them from all. To the contrary, the assurances by Trumbull, Shell, Berger, Thayer, and Wilson that when states granted certain rights they had to be available to all indicates that whether to grant or withdraw them was left in the state's discretion, a far cry from inalienable rights. Curtis' unceasing drumbeat on personal liberty, personal security, invests them with near mystical significance. The framers, however, viewed them concretely protecting the emancipated blacks from laws barbaric and treatment inhuman, from crimes and outrages, murder and torture. 65 If personal liberty, personal security range further, beyond the rights particularized in the bill, the framers were guilty of an egregious oversight. Vain was their effort to limit protection to the enumerated particulars of the bill. What need was there for particularization if there existed a galaxy of absolute rights outside its confines? For the framers, however, as Thayer stated, the fundamental rights. 63 Avens 206. But compare Shell, Berger, Super Chapter 6 Text accompanying Note 17. 64 Avens 206. 65 ID. 164, 472, see also Super Chapter 4 Note 9. Of citizens are stated in the bill. 66 Senator Trumbull likewise referred to the great fundamental rights set forth in the bill. 67 As to these, there could be no discrimination. It is open to Curtis to insist that the Civil Rights Act was and remains fatally defective both because it does not guard against state repeal of the rights the bill enumerates, and because absolute rights embrace still others. But he may not saddle the framers with his view. The 14th Amendment, the Privileges or Immunities Clause, it will be recalled, was the primary source of substantive protection. As Curtis put it played the central role. 68 Drawn from Article 4, 2, which protected rights associated with trade and commerce, it protected a limited Category 5 of rights, without which the freedman could not exist. 69 Michael Peary concluded that by privileges or immunities the framers meant only to protect against state discrimination on the basis of race, a narrow category of fundamental rights, those pertaining to the physical security of one's person, freedom of movement, and capacity to make contracts and to acquire. Super Chapter 2 text accompanying Note 28. 67 Avens 122. Notwithstanding, Gressman opines that citing chapter and verse from the legislative history, Curtis concludes that the framers clearly intended to incorporate into the Privileges and Immunities Clause all the rights expressed in the Bill of Rights, plus all the other rights that might be deemed fundamental to a free people. Gressman, Book Re. View, 1 New Law Books Reviewer 57, 59-60, 1986. He concludes that Curtis's book made clear beyond all doubt that the framers did intend to incorporate an open-ended definition of all other fundamental rights that belong, of right, to the citizens of all free governments. ID. 62 An activist's eagerness to believe blurs judgment. Super Chapter 1 text accompanying Note X, Curtis, Book 9. Hold and transfer chattels and land, life, liberty, and property in the original sense. Point 70 The right to sue for the protection of those rights was embodied in the Due Process Clause, which had a centuries-old procedural connotation. Point 71 Equal protection of the laws. Equal protection of the laws restated affirmatively the Act's negatively framed proscription of discrimination. Stevens explained that the amendment allows Congress to correct the unjust legislation of the states, so far that the law which operates upon one man shall operate equally upon all. Whatever law punishes a white man for a crime shall punish the black man precisely in the same way. I need not enumerate those partial and oppressive laws, 72 i.e., the Black Codes. This was made explicit by Leonard Myers who, in commenting on the amendment, observed that a change was required so that each state shall provide for equality before the law, equal protection to life, liberty, and property, equal right to sue and be sued, to inherit, make contracts, and give testimony, 73 Wedding equal protection to the components of the Civil Rights Bill. Curtis does not explicitly invoke the Equal Protection Clause as an independent source of substantive rights, but 70 Michael Perry, Interpretivism, Freedom of Expression and Equal Protection, 42 Ohio Street. LJ. 261, 273, 1981. Shell Berger referred to those rights to contract, sue, testify, inherit and see, which this bill says the races shall hold as races in equality, are of that class which are fairly conductive and necessary as means to the constitutional end, to wit, the protection of the rights of person and property of a citizen. Avens 188. 71 See Super Chapter 1 text accompanying Notes 20-22. See also Edward Corwin, The Twilight of the Supreme Court 95, 1934. 73 ID. 193, emphasis added. Refers to Lincoln's reference during a campaign to the statement in the Declaration of Independence that all men are created equal in certain inalienable rights, among which are life, liberty, and the pursuit of happiness. 74 But as president, Lincoln told a delegation of black leaders that you are far removed from being placed on an equality with the white man. 75 Equal protection was not an expression of boundless equality, for the framers repeatedly rejected proposals to ban all discrimination. 76 Plainly it did not comprehend suffrage. 77 One is driven by the evidence, wrote C. Van Woodward, to the conclusion that popular convictions were not prepared to sustain a guarantee of 74 Curtis, Book 16. 75 Super Chapter 5 text accompanying Note 58. In an 1859 campaign speech, Lincoln said, I have no purpose to introduce political and social equality between the white and black races. There is a physical difference between the two which, in my judgment, will probably forbid their ever living together upon the footing of perfect equality, and inasmuch as it becomes necessary that there must be a difference, I, as well as Judge Douglas, am in favor of the race to which I belong having the superior position. In his Columbus, Ohio, speech in September 1859, he quoted from an earlier address, I am not or ever have been in favor of making voters or jurors of Negroes, nor of qualifying them to hold office or to intermarry with the white people. Quoted Avens 242-43. Such remarks attest to an electorate that was stirred by the very fears Lincoln sought to allay. 76 For citations, see Berger, Judiciary 163. 77 Commenting on 2 of the 14th Amendment, which reduces representation in the House of Representatives in proportion as a state denies the franchise to blacks, Senator Jacob Howard commented, this section of the amendment does not recognize the authority of the United States over the question of suffrage in the several states at all, nor does it recognize, much less secure, the right of suffrage to the colored race. Three-fourths of the states of the Union could not be induced JJP vote to grant the right of suffrage, even in any degree or equality. 78 An Illinois radical, John Farnsworth, asserted in the 39th Congress that Negro equality is the everlasting skeleton which frightens some people. 79 A black academician, Derek Bell, has noted that few abolitionists were interested in offering blacks the equality they touted so highly. Indeed, the anguish most abolitionists experienced as to whether slaves should be granted social equality as well as political freedom is well documented. 80 David Donald, a Reconstruction historian, wrote, His suggestion that Negroes should be treated as equals to white men woke some of the deepest and ugliest fears in the American mind. 81 If we look to the legislative history, Curtis springboard equal protection cannot be given unbounded Scope. It cannot be read to create substantive rights extending beyond those comprehended in the Privileges or Immunities Clause. Nor does the text afford much comfort. John Hart Ely considers it to be inscrutable. 82 The residuary jurisdiction guaranteed to the states by the 10th Amendment cannot be curtailed under the cover of land. Gauge lacking perceptible boundaries. Point 83 What then is the substantive content of the words equal protection of the laws? The almost exclusive focus on under any restrictions, to the colored race. The second section leaves the right to regulate the elective franchise still with the states, and does not meddle with that right. Avens 220. C. Trumbull, Super Chapter 6 Note 17. 78c. V. Woodward, The Burden of Southern History 83, I 960. 79 Globe 204. 80 Derek Bell, Book Review, 76 Column. L. Rev. 350, 358, 1976. 81 David Donald, Charles Sumner, and the Rights of Man 157, 1970. 82 Like the inscrutable Privileges or Immunities Clause, the Equal Protection Clause is also unforthcoming with details. J.H. Ely, Democracy and Distrust 98, 1980. 83 Super Chapter 5 Note 44. Equal has obscured the significance of word protection. Yet it is protection that is the subject of discourse, equal is the modifier. Whatever protection is furnished must be equal. What, it needs to be asked, was to be protected? The abysmal failure of the South to protect the poor, son and property of blacks against violence and murder, to safeguard the means whereby they could exist, furnishes the answer. Point 84 That approach can rescue analysis from treating the word equal as if it were a crystal ball. Protection, if given, must be impartial. The bill leaves no doubt as to what was to be protected. Shell Berger explained that it secures equality of protection in those enumerated civil rights which the states may deem proper to confer upon any races. 85 There was need, said Leonard Myers of the amendment, to provide equal protection to life, liberty, and property, equal right to sue and be sued, to inherit, make contracts, and give testimony. 86 Only when equal protection is viewed as a restatement of the bill's ban on discrimination with respect to particular rights does it respond to the framers' intention. Neither the Privileges or Immunities nor the Due Process Clauses address discrimination, that is the function of equal protection. It does not follow that due process and privileges or immunities are superfluous. The latter describes the rights that are to be protected, and the Due Process Clause affords them judicial protection. Curtis threw his superfluous spotlight on the wrong clause. His argument led me to re-examine the relation between the three clauses, and it dawned on me that, if any, it may be the Equal Protection Clause that is superfluous. 84 Super text accompanying notes 26 to 27. Discrimination is comprehended in the Privileges or Immunities phrase no state shall abridge, for discrimination abridges the rights of the victim. Rights which may not be abridged stand in no need of equal protection. The legislative history establishes that equal protection articulates the ban on discrimination respecting rights embodied in the Privileges or Immunities Clause, and that it was not meant to be an independent source of substantive rights. The contrary view would render the central Privileges or Immunities Clause supererogatory because the rights it incorporates would be comprehended in the boundless ambit of equal protection. That view collides with the preponderant role privileges or immunities played in the debates. Point 87 How could the framers have overlooked this tautology? Originally the Bingham draft centered on equal protection, it did not contain the word abridged. That word, Curtis recounts, appeared in Bingham's proposal of April 28, 1866. 88 Although I have read the three clauses countless times, I too have overlooked what now seems to me the duplication of abridged by equal protection. This suggestion calls for further exploration. In sum, the drive to preserve the Civil Rights Act from repeal, the derivation of the Privileges or Immunities Clause from the Act, and the provision that no state shall abridge the privileges or immunities put it beyond the power of a state to curtail or withhold the rights the clause. Subsum S. By the same token, it lies beyond state power to deprive any person of life, liberty, or property without due process of law, although that process is governed by state, not federal standards. In these respects the Amendment 87 Curtis, Book 60 to 73, 78 to 80, 87 to 88, 90. Is not absolutely the same as the Civil Rights Act. It cannot be repealed by a subsequent Congress, and the rights it protects from abridgment cannot be withdrawn by a state from its citizens. Statewide equality. Curtis devotes a section of his book to equal national rights or equal rights within a state. 89 If, as seems to be the case, he questions Fairman's understanding of the bill as providing for equality under state or local law. 90 He betrays unfamiliarity with the facts. It is hardly deniable that the Equal Protection Clause referred to statewide, not national, equality. At the outset Stevens had proposed that all laws, state or federal, shall operate impartially and equally. 91 But his proposal came to naught. On the other hand, Trumbull spoke of any state which shall protect all alike, Shell Berger of rights conferred by states, and Stevens of correct FING the unjust legislation of the states. The rights to contract, to own property, to inherit, are peculiarly the creatures of state law. It will be recalled that Shell Berger stated, if the section did in fact assume to define or regulate these civil rights, which are named by the words contract, inherit and see, then it would be an assumption of the reserved rights of the states and the people. 92 Thus Shell Berger underscored that the framers had no intention of displacing state control. 89 ID. N7. 90 ID. 93. Emphasis by Curtis. 91. Benjamin Kendrick, The Journal of the Joint Committee on 15 on Reconstruction 46, 1914, emphasis added. 92. Super Chapter 6 text accompanying Note 17. See also Curtis Super Chapter 6 Note 15. Of those local rights by a national equal standard. Point 93. That only a statewide equality was intended may be gathered from contemporaneous constructions of the cognate due process. In Walker v. Sabinet, 1875, the court declared that due process in the states is regulated by the law of the state. 94. Justice Bradley went on to say in Missouri v. Lewis, 1879, that the 14th Amendment does not profess to secure to all persons in the United States the same laws or the same remedies. Great diversities in these respects may exist in two states separated by an imaginary line. Each state prescribes its own mode of judicial proceeding. 95. In fine, the 1866 Act, embodied in the 14th Amendment, protected a limited category of rights against discrimination. Trumbull's emphasis, reiterated by Wilson and Senator Stewart, 96, that the act would have no application where the states treated all alike with respect thereto, is at war with the creation of absolute rights. Throughout, Curtis ignores the profound impact of 1. The continuing attachment of the North to state control of internal matters, which resulted in a ban on discrimination limited to enumerated rights, and 2. The widespread racism that hobbled improvement of Negro status. A scholarly search of the legislative history must begin with what the framers thought. During the ratification campaign, Governor Fletcher of Missouri, as Curtis notes, said that the 14th Amendment secures to all persons equality of protection under the laws of the state. Curtis, Book 146. See also Shell Berger, Supertext accompanying Note 83, Trumbull, Chapter 4 at Note N, Stevens, Supertext accompanying Note 72, and Myers, I.D. at Note 73. 94-92 U.S. 90, 93, 1875. 95 IOI U.S. 22, 31, 1879. 96 Avens 163-64, Supertext accompanying Notes 10-12. Fundamental and absolute rights not with what Curtis would have them think today. Point 97. That must be the focus if we would avoid lawyers' history. 98-97 An English scholar, W. R. Brock, wrote, a belief in racial equality was an abolitionist invention. To the majority of men in the mid-19th century it seemed to be condemned both by experience and by science. Even abolitionists were anxious to disclaim any intention of forcing social contacts between the races. W. Brock, An American Crisis, Congress and Reconstruction 285, 286, 1963. See also President Lincoln, Super Chapter 5 text accompanying Note 60. Americans clung firmly to a belief in the basic inferiority of the Negro race, a belief supported by the preponderance of 19th century scientific evidence. Paludan, Super Note 21 at 54. See also Lincoln, Super Note 75. 98 Maitland wrote that the process by which old principles and phrases are charged with a new content is from the lawyer's point of view an evolution of the true intent and meaning of the old law, from the historian's point of view it is almost of necessity a process of perversion and misunderstanding. 3 Peter Gay and Victor Wexler, Historians at Work 301. Chapter 9 John Bingham and Senator Jacob Howard. John Bingham Curtis strives mightily to restore the reliability of John Bingham because he is the linchpin of his argument. The views of Bingham and Howard, leading proponents of the amendment, he asserts, are entitled to very great weight. 1 But Curtis notes Fairman's conclusion that Bingham was a man of peculiar conceptions, an ardent rhetorician, not a man of exact knowledge or accurate language. 2 Fairman was not alone in doubting Bingham. Alexander Bickel charitably wrote that Bingham was not normally distinguished for precision of thought or statement. 3 Leonard Levy observed that Bingham was extremely confused and contradictory in his presentation. 4 And Wallace Mendelson concluded that Bingham is one who used ringing rhetoric as a substitute for analysis. 5 Can it be that Curtis alone perceived the true worth of Bingham, a vision that was Curtis, Book 120. Curtis stresses that the views of the author of Section 1 of the amendment should receive the greatest weight of all. ID 13. 2 ID 121 Curtis cites DIs 4 Bingham was subjected by Fairman to a series of ad hominem attacks. ID 109 Nickel $2. 4 L. Levy, Judgments, Essays on Constitutional History 77, 1972. 5 W. Mendelson, M.R. Justice Black's 14th Amendment, 53 Min. L. Rev. 711, 716, 1969. Denied to Bickel, Fairman, Levy, Mendelson, and Berger? Let me show Bingham's serious shortcomings. Bingham's draft of the 14th Amendment provided for equal protection in the rights of life, liberty, and property, and he stated flatly that the amendment proposed stands in the very words of the Constitution. Every word of the proposed amendment stands in the very words of the Constitution. 6 The words equal protection, however, were not in the Constitution, they were added by the 14th Amendment. This is a glaring inexactitude. Bingham was unable to discriminate. Thus he translated the provision of Article 4, 2, that the citizens of each state shall be n. Titled to the privileges and immunities of citizens in the several states as the provision in the Bill of Rights that citizens of the United States shall be entitled to all the privileges and immunities of citizens of the United States in the several states. 7. The Bill of Rights contains no privileges and immunities provision. To this Curtis replies that Bingham never said it did. 8. But he is squarely contradicted by the quotation. Nor did the framers confuse the rights of a citizen of a state with those of a citizen of the United States. They expressly distinguished between the two. 9. Bingham, Curtis tells us, thought the provisions of the Bill of Rights were binding on state officers by their oath and by the Privileges and Immunities Clause of Article 4, Section 2. 10. When Article 4 was enacted there was no Bill of Rights, so Article 4 could not make the unborn Bill of Rights binding on state officers. And if under Berger v. Baltimore the Bill of Rights did not apply to the states, the 6 Avens 150, emphasis added. 7. ID 157, emphasis added. 8. Curtis, Book 121. 9. Super Chapter 7 text accompanying Note 27. Oath state officers took to support the Constitution did not bind them to enforce the Bill of Rights against the states. So too, Bingham said, contrary to the express letter of your Constitution, cruel and unusual punishments have been inflicted under state laws. 11. The First Amendment's Congress shall make no law warns that the 8th likewise does not apply to the states. Again, Bingham read Barron to show that the power of the federal government to enforce in the United States courts the Bill of Rights had been denied. 12. Barron held the Bill of Rights inapplicable to the states. It uttered no word about a lack of enforcement power. Of the same order is Bingham's statement, if the Bill of Rights, as has been solemnly ruled by the Supreme Court, does not limit the power of the states, the care of the property, liberty, and the life of the citizen, under the solemn sanction of an oath imposed by your federal Constitution, is in the states, not in the federal government. I have sought to effect no change in that respect. I have advocated here an amendment which would punish all violations by state officers of the Bill of Rights. 13. If the care of life, liberty, and property is in the states, how do state officers violate the Bill of Rights, which, Bingham noted, does not limit the powers of the states? Curtis takes refuge in the word if, arguing that it shows Bingham's skepticism about the correctness of Berger v. Baltimore. 1 solemnly ruled suggests respect rather than skepticism, and Bingham's I have sought to effect no change in that respect has no hypothetical overtones. Bingham was addressing an audience he sought to influence, and his has ID 124, emphasis added. 12 ID 70-71, emphasis added. Been solemnly ruled would lead his fellow lawyers to deduce that the court had laid down the law, and that could not be shaken by his skepticism. Bingham's remarks are rife with contradictions. I do not admit that any state has a right to disenfranchise any portion of the citizens of the United States. 15. But later he stated, we all agree that the exercise of the elective franchise, though it be one of the privileges of a citizen of the Republic, is exclusively under the control of the states. 16. If the franchise is indeed a privilege of a citizen of the Republic, it cannot be exclusively under the control of the states. Such evidence is dismissed by Curtis as supposed contradiction. 17. Upon which of Bingham's conflicting utterances did the framers rely? It is a measure of the feebleness of Curtis' cause that he must go to such lengths to rehabilitate Bingham. One of Curtis' major flaws is his refusal to face up to Bingham's repeated recognition that control of internal matters was left to the states. To escape the impact of one such instance he charged me with editing to produce a decidedly misleading effect, illustrating the dangers of selective quotation. 18. In a footnote buried at the back of his book, he explains that my omission occurred based on a mistaken assumption. 19. Consequently, his pejorative, decidedly misleading, and selective quotation, which connote intentional suppression, disclose him to be a propagandist. 15. Globe App 57. 16. Globe 254-2. So Trumbull stated, Super Chapter 6 Note 17, see also Howard, Super Chapter 8 Note 77. 17. Curtis, Book 121. Bingham considered that enfranchisement of the blacks conformed exactly to the spirit of the Constitution and according to the declared intent of the framers. Globe 430. In fact, the Constitution protected slavery. Super Chapter 5 text accompanying Notes 87-88. 18. Curtis, Book 122-23. 19. ID 249. This extenuation would with better grace have been inserted in the text to defuse the noisome accusation, rather than a dispassionate historian. With apologies to the weary reader, I must examine such trivia because they exemplify the tactics that have taken in respected scholars, let alone that they tarnish my reputation. My edited version follows, the care of the property, the liberty, and the life of the citizen is in the states, and not in the federal government. I have sought to effect no change in that respect. I have advocated here an amendment which would arm Congress with the power to punish all violations of the Bill of Rights. I have always believed that protection within the states of all the rights of person and citizen was of the power reserved to the states. 10. What Bingham actually said was, the care of the property, the liberty, and the life of the citizen, under the solemn sanction of an oath imposed by your federal Constitution, is in the states and not in the federal government. I have sought to effect no change in that respect in the Constitution of the country. I have advocated here an amendment which would arm Congress with the power to compel obedience to the oath, and punish all violations by state officers of the Bill of Rights, but leaving those officers to discharge the duties enjoined upon them as citizens of the United States and by the Constitution. 11. Emphasis in the original. My misleading omission was to leave out Bingham's qualification, which was, essentially, that the care of the life, property, and liberty of the citizen, subject to constitutional limitations, i.e., the oath is in the states. 22. The limitations are a figment of Curtis' imagination. In the very same speech, Bingham, without qualification, said, I have always believed that the protection within the states of all the rights of person and property was of the powers reserved to 20 Curtis, Book 122-23. 21 ID. 123-22 ID. Emphasis added. The states. And so I still believe. 23. He proceeded on the false assumption that the Bill of Rights applied to the states in the teeth of Barron v. Baltimore, the assumption, as Curtis puts it, that his constitutional views and those of a number of his colleagues, not the decisions of the Supreme Court, accurately stated the law. 24. It may not be assumed that the sober lawyers who listened to him preferred his version of the law to that of the Supreme Court. Like Lincoln, who knew that the court's decisions did not vanish because deemed objectionable, but must be overruled by the court, or by amendment, as the framers did explicitly with respect to Dred Scott. 25. They cannot be saddled with Bingham's view. His disavowal of any intention to take away from any state any right that belongs to it was calculated to allay fears of undue interference with states' rights. Nor does this excerpt stand alone. To Robert Hale's statement that the citizen must rely upon the states for their protection, Bingham replied, I admit that such is the rule under the Constitution as it now stands, and underscored the point by reading to the House Madison's assurance in the Federalist that internal matters were reserved to the states, emphasizing that this is the text of the Constitution. 26. So my misleading omission of Bingham's subject to constitutional limitations turns out by his own testimony to be no constitutional limitation at all. Bingham further illustrates the folly of inflating the influ. 23. Evans 188. 24 Curtis, Book 63. 25 ID. 215. 26 Evans 159. Curtis quotes Bingham's rejection of an intention to take away from any state any rights that belongs to it. The proposition pending before the House is simply a proposition to arm the Congress with the power to enforce the Bill of Rights as it stands in the Constitution today. It hath that extent no more. Curtis, Book 95, emphasis added, another example of Bingham's befuddlement. In the anti-slavery origins of the amendment, which Curtis asserts, it was Fairman's major fault to overlook point 27 in 1859. For example, Bingham had opposed the admission of Oregon because its constitution forbade the entry of a free Negro or mulatto into the state. Point 28. But in 1866 he led the fight against radical opposition to the readmission of Tennessee because its constitution did not provide for Negro enfranchisement, and prevailed by a vote of 125 to 12.29. He had been defeated in 1862 and re-elected in 1864. 30. David Donald states that he was fully aware that his Ohio district could easily go Democratic, since his own average from 1862 to 1870 was only 50.6% of the total. Bitterly he protested against radical proposals for universal suffrage. 31. His political instincts did not betray him, for in the April 1867 elections Ohio overwhelmed a Negro suffrage amendment by 40,000. 32. This was the state in which Senator John Sherman said, "We do not like Negroes. We do not conceal our dislike." 33. Not only had Northern goals shifted after the abolition of slavery, but political realities had diluted Bingham's early zeal. To prate against this background. 27. Curtis, Book 2, 42. Leonard Levy anticipated Curtis in concluding that the evidence of 1866 to 1868 must be read in the light of a received tradition of abolitionist constitutional argument. Levy, Supernote 4 at 70. Fairman erred, Levy opined, in construing the words used in a lawyer's terms. He therefore missed the history that was behind those words that can be appreciated only by understanding them, and the language of the amendment as expressions of the constitutional ideology of the abolitionists. Levy, ID. 69 to 70. For detailed refutation of this view, see Super Chapter 5 text accompanying notes 72 to 102. 28 Curtis, Book 59. 29 Globe 3979, 3980. 30 Curtis, Book 248 Note 212. 31 D. Donald, The Politics of Reconstruction 46, 1965. 32 C. V. Woodward, Seeds of Failure in Radical Race Policy, in New Frontiers of American Reconstruction 137, H. Hyman ed. 1966. Of the impact of abolitionist theology on the amendment is to prefer fantasy to fact. Senator Jacob Howard is, with Bingham, one of the pillars of Curtis' case, as he was of Justice Black's. Due to the sudden illness of Chairman Fessenden, it fell to Howard to act as spokesman for the Joint Committee, saying, "I can only promise to present to the Senate the views and motives which influenced that committee, so far as I understand those views and motives." 34 This does not pretend to be the committee's official view but merely Howard's impression thereof. Curtis to the contrary notwithstanding, Howard did not have charge of the amendment in the Senate 35. Up to this point his participation in the debates on the Civil Rights Bill and the several aspects of the amendment had been negligible. Nor were his views fine-tuned to those of Bingham. Fairman recounts that Howard apparently had not entered into the spirit of Bingham's drafting 3 times in the committee he had voted against the author's work. 36. According to Benjamin Kendrick, author of the Journal of the Joint Reconstruction Committee, Howard was one of the most reckless of the radicals, who had served consistently in the vanguard of the extreme Negrophiles, 37, in which he was certainly far removed from the pervasive racism of the North. He and Elisha Washburn had been the only Republicans to hold out for blacks. 34. Evans 218-1935 Curtis, Book NS, emphasis added. 36. Charles Fairman, History of the Supreme Court of the United States 1291, 1971, 37b. Kendrick, The Journal of the Joint Committee of 15 on Reconstruction 257, 192, 1914. Fridge to the end, all the others proved willing to abandon it. 38. Howard's attitude tended to be more radical and purely partisan than that of Fessenden. 39. That such a man could speak for a non-radical joint committee, 40. In which by Fessenden's testimony there was very considerable difference of opinion, 41. Strains credulity. How little Howard's loose utterances are to be trusted is underlined by his statement that the amendment abolishes all class legislation in the states in the teeth of the framers' repeated rejection of attempts to prohibit all manner of discrimination. 42. In the midst of a very long speech, Howard read an extract from Corfield v. Coriel and said, to those privileges and immunities should be added the personal rights guaranteed and secured by the first 8 amendments. 43. Like Bingham, who recognized that Barron v. Baltimore solemnly ruled that the Bill of Rights did not limit the pow-dash of the states, yet considered that it was enforceable by the oath state officers took to support the Constitution. 44. Howard perceived that the Bill of Rights does not operatic in the slightest degree as a restraint or prohibition upon state legislatures. States are not affected by them. Nevertheless, the bill was to be enforced by the 5th section of this amendment, which declares that the Congress shall have power to enforce by appropriate legislation the provisions of this Article 45. Historically, we have seen privileges or immunities drawn from Article 4.2 did not embrace the 38 M. L. Benedict, A Compromise of Principle 170, 1975, James 82. 39. James 135. 40. Benedict, Supernote 38 at 37, 34. 41. Avens 211. 42. ID. 220, Berger. Judiciary 163-64. 43. Avens 219. 44. Super Chapter 8 Text accompanying Note 13, and Chapter 6 Text accompanying Note 98. 45. Avens 219, 220, emphasis added. Then unborn Bill of Rights. A contemporary decision of the Supreme Court declared that the amendment did not add to the privileges and immunities of a citizen. 46. Section 5 did not purport to enlarge the provisions of the amendment but only to furnish the means of enforcing them. Are we to conclude that the able lawyers who listened to Howard concurred in Howard's patently fallacious conclusion that Congress was authorized to enforce upon the states a provision that did not bind them? Curtis notes that there was no extended discussion of Section 1, but urges that after Howard spoke not a single senator or congressman contradicted him. 47. The senators who had been categorically assured by Lyman Trumbull, chairman of the Senate Judiciary Committee, of the limited scope of privileges and immunities, and who probably were aware of similar expressions in the House shortly before Howard spoke. 48. Presumably felt no need to contradict one of many Howard assertions. Republican members of the Senate, Joseph James found, refrained from defining their positions on the floor. Their actions in the Senate were mostly confined to voting. 49. Even so, shortly after Howard spoke, Senator Luke Poland said that the clause secures nothing beyond what was intended by the original Article 4 provision in the Constitution, 50, which antedated and therefore could not comprehend the Bill of Rights. Doubtless some Republicans, Bingham among others, went beyond the conventional reading of Article 4, Super Chapter 7 text accompanying Note 38, see also Bingham, ID. Text accompanying Note 45. 47. Curtis, Book 89, 91, emphasis in original. Levy dismisses the assumption that silence on the part of their opponents signified acquiescence. LXVY, Super Note 4 at 68. Infra Note 52. 49. James, Super Note 38 at 146. But it does not follow that Poland's remarks did not reflect the intent of the framers. 51. Poland, I dare say, was closer to their thinking. 52 than the arch-radical Howard. A few days after Howard spoke, Senator Timothy Howe, a radical, 53, urging adoption of the Privileges or Immunities Clause of the amendment, and echoing his earlier statement, referred to the South's determination, balked by the military occupation, to deny to blacks the plainest and most necessary rights of citizenship. The right to hold land when they bought and paid for it would have been denied them, the right to collect their wages by the processes of law when they earned their wages, the right to appear in court as suitors for any wrong done them or any right denied them, the right to give testimony in any court. All these rights would have been denied. 54. Those rights, specifically written into the Civil Rights Bill in response to the Black Codes, patently remained the framers' concern when they turned to the amendment, which 51. Curtis, Book 127. 52. Poland echoed narrowing explanations in the House only 2 weeks before Howard spoke. James Garfield stated that the amendment proposed to put the Civil Rights Bill beyond the reach of the plots and machinations of any party. Avens 213. Thayer said, it is but incorporating in the Constitution the principles of the Civil Rights Bill which has lately become a law, in order that it shall be forever incorporated into the Constitution of the United States. ID. John Brummel remarked, it may be asked, why should we put a provision in the Constitution which is already contained in an act of Congress? He wished to prevent a mere majority from repealing the law. ID. 214 Henry Raymond observed that by the bill Congress proposed to exercise precisely the powers which that amendment was intended to confer. ID. 214 Howard himself stated that the amendment was designed to give validity to the Civil Rights Act. ID. 228. 53 Super Chapter 2 Note 25. They considered to be identical with the Bill 55 as Howe's audience was well aware. Where is the evidence that the framers intended to enlarge the goals of the bill? Howe's remarks bespeak identity, not change. The fact is that the prevailing racism and attachment to states' rights speak against such an unexplained change. Senator Poland observed that great differences have existed among ourselves, many opinions have had to yield to enable us to agree upon a plan. 56 He is corroborated by Senator Fessenden, the chairman of the Joint Committee. Unquestionably in the committee there was very considerable difference of opinion. That difference of opinion had to be reconciled. TE Committee, after much deliberation, came to the conclusion that its duty was to agree upon that which seemed the best scheme with regard to Reconstruction upon which they would come to a unanimous or nearly unanimous agreement. 57 Now, after the compromise of such differences and the express sign of the reconciliation in explicit terms, Curtis would have us believe on the basis of Howard's remark that the framers threw the carefully wrought compromises into the discard and blindly accepted Howard's position, that of a most reckless radical, entailing a sweeping encroachment on the domain of northern states. Were Howard's remarks contrary to the fact, representative of majority opinion in the Senate, it would remain to inquire whether they reflected opinion in the House. After 55 Super Note 52. Senator Cowen, who spoke not long before Howard, said that all people should have the right to contract. I agree. That all people should have the right to enforce their contracts. I agree. I would allow them to purchase, hold, and lease, and to be entitled to their remedies for the defense of their property. Avens 202. Globe 2964. T***. Howard spoke. George Latham said that the Civil Rights Bill, which is now a law, covers exactly the same ground as this amendment. 58 Thereafter William Wyndham, a radical, summarized the amendment as meaning your life shall be spared, your liberty shall be unabridged, your property shall be protected. 59 Viewed most generously, Howard's remarks are met by countervailing views, so that they do not constitute satisfactory evidence of the framers' intent. More important, Leonard Levy, whose encouragement, Curtis tells us, has been constant and crucial. 60 wrote, there is no reason to believe that Bingham and Howard expressed the view of the majority of Congress. 61. 58 ID. 223 59 Curtis citation to Wyndham's reference to a purpose to secure all the rights of citizenship, Curtis, Book 89-90, should be juxtaposed with this statement. Compare Wyndham's remarks, Super Chapter 8 text accompanying Note N. Curtis, Book 1161 Levy, Super Note 4 at 77. When Howard's remarks were cited to the court in Maxwell v. Dow, 176 U.S. 581, 601, 1899, it said, it is clear that what is said in Congress upon such an occasion may or may not express the majority of those who favor the adoption of the measure, and it demanded evidence of what construction was given to it, if any, by other members of Congress. Alfred Kelly, himself an activist apologist, explained that the radicals were reluctant to take the majority into their confidence. He noted a curious ambiguity in Die Radicals' advocacy of the measure. It was as though the radical leaders were avoiding a precise delineation of legal consequences, this on the basis of their resort to the technique of lofty, expansive, and highly generalized language. Why? There was a substantial block of moderate Republicans who had not yet committed themselves entirely to the radical position. If the radicals drove home too far the proposition that this amendment would undoubtedly consummate the destruction of all caste and class legislation, moderate Republican support might be alienated and the requisite two-thirds majority necessary to the amendment's adoption might not be obtained. Political strategy called for ambiguity, not clarity. In truth, the evidence compels the contrary conclusion that the majority rejected their views. 62 The foregoing by no means exhaust the list of Curtis' shortcomings. To do so would merely pile up cumulative evidence and needlessly tax the patience of the reader. Instead, let me turn to Curtis' belittling remarks about the scholarship of Charles Fairman, whose incorporation study, wrote William Nelson, is a now classic. 63 Whose research, wrote Harold Hyman, shaped much of the constitutional field. 64 And who was chosen to treat the Reconstruction period of the history of the Supreme Court under the bequest of Justice Holmes. 65 To argue that Fairman overlooked much evidence that tended to contradict his thesis. 66 Is to suggest purposeful suppression. Again, Fairman, Curtis charges, found clarity from the Democrats. Michael C. Kerr, Indiana Democrat, noted that the Fifth Amendment has limited only the federal government, not the states. A. Kelly, the 14th Amendment reconsidered the segregation question. 54 Mitch L. Rev. 1049, 1084, 1956. Bingham had protested against the oppressive scope of the Civil Rights Bill, and Curtis has yet to explain why Bingham embraced precisely that oppressive effect in the amendment. Could Bingham have conspired to hoodwink the ratifiers and shield himself from retribution? If so, lacking full disclosure of material facts, the ratification would be invalid. Berger. Judiciary 155 Note 93. Although I consider that the majority knowingly employed words of art of established and limited meaning, Kelly underlines my view that the radical views were not those of the majority. Nor can the rights reserved to the states be defeated by ambiguous terms. That calls for expression of a clear intention to do so. Super Chapter 5 Text accompanying Notes 94 to 101. William Nelson, History and Neutrality in Constitution Adjudication, 72 VA. L. Rev. 1237, 1253, 1986. Curtis refers to Fairman's massive study of the Supreme Court during Reconstruction. Curtis, Book 93. 64H. Hyman, Federalism, Legal Fiction and Historical Artifact. 1987 Brigham Young Law Review 905, 924. Super not asterisk, 63. Curtis, Book 6. And cited Barron v. Baltimore. 67 to Curtis. This indicates that something is askew. 68 An ill-disguised attempt to tar Fairman as a Democratic sympathizer, as if an incontrovertible fact becomes less so when stated by a Democrat. Consider also, to Fairman's dismay, Trumbull quoted Corfield and Story as to privileges or immunities as though the two were inconsistent. Fairman was horrified at the thought that the 14th Amendment might require the states to obey all of the Bill of Rights. 69 Meticulous scholar that he is, Fairman would not be dismayed or horrified because the facts did not tidily fit a preconceived theory, but would bow to the facts, as is the prime duty of a scholar. After 55 years of dedication to scholarship, I may be permitted to notice Curtis charges that Berger's work is riddled with errors of fact and interpretation, grossly inaccurate, contains obvious misstatements. His historical analysis is so mistaken that it is entitled to lit. Wait 70 Let Alexander Bickel speak for me. Of an earlier book he wrote that Berger's analysis is independent and rigorous, and so his book offers much fresh interpretation and insight. He is always deeply informed and powerful and altogether convincing. A distinguished work. 71 To those who may consider that I am unduly harsh on Curtis, I may say, like Edward Gibbon, I have tediously acquired by a painful perusal, the right of pronouncing this unfavorable sentence. 7267 ID. 97, see also ID. 94, 100. 68 ID. 169 ID. 93, 570 M. Curtis, Judge Hans. History, an Analysis of History and Method in Jaffery v. Board of School Commissioners of Mobile County. 86 W. VA. L. Rev. 109, 124, 1983, Curtis, Reply 47. A. Bickel, Book Review 73 AM. Hist. Rev. 1509, 1510, 1970. 72E. Gibbon, The History of the Decline and Fall of the Roman Empire. 60 Note N, Nottingham ed. Undated. Attempt to rescue the emancipated blacks from a return to bondage, hammered out in a racist atmosphere by northern states jealous of incursions into their sovereignty. It did not purport, as Senator Fessenden and Thaddeus Stevens lamented, to abolish all discriminations. At the outset Stevens had sought to ban all discrimination, saying that Proposition is the one I love, that is the one which I hope, before we separate, we shall have educated ourselves up to the idea of adopting, and that we shall have educated our people up to the point of ratifying. One Stevens' recognition of the need to educate Congress and the people to ban all discriminations testifies that abolitionist theology had made small impact. In the end, Stevens settled for less, notwithstanding he had hoped that the people would have so remodeled all our institutions as to have freed them from every vestige of inequality of rights, that no distinction would be tolerated. This bright dream has vanished. We shall be obliged to be content with patching up the worst portions of the ancient edifice. Point 2 The co-chairman of the Joint Committee, Senator Fessenden, also recognized that we cannot put into the Constitution Avens 133 2 ID 237. Owing to existing prejudices and existing institutions, i.e., racism, and states' rights, an entire exclusion of ale distinctions. 3 No reference to these remarks will be found in Curtis' opus. He turned his back on the most potent influences that served to limit the scope of the amendment. Point 4 A long-standing guide to construction is, what was the mischief the draftsman sought to remedy. Point 5 The Civil Rights Bill, which both the framers and ratifiers stated was identical with the amendment, was fueled by the Black Code's attempt to return the emancipated slaves to serfdom, accompanied by a campaign of flogging, murder, and terrorism. When the framers and ratifiers spoke of equal protection, it was against such violence that they meant to protect the helpless blacks. Point 6 To enable the freedmen to exist, they granted them the right to contract for their labor, to own property, to go freely from place to place denied them by the codes, and to sue for enforcement of these rights. The words employed in the amendment were not glittering generalities, but for equal protection they had historic content. They were what lawyers term words of art. Tech 3 Globe 705. For Curtis' own authority, Harold Hyman, wrote that Negrophobia held Reconstruction at low throttle, and that a heavy phalanx of Republican politicos, including Sherman and Trumbull, were states' rights nationalists, suspicious of any new functional path the nation traveled. H. Hyman, A More Perfect Union 447, 304, 1973. 5 Under Principles coming down from Hayden's Case 3 Co. Rep. 7A, 76N. Rep. 637, 1584, a court faced with the task of construction must endeavor to appreciate the mischief the framers were seeking to alleviate. Henry Friendly, The Bill of Rights as a Code of Criminal Procedure, 53 California. L. Rev. 929, 943, 1965. 4 Additional citations, see Rahul. Berger, Congress v. The Supreme Court 220 Note 95, 1969. 6 Alexander Bickel concluded that the Senate moderates, led by Trumbull and Fessenden, viewed a right to equal protection in the literal sense of benefiting equally from the laws for the security of person and property. Bickel 56. Nickel terms. For centuries due process of law had meant that a defendant was entitled to judicial process that was due, i.e., customary. Privileges or immunities had their origin in the Articles of Confederation, and were picked up by Article 4, 2, of the Constitution. A number of courts had construed them narrowly, as Senator Trumbull remarked to the framers. In lieu of privileges and immunities, the Civil Rights Bill had employed civil rights and immunities, followed by a few particularized privileges. This phrase incensed Bingham, the putative draftsman of the amendment, who vehemently disapproved of the oppressive invasion of the state's domain. In deference to his protest, the words civil rights and immunities were deleted, in order, Wilson explained, to avoid a latitudinarian construction not intended. After reviewing this history, the Supreme Court concluded, the legislative history of the 1866 Act clearly indicates that Congress intended to protect a limited category of rights. 7 The argument that these limited rights were tersely encapsulated in the amendment rests not only on the repeated, never contradicted, assertion that Act and amendment were identical, but also on the thus far unanswered question, why did Bingham come to embrace in the amendment what he had roundly condemned as oppressive in the Civil Rights Bill? The limited scope of the amendment was repeatedly emphasized during the ratification campaign. Then too, there is the undeniable racism that threatened officials who went too far in behalf of blacks, limiting the framers to outlawing terrorism in the South, with never an intimation in the course of the ratification campaign that the North also must accept federal intrusion into local administration. Where is the clearly expressed intention on 7 Georgia v. Rachel, 384 U.S. 780, 791, 1966. Which Chief Justice Marshall insisted to curtail Northern control of its own destiny, and under cover of equal protection and privileges or immunities to extend federal intervention in local affairs to an undreamed of extent. 8 Against the historical evidence, equal protection has become a crystal ball in which judicial soothsayers can find whatever they will point. 9 8 Protesting against regarding a corporation as a person for purposes of the 14th Amendment, Justice Black stated, I substitute criminal administration for his corporation. The states did not adopt the amendment with knowledge of its sweeping meaning under its present construction. No section of the amendment gave notice to the people that, if adopted, it would subject every state law affecting criminal administration to censorship of the United States courts. No word in all this amendment gave any hint that its adoption would deprive the states of their long-recognized power to regulate criminal administration. Connecticut General Insurance Co. v. Johnson, 303 U.S. 77, 89, 1935, dissenting opinion. Referring to grand jury indictments, trial by jury of 12, etc., Justice Frankfurter said, it would be extraordinarily strange for a constitution to convey such specific commands in such a roundabout and inexplicit way. Those reading the English language with the meaning it ordinarily conveys would hardly recognize the 14th Amendment as a cover for the various explicit provisions of the first 8 amendments. Adamson v. California, 322 U.S. 46, 63, 1947, concurring opinion. Horace Flack concluded, had the people been informed of what was intended by the amendment, they would have rejected it. Flack 237. See Alfred Kelly, Super Chapter 9 Note 61. 9 Philip Kurland stated, the new equal protection is the old substantive due process. The difference between the new equal protection and old substantive due process is essentially the difference in the hierarchy of values of the court. Forum, Equal Protection and the Berger Court, 2 Hastings Const. LQ. 645, 661, 1975. Herbert Packer pointed out that the new substantive equal protection has under a different label permitted today's justices to impose their prejudices in much the same manner as the Four Horsemen once did. H. Packer, the aim at stake is the integrity of the Constitution, the right of the people to govern themselves, for instance, to require death penalties even though they offend the sensibilities of the justices. Point 10 Whence does the court derive authority to bring the Constitution in tune with its own predilections? Its sense of justice may for the moment reflect our own, but, as Justice Cardozo observed, to substitute it for the will of the framers might result in a benevolent despotism if the judges were benevolent men. It would put an end to the rule of law. 11 Just now these views are unfashionable in ACOB. The Criminal Law Revisited, a plea for a look at substantive due process, 44s. Cal. L. Rev. 490, 491-92, 1971. For a detailed discussion of the roots of equal protection in the framers' aim to outlaw discrimination with respect to the rights granted by the Civil Rights Bill, see Berger. Judiciary 170, 166-92. Consider Justice Brennan's acknowledgement that his view that death penalties constitute a cruel and unusual punishment is an interpretation to which a majority of my fellow justices, 7 not to mention, it would seem, a majority of my fellow countrymen, about 70%, does not subscribe. Yet he steadfastly maintains his view in dissent after dissent, hoping to embody a community striving for human dignity for all, although perhaps not yet arrived. Address, October 12, 1985, reprinted in The Great Debate, Interpreting Our Written Constitution, N. 24, Washington, Federalist Society, 1986. Were Brennan in the majority, he would be cramming his view down the throat of a dissenting public illustrating what government by judiciary means. In a 1987 speech at Harvard Law School, Judge Richard Posner said that a judge ought not to substitute personal values for those that are part of the text, structure, and history of the Constitution. As an example, he argued that judges should not interpret the Constitution to bar the death penalty. Capital punishment was common when the Eighth Amendment was adopted, is supported by 75% of the nation, and can be supported by evidence of its deterrent effect. 38 Harv. L. Bull. 34, 1987. N.B. N. Cardozo, The Nature of the Judicial Process, 136, 1921. Justice Harlan declared 1, when the court disregards the express intent and deem. But when I deflated the alleged impact of anti-slavery theology on the 14th Amendment, which had been heralded by Jacobus ten Broek and Howard J. Graham, and is now applauded by Curtis and Leonard Levy 12, Lord Beloff F., an Oxford emeritus and longtime student of American constitutionalism, concurred, saying, the quite extraordinary contortions that have gone into proving the contrary make sad reading for those impressed by the high quality of American legal historical scholarship. 13 The present attempt by academicians to find in the amendment what they want to believe stands no higher, and it will not, I predict, be viewed in the future as their shining hour. All this may seem like tilting at windmills at a time when Judge Robert Bork, during the hearings on his nomination to the Supreme Court, felt constrained to say that too many expectations had crystallized around the incorporation doctrine to permit its disturbance. That, to my mind, is particularly inappropriate at this juncture when we purport to celebrate the bicentennial of the written Constitution rather than the judicial barnacles with which it has become encrusted. 14 The struggle for a written Constitution, Justice Black justly stated, was to make certain that men in power understanding of the framers, it has invaded the realm of the political process to which the amending power was committed, and it has violated the constitutional structure which is its highest duty to protect. Oregon v. Mitchell, 400 U.S. 112, 202-03, 1970. 12 Curtis, Book M. L. Levy, Judgments, Essays in American Constitutional History 70, 1972. 13 Max Beloff F., Book Review, The Times, London, April 7, 1978, Higher Education Supplement at 2. 14 Compare Solicitor General Robert Jackson's paean to the then re-emergence of the constitutional text from beneath a laissez-faire gloss, analogizing it to the rediscovery of an old master after the retouching brushwork of succeeding generations had been removed. R. Jackson. Back to the Constitution, 25 ABAJ. 745, 748, 1939. Would be governed by law, not by the arbitrary fiat of the man or men in power. 15 It is difficult for me to regard the precedents of the last 40 years as more sacrosanct than those of the prior 135 years during which, as Lewis Henkin reminded us, the exemption of the states from the Bill of Rights had been the consistent, often reaffirmed, and almost unanimous jurisprudence of the court. 16 Adverse possession does not run against the government, still less against the sovereign people. Usurpation is not legitimate by inertia. 17 The contrary view, as Willard Hearst said in an analogous context, would simply be a way of practically reading Article V out of the Constitution. 18 The fact is, as Leonard Levy noted, that at no time in our history have the American people passed judgment, pro or con, on the merits of judicial review over Congress. 19 How could they ratify judicial review of the Constitution when they were repeatedly told that, as Frankfurter wrote to Franklin Roosevelt, when the Supreme Court speaks it is not they who speak but the Constitution. 20 Were the court endowed with the power of divining the 15 in Rewinship, 397 U.S. 358, 384, 1970, dissenting opinion. Super Chapter 1 Text accompanying Note 1217 Non-existent power cannot be prescripted by an unchallenged exercise. United States v. Morton Saltco, 338 U.S. 632, 647, 1950. Sir Frederick Pollock wrote to Justice Holmes, strange that approved series of blunders should be more sacred than one. 1 Holmes Pollock Letters 239. 1946, 18 W. Hearst, Discussion, in Supreme Court and Supreme Law 74, E. Kenned. 1954, Learned Hand also adhered to amendment as the proper means of change. Catherine Griffith, Judge Learned Hand and the Role of the Federal Judiciary 83, 1975, Justice Hugo Black rang the changes on this theme, example in Griswold v. Connecticut, 381 U.S. 479, 522, 1965. 19L. Levy, Judicial Review, and the Supreme Court 3, 1967. 20 Roosevelt and Frankfurter, Their Correspondence, 1928 to 1945 381, M. Friedman ed. 1967. Public desire contrary to its course in the death penalty cases, it would yet run afoul of Hamilton's assurance to the ratifiers, until the people have, by some solemn and authoritative act, annulled or changed the established law, it is binding upon themselves collectively as well as individually, and no presumption, or even knowledge of their sentiments, can warrant their representatives in a departure from it, prior to such an act. Point 21. Finally, Erie Re. Co. V. Tompkins reversed the IOO-year-old course of Swift v. Tyson, about which many expectations of the commercial and financial communities had gathered in the course of a century, because, in the words of Justice Bran D.E.D., quoting Justice Holmes, it was an unconstitutional assumption of power by courts of the United States which no lapse of time or respectable array of opinion should make us hesitate to correct. 22. Celebration of the bicentennial of the Constitution calls on us to exhibit no less hardihood and to respect its integrity, i.e., its original meaning. 21. Federalist No. 78 at 509, Mod. Lib. Ed. 1937, in the first Congress, Madison said sovereignty of the people means the people can change the Constitution if they please, but while the Constitution exists, they must conform themselves to its dictates. 1N. Cong. 739, 1st Cong, 1st Session, Gales and Seaton 1834, print bearing running head history of Congress. 22. Erie Re. Co. V. Tompkins, 304 U.S. 64, 79, 1938. Doubtless I shall be charged with the inconsistency because I wrote that it would be probably impossible to undo the past in the face of the expectations that the segregation decisions have aroused in our black city. Zen's expectations confirmed by every decent instinct. Berger, Judiciary 41213, Raoul Berger, Death Penalties, The Supreme Court's Obstacle Course 179-80, 1982. But the rank discrimination against blacks cannot be equated with equal application of the procedural safeguards of the Bill of Rights which, if they be applicable to the states, protect whites and blacks alike. To leave electronic wiretapping to the states, for instance, is not of the same order as a return to Jim Crowism. The latter would be met by widespread resistance, an altogether unlikely consequence were wiretapping returned to the states. Books. Adams, Henry. John Randolph, Boston, Houghton Mifflin, 1882. Adams, J. Donald. Copy at Harvard, Boston, Houghton Mifflin, I-960. Avens, Alfred. The Reconstruction Amendments Debates, Richmond, Virginia, Virginia Commission on Constitutional Government, 1967. Benedict, Michael L. A Compromise of Principle, New York, Norton, 1975. Berger, Raoul, Congress v. The Supreme Court, Cambridge, Massachusetts, Harvard University Press, 1969. Government by Judiciary, The Transformation of the 14th Amendment, Cambridge, Massachusetts, Harvard University Press, 1977. Death Penalties, The Supreme Court's Obstacle Course, Cambridge, Massachusetts, Harvard University Press, 1982. Federalism, The Founder's Design, Norman, University of Oklahoma Press, 1987. Bickel, Alexander. The Least Dangerous Branch, Indianapolis, Bobbs Merrill, 1962. The Supreme Court and the Idea of Progress, New York, Harper and Row, 1970. Blackstone, William. Commentaries on the Laws of England, London, 1765-1769. Brock, William. An American Crisis, Congress and Reconstruction, London, Macmillan, 1963. Brody, Fawn Thaddeus Stevens, The Scourge of the South, New York, Norton, 1959. Cardozo, Benjamin N. The Nature of the Judicial Process, New Haven, Yale University Press, 1921. Commager, Henry S. Documents of American History, 7th ed., New York, Appleton, 1963. Corwin, Edward S. The Twilight of the Supreme Court, New Haven, Yale University Press, 1934, Krosky, William. Politics and the Constitution in the History of the United States, Chicago, University of Chicago Press, 1953, Donald, David. The Politics of Reconstruction, Baton Rouge, Louisiana State University Press, 1965. Charles Sumner and the Rights of Man, New York, Knopf, 1970. Ely, John H. Democracy and Distrust, Cambridge, Massachusetts, Harvard University Press, 1980. Farrand, Max. The Records of the Federal Convention 1787, New Haven, Yale University Press, 1911. The Federalist, New York, Modern Library ed. 1937, Fehrenbacher, Donnie. The Dred Scott Case, Its Significance in American Law and Policy, New York, Oxford University Press, 1978. Fairman, Charles. History of the Supreme Court of the United States, Volume 6, New York, Macmillan, 1971. Flack, Horace. The Adoption of the 14th Amendment, Baltimore, Johns Hopkins University Press, 1908. Frankfurter, Felix. The Commerce Clause, Chapel Hill, University of North Carolina Press, 1937. Law and Policy, New York, Harcourt Brace, 1938. Felix Frankfurter Reminiscences, H. R. Phillips ed. New York, Rennell, I-960. Gay, Peter and Wexler, Victor. Historians at Work, New York, Harper and Row, 1975. Gibbon, Edward. Decline and Fall of the Roman Empire, Nottingham ed. Undated. Gillette, William. The Right to Vote, Politics and the Passage of the 15th Amendment, Baltimore, Johns Hopkins University Press, 1965. Graham, Howard J. Every Man's Constitution, New York, Norton. Griffin, Catherine. Judge Learned Hand and the Role of the Federal Judiciary, Norman, University of Oklahoma Press, 1975. Haynes, Charles. The American Doctrine of Judicial Supremacy, New York, Russell and Russell, 1959. Hamilton, Alexander. The Papers of Alexander Hamilton. H. Syrett and J. Cook, eds. New York, Columbia University Press, 1962. Hamilton, Walden and Adair, Douglas. The Power to Govern, New York, Norton, 1973. Hand, Learned. The Spirit of Liberty. I. Dillard, ed. New York, Knopf, 1952. Hurst, R.A. Early Life and Letters of John Morley, London, Macmillan, 1927. Book, Sydney. Philosophy and Public Policy, Carbondale, Southern Illinois University Press, 1980. Hyman, H. M. A More Perfect Union, New York, Knopf, 1973. Hinman, H. M. Further Reminiscences, London, Macmillan, 1912. James, Joseph. The Framing of the 14th Amendment, Urbana, University of Illinois Press, 1965. Keller, Morton. Affairs of State, Cambridge, Massachusetts, Harvard University Press, 1977. Kelly, A. Harbison, W., and Bells, H. The American Constitution, New York, Norton, 1983. Kendrick, Benjamin. The Journal of the Joint Committee of 15 on Reconstruction, New York, Columbia University Press, 1914. Lacey, Dan. The White Use of Blacks in America, New York, Athenaeum, 1972. Levy, Leonard. Judgments, Essays on American Constitutional History, Chicago, Quadrangle Books, 1972. Lusky, Lewis. By What Right? Charlottesville, Mickey, 1975. Morrison, S. E. The Oxford History of the American People, Oxford, Oxford University Press, 1965. And Commager, H. S. The Growth of the American Republic, 4th ed., New York, Oxford Press, 1952. Morley, John. Edmund Burke, An Historical Study, New York, Harper, 1879. Paludan, Philip. A Covenant with Death, Urbana, University of Illinois Press, 1975. Rehnquist, William H. The Supreme Court, How It Was, How It Is, New York, Morrow, 1987, Roosevelt and Felix Frankfurter, Their Correspondence, 1928-194 SM. Friedman, ed. Boston, Lit Brown, 1967. Story, Joseph. Commentaries on the Constitution of the United States, 5th ed., Boston, Little Brown, 1905. De Tocqueville, Alexis. Democracy in America, New York, Colonial Press, 1900. Tenbroek, Jacobus. Equal Under Law, London, Collier Books, 1965. Woodward, C. Van. The Burden of Southern History, Baton Rouge, Louisiana State University Press, I-960. Articles Bader, Paul. Some Thoughts on Applied Federalism, 6 Harvard Journal of Law and Public Policy 51, 1982. Bell, Derek. Book Review, 76 Columbia Law Review 350, 1976. Beloff, Max. Book Review, The Times, London, April 7, 1978, Higher Education Supplement. Berger, Rahul. Constructive Contempt, A Postmortem, 9 University of Chicago Law Review 602, 1942. Law of the Land Reconsidered, 74 Northwestern University Law Review 1, 1979. Government by Judiciary, Judge Gibbons Argument ad hominem, 59 Boston University Law Review 783, 1979. Soifer to the Rescue of Legal History, 32 South Carolina Law Review 427, 1981. Incorporation of the Bill of Rights in the 14th Amendment, 42 Ohio State Law Review 435, 1981. Incorporation of the Bill of Rights in the 14th Amendment, a reply to Michael Curtis response, 44 Ohio State Law Journal 1, 1983. Bickel, Alexander. Book Review, 75 American Historical Review 1509, 1970. Bond, James E. The Original Understanding of the 14th Amendment in Illinois, Ohio, and Pennsylvania, 18 Akron Law Review 435, 1985. Bork, Robert. Forward, in Gary L. McDowell, The Constitution and Contemporary Legal Theory, Cumberland, Virginia, Center for Judicial Studies, 1985. Brest, Paul. Berger v. Brown et al., New York Times, December N., 1977, Book Review Section N. The Fundamental Bites Controversy, The Essential Contradiction of Normative Scholarship, 90 Yale Law Journal 1063, 1981. Krosky, William. Charles Fairman's Legislative History 3 and the Constitutional Limitations on State Authority, 22 University of Chicago Law Review 25, 1954. Curtis, Charles. Review and Majority Rule, INI. Com. ed. Supreme Court and Supreme Rule, Bloomington, University of Indiana Press, 1954. Curtis, Michael. The Bill of Rights as a Limitation on State Authority, a reply to Professor Berger, 16 Wake Forest Law Review 45, 1980. Further Adventures of the Nine-Libbed Cat, a response to M.R. Berger on Incorporation of the Bill of Rights, 43 Ohio State Law Journal 89, 1982. Judge Hand's History, an Analysis of History and Method in Jaffery v. Board of School Commissioners in Mobile Country, 86 West Virginia Law Review 109, 1983. Diamond, Paul. Strict Construction and Judicial Review of Racial Discrimination under the Equal Protection Clause, Meeting Raoul Berger on Interpretivist Grounds, 80 Michigan Law Review 462, 1982. Ely, John H. Constitutional Interpretivism, Its Allure and Impossibility, 53 Indiana Law Journal 399, 1978. Fairman, Charles. Does the 14th Amendment incorporate the Bill of Rights? 2 Stanford Law Review 5, 1949, A reply to Professor Krosky, 22 University of Chicago Law Review 144, 1954. Frankfurter, J. Galrix. John Marshall and the Judicial Function, 69. Friendly, Henry. The Bill of Rights as a Code of Criminal Procedure, 53 California Law Review 51, 1982. Forum. Equal Protection and the Berger Court, 2 Hastings Constitutional Law Quarterly 645, 1975. Gibbons, John. Book Review, 31 Rutgers Law Review 839, 1978. Goebel, Julius. Book Review, 54 Columbia Law Review 450, I-954. Gressman, Eugene. Book Review, 1 New Law Books Reviewer 57, 1986. Gray, Thomas. Do We Have an Unwritten Constitution? 27 Stanford Law Review 703, 1975. Henkin, Lewis. Selective Incorporation in the 14th Amendment, 73 Yale Law Journal 74, 1963. Hyman, Harold H. Federalism, Legal Fiction and Historical Artifact? 1987 Brigham Young Law Review 905. Kelly, Alfred. Cleo and the Court, An Illicit Love Affair, 1965, Supreme Court Review 09. Comment on Harold Hyman's paper, in H. Hyman, ed. New Frontiers of the American Reconstruction, Champaign, University of Illinois Press, 1966. Lowell, James R. Abraham Lincoln, 28 Harvard Classics 441, New York, Collier, 1910. Lynch, Gerald. Book Review, 63 Cornell Law Review 1091, 1978. Mendelson, Wallace. M.R. Justice Black's 14th Amendment, 53 Minnesota Law Review 711, 1969. Monahan, Henry. The Constitution Goes to Harvard, 13 Harvard Civil Rights Civil Liberties Law Review 117, 1978. Morrison, Stanley. Does the 14th Amendment incorporate the Bill of Rights? 2 Stanford Law Review 140, 1949. Nelson, William. History and Neutrality in Constitutional Adjudication, 72 Virginia Law Review 1237, 1986. Nye, Russell. Comment on C. V. Woodward's paper, in H. Hyman, ed. New Frontiers of American Reconstruction, Champaign, University of Illinois Press 1966. Packer, Herbert. The Aim of the Criminal Law Revisited, A Plea for a Look at Substantive Due Process, 44 Southern California. Perry, Michael. Book Review, 78 Columbia Law Review 685, 1978. Interpretivism, Freedom of Expression and Equal Protection, 42 Ohio State Law Journal 261, 1981. Richardson, H. and Sales, G. Parliament and Great Councils in Medieval England, 77 Law Quarterly 213, 1961. Seufer, Abiam. Protecting Civil Rights, A Critique of Raoul Berger's History, 54 New York University Law Review 651, 1981. Van Alstyne, William. Interpreting the Constitution, The Unhelpful Contributions of Special Theories of Judicial Review, 35 University of Florida Law Review 209, 1983. Forward, in Michael Curtis, No State Shall Abridge the 14th Amendment and Bill of Rights, 1986. Wexler, Herbert. The Political Safeguards of Federalism, The Role of the States in National Government, 54 Columbia University Law Review 543, 1954. Warren, Charles. The New Liberty Under the 14th Amendment, 39 Harvard Law Review 431, 1925. Woodward, C. Van. Seeds of Failure in Radical Reconstruction Policy, in H. Hyman, ed. New Frontiers of American Reconstruction, Champaign, University of Illinois Press, 1966. Miscellaneous Act of April 19, 1866, 14 Stat. 27 1 Annals of Congress, Gales and Seaton, 1834, print bearing Running Tide History of Congress. Congressional Globe, 39th Congress, 1st Session, 1866. 39th Congress, 2D Session, 1867. 42D Congress, 2D Session, 1872. Index of Cases Abbott v. Bailey, 6 Pic 89, Mass. 1827, 34, 92, 93 Adamson v. California, 332 U.S. 46, 1947 7, 26N, 78M, 9M, I-46N. Barron v. Baltimore, 32 U.S. 7 Pet. 243, 1833 6, 7M, 28, 48, 49, 75, 87-89, 95, 96N, 98M, 99, 101-103, M, 129, 130, 133, 136, 142 Bartkus v. Illinois, 359 U.S. 121, 1959 9N. Bradwell v. State, 83 U.S. 16 Wall. 330, 1872 73 M. Butchers Union Co. v. Crescent City Co., M.U.S. 746, 1884 84 M. Campbell v. Morris, 3H. and M.C.H. 535, M.D. 1797 33, Connecticut General Insurance County. V. Fonson, 303 U.S. 77, 1935 146 M. Corfield v. Coriel, 6F. Ca. 546, CCED. Pa. 1823, No. 3220. 34, 35, 36, 92-94, 105, IO6N, 136, 142 Dred Scott v. Sanford, 60 U.S. 393, 1857 9, 21, 88, 90, 94, 102, 133 Duncan v. Louisiana, 391 U.S. 145, 1968 7 M. Erie Re. Co. v. Tompkins, 304 U.S. 64, 1938 54 T-150 Ex Part Bain, 121 U.S. 1, 1887 109 M. Ex Part Virginia, 100 U.S. 339, 1879 89 M. Forco Glasgow. v. Transmura Products Corp., 353 U.S. 222, 1957 7 inches, IO6N. Georgia v. Rachel, 384 U.S. 780, 1966 27, 71, 145 M. Ginsburg and Sons v. Popkin, 285 U.S. 204, 1932 7 M. IO6N. Gitlow v. New York, 268 U.S. 652, 1925 12 Griswold v. Connecticut, 381 U.S. 479, 1965 I-49N. Hague v. CIO, 307 U.S. 496, 1939 36 Holmes v. Jennison, 39 U.S. 14 Penn. 540, 1840 17 M. Hurtado v. California, no U.S. 516, 1894 Ion. In Rewinship, 397 U.S. 358, 1970 I-7N, I-49N. Livestock Dealers and Butchers Association v. Crescent City Livestock Landing Co., 15F. Co. 649, CCD. Law. 1870, No. 8408-23 M. Maxwell v. Dow, 176 U.S. 581, 1893 7N, I4 on. Minor v. Happerset, 86 U.S. 21 Wall. 162, 1874 97N. Missouri v. Lewis, 101 U.S. 22, 1879 126 Noble State Bank v. Haskell, 219 U.S. 104, 1911 55 M. North American Utility Securities Corp. v. Posen, 176 F.2D 194, 3 DCIR. 1949 79 N. Ogden v. Saunders, 25 U.S. 12 Wheat. 212, 1827 19 M, IO4 N. Oregon v. Mitchell, 400 U.S. 112, 1973 M, 69 M, 148 M. Palco v. Connecticut, 302 U.S. 319, 1937 9 N, 13, I6 N. Paul v. Virginia, 75 U.S. 8 Wall. 168, 1865 32, 93 Pearson v. Ray, 386 U.S. 547, 1967 55 M. Peary v. Chicago Title and Trust Co., 182 U.S. 438, 1901 I03 N. Poe v. Ullman, 367 U.S. 518, 1961 I6 N. Prudential Insurance Co. v. Cheek, 259 U.S. 530, 1922 I2 N. Robinson v. California, 370 U.S. 660, 1962 17 M. Slaughterhouse Cases, 83 U.S. 16 Wall. 36, 1872 7, 9 M, I8 N, 19, 22 N, 24 M, 31, 32 to 33, 46 M, 5 M, 55, 69 N, 83 M, 93 94, 95 N, 96 M. 98 N, Iison. Swift v. Tyson, 41 U.S. 1, 16 Pet. 1842 150 United States v. Arredondo, 31 U.S. 1, 6 Pet. 691, 1832 76 MV. Berg, 25 F. Ca. 55, CC. VA. 1807, No. 14,693 55 N. V. Cruikshank, 92 U.S. 542, 1875 97 to 98, IO4 NV. Harris, 106 U.S. 629, 1882 2 on V. Morton Salt Co., 338 U.S. 632, 1951 49 MV. Wheeler, 254 U.S. 281, 1920 33 Walker v. Savinet, 92 U.S. 90, 1876 70 126 Ware v. Hilton, 3 U.S. 3 Dolly. 199, 1796 IO9 N. Yates v. United States, 354 U.S. 298, 1957 92 M. Abolitionists, and Due Process Clause, NN, Impact of, on 14th Amendment, 18, 29, 62 to 66, 100, 103, 135, 139, 143, 148, Impact of, on Reconstruction Congress, 55 to 66, 82, 109, 134 35, 140 N, 143, 148, Attitude of North toward, 57 to 58, 61, and Bill of Rights, 64 M, 75, and Rights of Feedman, I-27N, 135-36, see also Bingham, John, Howard, Jacob, Stevens, Thaddeus, Sumner, Charles Absorption, Doctrine of, see Bill of Rights, Incorporation of, into Due Process Clause of 14th Amendment Act of Settlement, of 1701, Relevance of, to Civil Rights Act and 14th Amendment, 112 to 13 Article 4, 2, Interpretation of, by Bingham, 29 M, 129, Relation of, to 14th Amendment, 73, 119, 145, Relation of, to Civil Rights Act, No. 117, see also Articles of Confederation and Privileges and Immunities. Articles of Confederation and Privileges and Immunities, 32 to 33, 93, 145. Bader, Paul, and Doctrine of Incorporation, N. Bell, Derek, on Northern Racism, 122. Beloff, Max, on Legal Scholarship, 148. Benedict, M.L., and Impact of Abolitionists on Reconstruction Congress, 64. Benson, Egbert, and Original Intent, 6, 76. N. Berger, Raoul, as interpreted by Curtis, 45 to 46, 47. N. 60, 64. M. 68. N. 9 on, 93, 94, 96. N. 04, 131 to 33, on Curtis Scholarship, 45 to 66, on Judicial Activism, 47. M. 147. 50. Bickel, Alexander, on Legislative History of 14th Amendment, 8, on Impact of Abolitionists on Reconstruction Congress, 19, on Scope of Civil Rights Act, 27, 113, on Bingham, 128-29, on Berger, 142, on Equal Protection Clause, 144. and Bill of Rights, First Amendment, 5, 6, 12 to 13, 46, 104, 130, Fourth Amendment, 5, Fifth Amendment, 5, 9 to 13, 15, 16. N, 28. N, 63, 69. N, 92. N, 97, Intent of Framers of, 5, 6, 13, see also. Hamilton, Alexander, Madison, James, Applicability of, to states, 5 to 7, 13 to 14, 17, 29, 48, 75, 83, 87, 92, 95, 98 to 99, 102. N, 104, 126, 129 to 33, 136, 149, Black on Incorporation of, 7, 8. N, 9, N, 48, 104, Incorporation of, into Due Process Clause of 14th Amendment, 7, 8. N, 9 to 19, 37, 40 to 41, 45, 48, 69. M, 73 to 77. 91, 92, 95, 103, 104, I-46. N, 148, Selective Incorporation of, 919, 69. N, 74 to 77, 91 to 92, and Article 4, 2, 9. N, 36, 91 to 98, 100, 129, 136 to 37, 10th Amendment, I-6. N, 52. M, 54, 55, 122, encompassed by Civil Rights Act, 27 to 30, 40, 78 to 81, 99, 11911, Abolitionist interpretation of, 64. M, 6th Amendment, 69. M, and Declaration of Independence, 83. I-6L. Bill of Rights, continued, 85, and Privileges or Immunities Clause of 14th Amendment, 91 to 104, 106, 122, 136 to 37, 146, 8th Amendment, 130, 147, 150. Bill of Rights, English, relevance of, to Civil Rights Act and 14th Amendment, 112 to 13. Bingham, John, Representative and the Due Process Clause, 10, and 13th Amendment, 20, and Scope of Civil Rights Act, 25, 26, 47. M, 72, 73, 99, 115, 16, and encompassing of Bill of Rights by Civil Rights Act, 27 to 30, 47. N, and relation of Civil Rights Act to 14th Amendment, 40. N, and selective incorporation, 47. N-75, and states' rights, 50, 5. M, 53, 79, 05-16, 131 to 33, 145, and slavery, 62. 63, and applicability of Bill of Rights to states, 86, 88, 95, 98. N, 130, 31, 133, interpreted by Curtis and Krosky, 87 to 88, and scope of 14th Amendment, 92, 100, 103, and rights of citizens, 96 to 97, evaluation of, 128-35, and Equal Protection Clause, 129, interpretation of Constitution by, 129 to 30, 13 M, 133, and suffrage, 131, and Northern Racism, 134, see also Abolitionists Black, Hugo, Justice and Incorporation of Bill of Rights, 7, 8 N, 9, N, 48, 104, and Ordered Liberty, 17, and Scope of the Civil Rights Act, 26, and Krosky Scholarship, 48, Reliance of, on Howard, 135, on Judicial Activism, 148 to 49. Black Codes, as target of Civil Rights Act and 14th Amendment, 23 to 25, 38 to 40, 50, 52, 53 N, and scope of Civil Rights Act and 14th Amendment, 83, M, 120, 138, 143, 144. See also Friedman, Racism, Northern, Impact of, on Reconstruction Congress Blacks, see Friedman Blackstone, William, and Definition of Liberty. 42, Definition of Civil Rights. By, No N, as cited by Curtis, 112-13 Blaine, James G. Senator, and Civil Rights Act, 57 Blair, James, Representative, and Northern Racism, 59 N. Bond, James, Dean and Due Process Clause, Ion, 14-15, on Privileges and Immunities, 3M, on Scope of Civil Rights Act and 14th Amendment, 37, 39-42, and Impact of Abolitionists on Reconstruction Congress, 82, on Racism and 14th Amendment, 86 N. Bork, Robert, Judge, on Doctrine of Incorporation, 148 Bradley, Joseph, Justice on Relation of Civil Rights Act to 14th Amendment, 23, and Definition of Pursuit of Happiness, 84, on Due Process, 126 Brandeis, Lewis, Justice on States' Rights, 54, on Judicial Activism, 150 Brennan, William, Justice, Judicial Activism of, 14,711. Brest, Paul, 46 Brock, W.R., and Northern Racism, 127 M. Brummel, John, Representative, and Relation of Civil Rights Act to 14th Amendment, 138 N. Capital Punishment, see Bill of Rights, 8th Amendment Cardozo, Benjamin, Justice and Bill of Rights, 13, 17, and Ordered Liberty, 1314, on Judicial Activism, 147 Citizenship, Rights of, 95-97, 101 103, 106, 129, see also Friedman, Privileges and Immunities Civil Rights, and Civil Rights Act, 26, 27, 30, of Friedman, 52-53, 144, Find by Blackstone, no, as understood by Reconstruction Congress, no -13, as understood by Curtis, and 617, and States' Rights, 124-27, 130, see also Bill of Rights, Citizenship, Rights of, Civil Rights Act, Privileges and Immunities. Civil Rights Act, Relation of, to 14th Amendment, 14, 17, 20, 22, 40-42, 67-74, 89 N, 114-15, 117 N, 124-25, 138 N, 139, 140, 144-45, and 13th Amendment, 21, Scope of, 22-30, 33, 40-41, 81, 107-108, No, H4I9, 126, 145, and Black Codes, 23-25, 115-19, 137, and Suffrage, 35. Applicability of, to North, 38-42, 57, as interpreted by Curtis, 67-74, 105-27, Johnson veto of, 105-106, 109, and 6, and Definition of Liberty, No 13, Impact of Abolitionists on, 135, see also Civil Rights, 14th Amendment, Friedman, Privileges and Immunities, States' Rights Conkling, Roscoe, Senator, and States' Rights, 50 Cowan, Edgar, Senator and Racism. 61-62, and Scope of 14th Amendment, 139 and Criminal Law, and 5th Amendment, 5, and Civil Rights Act, 77-78, State Jurisdiction over, 78, 146 and Krosky, William, on Fairman, 47-48, Evaluation of, 48, on Applicability of Bill of Rights to States, 88 Cruel and Unusual Punishment, see Bill of Rights, 8th Amendment. Curtis, Charles, and Due Process, 9-10 Curtis, Michael, and Scope of 14th Amendment, 14N, 16N, 40, 74-78, 82-87, 89-90, on 13th Amendment and Civil Rights Act, 20, and Scope of Article 4, 2, 36, and Doctrine of Incorporation, 45-49, 92, Scholarship of, 45-49, 67, 77M, 81, 92-93, 104, 108, Criticism of Berger by, 45, 46, 47N. 68N, 90N, 93, 94, 96N, 114, 130, 133, 142, on States' Rights, 52-53, and Northern Racism, 55-56, 77, 121, and Relation of Civil Rights Act to 14th Amendment, 67-74, on Applicability of Bill of Rights to States, 73, 78 to the power of 81st, 87-89, on Scope of Civil Rights Act, 78-81, on Impact of Abolitionists on Reconstruction Congress, 82-87, 95, 98, 101-104, 128-42, 148, and relation of Declaration of Independence to 14th Amendment, 83-85, and privileges and immunities, 91 to 102, 105 to 27, and definition of liberty, 112 to 13, criticism of Fairman by, 125, 134, 141 to 42. Davis, Garrett, Senator, and scope of 14th Amendment, 94 death penalty, see Bill of Rights, 8th Amendment Declaration of Independence, relation of, to 14th Amendment, 58N, 64M, 83 to 85, and racial equality, S8N. Delano, Columbus, representative and scope of 14th Amendment, 39M, 85, and states' rights, 51, 53 Donald, David, and 14th Amendment, 1938, on northern racism, 59, 122, on impact of abolitionists on Reconstruction Congress, 64, 65N, on Bingham's politics, 134 Douglas, William O. Justice, and judicial activism, 16. Due process, see Bill of Rights, 5th Amendment, 14th Amendment, and Due Process Clause 8th Amendment, see Bill of Rights, 8th Amendment Ely, John Hart, and applicability of Bill of Rights to states, N. 48 to 49, 122 Emancipation, see Abolitionists, Freedmen, Lincoln, Abraham Equal Protection, relation of, to privileges and immunities and due process, 123-24, see also 14th Amendment, and Equal Protection Clause Fairman, Charles, I6N, IO6N, 141, on 14th Amendment, 8, 22, 37, 45, 47 to 48, 77, 104M, 125, 134, 141 to 42. Fairman, Charles, continued, on Bill of Rights, 37, 45, 47 to 48, on Civil Rights Act, 22, evaluation of Bingham by, 128 to 29 Farnsworth, John, representative and states' rights, 53N, and northern racism, 122 federalism, 1926, and Reconstruction Congress, 2829, 50N, 51, see also states' rights Federalist, B. C. Hamilton, Alexan. Madison, James Fehrenbacher, Don, and States' Rights in Reconstruction Congress, 51 Fessenden, William, Senator, and Abolitionist Impact on Reconstruction Congress, 61, 65 to 66, and Scope of 14th Amendment, 65N, 103 to 104, 139, 143, I-44N, and States' Rights, 96 Field, Stephen, Justice and Scope of Privileges and Immunities, 7, 69N, 94, 95N, 105N. And scope of Declaration of Independence, 84 15th Amendment, 18 5th Amendment, see Bill of Rights, 5th Amendment 1st Amendment, see Bill of Rights, 1st Amendment Flack, Horace, and 14th Amendment, 18, 23, 4 on, 50, 146 M. Fletcher, Thomas C. Governor, and States' Rights, 126N. 14th Amendment, incorporation of Bill of Rights into, 7, 8N, 9 to 19, 37, 40 to 41, 45, 48, 69N, 73 to 76, 91 to 92, 95, 103,104, 146N, 148, and Due Process Clause, 8, 10N, 14 to 15, 69 to 70, 76, 91 to 92, 97, 120, 123 to 24, 126, 145, ratification of, 8, 10, 14 to 15, and judicial activism, 1718, impact of abolitionists on, 18, 29, 62 to 66, 100, 103, 135, 139, 143, 148, legislative history of, 20 to 30, relation of, to Civil Rights Act, 20, 22 to 23, 40, 42, 47 to 48, 67 to 74, 81, 89M, 107N, 114 to 15, and 7N, 124 to 25, 126, 138N, 139, 144 to 45, relation of, to Black Codes, 24, 71, 143 to 45, scope of privileges or immunities clause of, 31, 40, 41, 91,115, RI 9, 126, 137, 145 see also privileges and immunities, and suffrage, 35, 12M, applicability of, to North, 39, original meaning of, 45, 69N, 84, and states' rights, 54N, 55, 113, 133, 143, and women's rights, 72 to 73, enforcement of, 8990, and discrimination, 103, encompassing fundamental rights, 105 to 13, encompassing absolute rights, 11,315, and Equal Protection Clause, 121-23, T29, 146N, and Northern Racism, 134, 143, see also Civil Rights, Privileges and Immunities, Republicans' Fourth Amendment, see Bill of Rights, Fourth Amendment Frankfurter, Felix, Justice and Incorporation of Bill of Rights into the 14th Amendment, 8, 69N, 77, 78N, 91, 146N, and Rules of Legal Interpretation, 87, 108-109, and Judicial Activism, 149 Freedmen, Citizenship of, 2022, 97, Rights of, 25, 52, 79, 81, 94, 106-108, No 12, 118-19, 12M, 134-36, 144, and Reconstruction Republicans, 38, and Lincoln, 55, 58-59, 63N, 121, C. Also Abolitionists, Black Codes, Civil Rights Act, Racism, Northern, Impact of, on Reconstruction Congress, Republicans, Suffrage Freedmen's Bureau Bill, 19 Freedom of Speech, see Bill of Rights, First Amendment Frelinghuysen, Frederick, Senator, and 14th Amendment, 54N. Friendly, Henry, Judge, and Doctrine of Incorporation, N. 77 Garfield, James, Representative and Due Process, 10, and Relation of Civil Rights Act to 14th Amendment, 89M, 138N, and Scope of 14th Amendment, 92 Garrison, William Lloyd, and Impact of Abolitionists on Reconstruction. Congress, 61, and Abolitionist Constitutional Thought, 63 Gibbon, Edward, 142 Gillette, William, on Northern Racism, 86 Goebel, Julius, on Applicability of Bill of Rights to States, 48N. Graham, Howard J., on Relation of Civil Rights Act to 14th Amendment, 22-23, on Impact of Abolitionists on Reconstruction Congress, 63-64, 74, 148 Gressman, Eugene, on Curtis, 45-46, U9N. Habeas Corpus Act, of 1679, Relation of, to Civil Rights Act, 112-13 Haynes, Charles, on Due Process, Ion. Hale, Robert, Representative/Judge, and States Rights, 53N, 58N, 133 Hamilton, Alexander, and Due Process, 9, 10, and States Rights, 26N, and Relevance of Magna Carta and Bills of Rights to Constitution, 112. And Judicial Activism, 150 Hand, learned, on Judicial Activism, 17, 149N Harlan, John, Justice on Applicability of Bill of Rights to States, 7, on Scope of Privileges and Immunities, 31, 69 Hendricks, Thomas, on Northern Racism, 59N. Henkin, Lewis, and Applicability of Bill of Rights to States, 7, 149, and Selective Incorporation, N, 15-16 Higby, William, and Scope of 14th Amendment, 92N, 98N. Holmes, Oliver Wendell, Justice and Selective Incorporation, 12, on Judicial Activism, 55N, I-49N, 150 Hotchkiss, Giles, Representative, and Scope of Privileges and Immunities, 96N. Howard, Jacob, Senator, and Citizenship of Freedmen, 21, and Suffrage of Freedsen, 70, 12M, on Women's Rights, 72, and Selective Incorporation, 75, and Due Process, 77N, and Incorporation of Bill of Rights into 14th Amendment, IO2N, 136-37, Radicalism of, 135-42, cited by Curtis and Black. 135, 139, and Scope of 14th Amendment, 136, see also Abolitionists. Howe, Timothy, Senator and Scope of Privileges and Immunities, 138-39, and Rights of Freedmen, 24 Amherst, Willard, 149 Hyman, Harold, and Slaughterhouse Cases, 19, and States Rights, 21, 96N, and Rights of Freedmen, 53N, 60, and Northern Racism, 60, 144N. Evaluation of Fairman by, 141 Incorporation, Doctrine of, Derivation of, N13, see also Bill of Rights, Incorporation of, into Due Process Clause of 14th Amendment Iredell, James, Justice, and Rules of Legal Interpretation, 109 Jackson, Robert, Solicitor General, and Judicial Activism, 148N. James, Joseph, and Scope of 14th Amendment, 39, 82, 89N, and Reconstruction Congress, 137 Jefferson, Thomas, and Bill of Rights, 6, 13, and Declaration of Independence, 58N. Jim Crowism, 150M, see also Black Codes Johnson, Andrew, and Veto of Civil Rights Act, 38N, 105, 106, 109, and 6 Johnson, William, Justice, on Bill of Rights, 19, 104 Judicial Activism, 17-18, 46N, 47N, I-46N, 147-50 Julian, George, Representative, and Northern Racism, 59 Keller, Morton, and Impact of Aboli. Shinis on 14th Amendment. Kelly, Alfred, on Black Codes, 23N, on Scope of Civil Rights Act, 23N, 53, 113, on Impact of Abolitionists on Reconstruction Congress, 140, 14M. Kendrick, Benjamin, on Bingham, 29, on Howard, 135 Kent, James, Chancellor, and Scope of the Civil Rights Act, 112 Kerr, Michael, Representative, on Applicability of Bill of Rights to States, 141-42 Kurland, Philip, on Equal Protection Clause, 146N. Lane, Henry, Senator on Relation of Civil Rights Act to the 14th Amendment, 40, on Northern Racism, 59 Latham, George, Representative on Relation of Civil Rights Act to 14th Amendment, 22, 140, and States' Rights, 51 Lawrence, William, Judge and Due Process, 10, on States' Rights, 52, on Scope of Privileges and Immunities. 92, 93, 99, 100, and 17-18 Legal Interpretation, Rules of, I-7N, 76M, 87, 106N, 108-109, 127M, 144N, 145-46, see also Original Intent Levy, Leonard, on Black's Interpretation of 14th Amendment, 8N, 46N, on Incorporation of First Amendment into 14th Amendment, 12, on Framers of Bill of Rights, 17N, on Curtis, 45, on Original Intent, 49N, on Influence of Abolitionists on Reconstruction Congress, 58M, 74, 128-29, 134M, 137N, 140, 148, on Judicial Review, 149 Liberty, Doctrine of Ordered, 1317, as defined by Blackstone, 42, as understood by framers of 14th Amendment, 84 Lincoln, Abraham, on Slavery, 55, 63N, on Rights of Freedmen, 58-59, 121, on Status of Negro, 12M, on Judicial Supremacy, 133 Logan, John Alexander, Representative, and Scope of Privileges and Immunities, 85-86 Lowell, James Russell, and Emancipation, 57N. Lusky, Lewis, and Ordered Liberty, 15 Madison, James, on Applicability of First Amendment to States, 5-6, 13, on Scope of Privileges and Immunities, 32, on States' Rights, 50-51, 133, on Slavery and Constitution, 63, and Pursuit of Happiness, 85N, on Rule of Law, 150 Magna Carta, Relevance of, to Civil Rights Act and 14th Amendment, and 213 Maitland, William, and Rules of Legal Interpretation, 127 N. Marshall, John, Chief Justice on Applicability of Bill of Rights to States, 67, 87, and Barron v. Baltimore, 48, 75, and Original Intent, 55, 83, on Rules of Legal Interpretation, 145-46 Mendelsohn, Wallace, on Bingham. 28N, 128-29 Miller, Samuel, Justice on Scope of 14th and 15th Amendments, 18, 55, and States' Rights, 18, 51, 55, 83, 97N, and Rights of Freedmen, 21, 97N, and Scope of Article RV, 2, 32-33 Monahan, Henry, on Rights of Freedmen, 56, on Enforcement of 14th Amendment, 89N Morley, John, on Objective Scholarship, 47 Morrison, Stanley, on Privileges and Immunities, 3M. Morton, Oliver, Senator, on States' Rights, 53N, on Enforcement of 14th Amendment, 90 Myers, Leonard, on Scope of Equal Protection Clause, 120, 123. Negroes, C. Friedman Nelson, William, on Fairman, 141 Norton, Governor, of Indiana, on Applicability of Bill of Rights to Northern States, 39N Nye, Russell, on Racism, 60 Oaths of State Officers, and Enforcement of Bill of Rights, 129-33, 136 Oregon, and Racism, 134 Original Intent, and Will of People, 17. And Marshall, 55, 83, and Contemporaneous Understanding, 104, 108, 109, see also Judicial Activism, Legal Interpretation, Rules of Packer, Herbert, and Equal Protection, 146N. Paludan, Philip, and States' Rights, 54N, 10910, and Northern Racism, 60, 127N. Patterson, James, Senator, on Rights of Freedmen, 52, 81 Perry, Michael, on Incorporation of Bill of Rights into 14th Amendment, 5211. Petition of Right, of 1627, Relevance of, to Civil Rights Act and 14th Amendment, 11213 Phillips, Wendell, and Impact of Abolitionists on Reconstruction Congress, 63 Poland, Luke, Senator and Relation of Civil Rights Act to 14th Amendment, 40, and Scope of 14th Amendment, 137-39 Pollock, Frederick, on Judicial AC. Tivism, 149 N. Pomeroy, Samuel, Senator, on suffrage for freedmen, 35 N. Posner, Richard, Judge on original intent of 14th Amendment, 1718, on death penalty, 147 N. Price, Hiram, Representative, on scope of privileges and immunities, 99 N. Privileges and immunities, of Article 4, 2, 9 N, 36, FJFKH, No, 117, 145, Cardozo's understanding of, I3N I4N, Bingham's understanding of, 29, 88, 96, 129, scope of, 29, 31 to 36, 40, 69 to 75, 93 to 94, 99 IOI, 106 to 107, No, 114 19, 126, 145 to 46, and enforcement of 14th Amendment. 30, in 14th Amendment, 91 to 104, 106, 122, 136 to 37, 146, and Curtis, 91 to 102, 105 to 27, relation of, to equal protection and due process clauses of 14th Amendment, 123-24, origin in Articles of Confederation, 145 racism, Northern, impact of, on Reconstruction Congress, 55 66, 86, 122, 126, 127 N, 134 to 35, I4 on, 143 to 45. See also Black Codes, Freedmen Racism, Southern, see Black Codes Radical Republicans, see Abolitionists Ratification Debates, see 14th Amendment, Ratification of Raymond, Henry, Representative, on Relation of Civil Rights Act to 14th Amendment, 138 N. Reconstruction Congress, see Abolitionists, Impact of, on Reconstruction Congress, Republicans Rehnquist, William, Chief Justice, and Incorporation of Bill of Rights into 14th Amendment, 18 to 19, 54 N. Republicans, on Scope of Civil Rights Act, 20, 27, 30, 38 to 42, and Southern Representation, 37, and States' Rights, 50, 53 N, Racism of, 59 66, and Abolitionists, 62, 64, 82, 100, 103 104, 109, and Slavery, 63, and Incorporation of Bill of Rights, 76, and Scope of Privileges and Immunities, 91 95, 97 101, 103 104, and Rights of Freedmen, 108, see also Abolitionists Roberts, Owen, Justice and Judicial Activism, 16, and Rights of Citizens, 36 Roosevelt, Franklin, 149. Shell Berger, Samuel, Representative on Scope of the Civil Rights Act, 71, 79, M, and 6, and States' Rights, 71 72, 125, on Scope of Privileges and Immunities, I07N, I2 on Scope of Equal Protection Clause, 123, 125 Sherman, John, Senator on Rights of Freedmen, 25, on Relation of Civil Rights Act to 14th Amendment, 40, on Scope of 14th Amendment, 41, 109, and Northern Racism, 60, 86N, 134, and Impact of Abolitionists on Reconstruction Congress, 65, 100, on Scope of Civil Rights Act, 108, and States' Rights, 109, 144N. 6th Amendment, see Bill of Rights, 6th Amendment Spooner, Lysander, and Abolitionist Theory, NN. States' Rights, and Bill of Rights, 57, 13 to 14, I6N, 78, Jefferson on, 13, and 14th Amendment, 1719, 29, 49 to 55, 73 to 74, 107, 109, 113, 122, 125 to 26, 143 to 44, and 13th Amendment, 21, and Civil Rights Act, 28 30, 71, 115 to 16, in Northern States, 49 to 50, 52, 53 and 54, 61, 78, 100, 109 to 10, 126, 143 to 45, and Rights of Freedmen, 109-10, and Civil Rights, and 6I8, 124, 130, 133 Stevens, Thaddeus, Representative on Scope of 14th Amendment, 29, 95N, 120, 143, Impact of, on the Reconstruction Congress, 62, 82, 103 104, on Relation of Civil Rights Act to 14th Amendment, 67, 115, and Rights of Freedmen, 58N, 97N, 125, on States' Rights, 98, 101 to 102, see also Abolitionists Stewart, Potter, Justice, on Applicability of Bill of Rights to States, 7 Stewart, William, Senator on Scope of Civil Rights Act, 24, 38 to 39, 126, on Rights of Freedmen, 56, 126, and Northern Racism, 59 Story, Joseph, justice and privileges and immunities, 32n, 142 suffrage, of freedmen, and Civil Rights Act, 35, and Article 4, 2, 36, and 14th Amendment, 38, 121, 122n, Attitude of North toward, 52, 53, 56, 71, 134, and Reconstruction Congress, 65, and Abolitionists, 135, 36, see also Civil Rights, Freedmen. Sumner, Charles, Senator and 14th Amendment, Ion, 35, Impact of, on Reconstruction Congress, 19, 38, 62, 82, and Civil Rights, 38, 65, see also Abolitionists Taney, Roger, Chief Justice, and Due Process, 17n. 10 Broke, Jacobus, and 14th Amendment, 148 Tennessee, Suffrage in, 134 10th Amendment, see Bill of Rights, 10th Amendment Thayer, Martin, Representative on Relation of Civil Rights Act to 14th Amendment, 22, 138n, on Scope of Civil Rights Act, 25, 7980, 106 107, and 6 13th Amendment, and Civil Rights Act, 20, 2 inches, 57, and Rights of Freedmen, 20 to 22, 7m, and States' Rights, 21, see also Citizenship, Rights of, Civil Rights, Freedmen Tiffany, Joel, and Abolitionist Theory, NN, 62 Trumbull, Lyman, Senator, and Citizenship of Freedmen, 21, 105, and Scope of Civil Rights Act, 23 to 24, 33 34, 36, 38, 46n, 71n, 105 to 106, 109, non, M, 05-17, 126, and Relation of Civil Rights Act to 14th Amendment, 40, on Northern Racism, 59n, 05-17, and Scope of 14th Amendment, 65m, 92 to 94, 97 to 100, 137, and States' Rights, 96, 109, 125, 144n, on Equal Protection, 144n, see also Republicans Tucker, Thomas, Representative 6. Van Alstyne, 5, 45 Waite, Morrison, Chief Justice, and Applicability of First Amendment to States, 104 Warren, Charles, on Selective Incorporation, 12 to 13 Washburn, Elisha, Abolitionist Views of, 135 Washington, Bushrod, Justice, on Scope of Article 4, 234 to 36 Webster, Daniel, quoted by Bingham, 99, and Scope of Article 4, 2, 101 Wexler, Herbert, on Original Intent. 54 White, Byron, Justice, and Judicial Activism, 1617 White, Edward Douglas, Chief Justice, and Scope of Article 4, 233 Wilson, Henry, Senator on Black Codes, 2324, on Northern Racism and 14th Amendment, 60, 86n, on Rights of Freedmen, M. Wilson, James, of Pennsylvania, on Legal Interpretation, 7611. Wilson, James, of Iowa, Representative and Due Process Clause, 10, and Scope of Civil Rights Act, 26 to 27, 30, 38, 77, No 13, NSN, 126, 145, on Northern Racism, 5960, on Suffrage of Freedmen, 7m. Wyndham, William, Representative on Scope of Civil Rights Act, 107 to 108, M, on Scope of 14th Amendment, 140 Women's Rights, and 14th Amendment, 72-73 Woodward, C. Van, on Northern Racism, 50, 59, 61, 100, and 21 to 22 Yates, Richard, Senator, and Impact of Abolitionists on Reconstruction Congress, 65n, 82, 86. /I. Berger painstakingly traces the court's departure from its earlier precedents until the federal government has taken over the predominant role in many key internal state matters. His position is that the 14th Amendment is to be construed in light of the 10th's guarantee to the states of their residuary rights, and that guarantee is to be diminished only when the language of a later amendment clearly states that intent. Berger's point is that the framers had no intention of curtailing those rights except within the specific areas delineated in the legislative history of the 14th Amendment. At stake, he says, is the right of the states to govern their own local affairs, such as the right to dispense with grand juries, to regulate their own criminal proceedings, to enact death penalties, and to have prayer in the schools. In this book, Berger examines another facet of what he regards as the Supreme Court's ongoing takeover of major policy decisions that under the Constitution were reserved unto the people. The author Raoul Berger is a retired legal scholar and a prolific author. He is a constitutional historian of great renown, and his studies of the role of the Supreme Court have triggered an ongoing debate about whether it may revise the Constitution under the guise of interpretation. He is the author of Federalism, the Founders' J-Design, also published by the University of Oklahoma Press. University of Oklahoma Press, Norman and London. Books of related interest: Federalism, the Founders' Design by Raoul Berger, tightly argued and heavily documented. Berger's book presents a compelling argument for states' power under the Constitution generally and the 10th Amendment in particular. Choice. 232 pages. The Politics of Education by John Perdamus with Lynn P. Brown Volume 1 in Julian J. Rothbaum Distinguished Lecture Series. This is a readable and important book that will be an eye-opener for many people, and must reading for those to whom the political processes are a major interest. West Coast Re. View of Books. 152 pages. Thomas Jefferson, American Tourist by Edward Dumbald Volume 9 in the American Exploration and Travel Series. Edward Dumbald offers some highly satisfactory elucidation of the many contributing factors that produced one of the most vital, many-sided fathers of the Republic. The Commercial Appeal. Also available in paperback. 284 pages. Thomas Jefferson and the Law by Edward Dumbald. For those who have interest in the history of the law and the contribution of a great American, this book is fascinating reading. Law Books in Review. This is a valuable and thorough book. American Bar Association Journal. 309 pages. Illustrations. University of Oklahoma Press, Norman, Oklahoma, 73019 ISBN, 0FLDHLBLFLBB.